Good morning, everyone, and welcome to the University of Richmond School of Law to our annual symposium that the Law Review puts on. A particular welcome to any alums we have in the audience. It's always great to have you back. I want to start by thanking the Law Review for organizing this terrific symposium, in particular Zoe Jackson for your work as symposium editor. This is such an important topic. You know, the Civil War ended 159 years ago. Now that sounds like a long time, but let me put that in context. There were enslaved individuals who lived well into the 20th century. Peter Mills, Anna Cooper, Jeff Dobby. There are people alive today who knew them and spoke with them. That means that was not very long ago. The vestiges of the Confederacy are all around us. Some are explicit in the names and monuments. The Southern Poverty Law Center estimates that there are 723 monuments, 741 roads, 201 schools, 51 buildings, and 38 parks, all named in honor of Confederates. There are other kinds of pernicious vestiges that linger with us today. Impacts such as political disempowerment, along with unequal health, wealth, and rates of imprisonment. We haven't mounted these on concrete pedestals, but they are just as real vestiges. The Confederacy, slavery, and their foundational ideology of white supremacy are woven into our history, particularly in the South. If we are ever to embrace our better angels and bind up our wounds, as Lincoln called for, then we must wrestle with that history and how it continues to shape us. The program today offers an opportunity for us to do just that. So let me turn things over to the symposium editor, and I hope you have a terrific day today.
Good morning, everyone. I would like to welcome you again to the University of Richmond Law Review's Spring 2024 Symposium, Vestiges of the Confederacy, Reckoning with the Legacy of the South. My name is Zoe Jackson, and I have the great pleasure and honor to serve as the symposium editor on Law Review's Volume 58 Executive Board. I've also had the very great pleasure of planning our event today. From the vantage point of the former seat of the Confederacy, a city rife with physical reminders of this nation's human rights violations, there is no place quite like Richmond to call out the continuing ramifications of this nation's original sin. The 246-year enslavement of 12.5 million African people, and its stead, the system of Jim Crow laws that codified and enforced white supremacy and racial segregation for nearly 100 years. As we will see today, the institution of the American slave trade touched nearly every aspect of the American life, north and south of the Mason-Dixie line. While the toil and labor of civil rights activists has done much to move us forward, we have not escaped the racist systems and racist social norms which remain, continuing to injure Black Americans and anyone who falls distinctly beyond our definition of whiteness. I hope that this event today will serve as an opportunity for restorative imagination, that standing on the ground which once supported physical institutions of abuse, we can call to attention its harms and propose a better way forward. Our very first speaker to join me in this venture is Richmond's own Professor Marissa Jackson-So. Professor Jackson-So teaches and writes in the areas of contracts, constitutional law, international law, human rights, law and philosophy, and rhetoric. She has authored far too many fabulous articles to list, including one with our very own Law Review entitled Redemption, commenting on the law school's announcement to change its name from T.C. Williams School of Law, a name it had shared with a known owner of enslaved people for more than a century, to how we know it today, the University of Richmond School of Law. Please join me in welcoming Professor Jackson So.
Thank you, Zoe, for this wonderful introduction and for inviting me to participate. Good morning, everybody. It's an absolute honor to be your first speaker today. Just a little intimidated, but don't mind me. I have actually been looking forward to this symposium for months, so I just want to congratulate Zoe and all of her colleagues on our law review for doing a really spectacular job of bringing it together. I'm extremely proud of you all and just glad to be in community with you. So my goal for today is to just set the stage for the rest of the wonderful presentations and panels to which you will be treated today. And to do that, I'm just going to sort of riff on the title and theme of the symposium, of the idea of the Confederacy's vestiges. And so I'm going to try to make the sort of counterpoint that while there was a formal end to the Confederacy, such that vestiges could be possible, that perhaps the Confederacy has actually never died, right? That instead it has persisted in the form of afterlives or maybe even reincarnations, sometimes by hiding itself in systems and structures, but also loudly and proudly in many ways, particularly here in Richmond. So to do that work, I'm going to talk this morning about personhood. So not necessarily humanity, but personhood, which I will explain, and its relationships to race, space, and place. Okay, so as a theoretical point of departure, right, I would like to invite all of you to consider how personhood is negotiated and renegotiated. If you can see sort of kind of dimly behind the text, you can see a portrait of Chief Justice John Marshall, right, for whom I believe a high school is still named here, and who is considered one of the greatest Chief Justices of the United States Supreme Court. Chief Justice John Marshall was gifted his first enslaved person as a wedding gift from his father. He grew up in a family of slaveholders, and by the time he had died here in Richmond, he owned approximately 200 enslaved people. He consistently ruled in favor of slaveholders and against the enslaved in his judicial decisions. In the approximately 50 cases involving slavery that he heard at as Chief Justice of SCOTUS. And so his jurisprudence therefore sort of reinforced the dispossession of African American bodily autonomy and physical integrity. So it cut against their humanity, but it also stripped them of their legal and political personhood, right? And so when I talk about personhood, I'm talking about one's recognition before a government or a state. Likewise, Justice Marshall stripped personhood from indigenous nations and dispossessed Indian tribes of their land, as he did in the famous 1823 and 1830 cases of Johnson versus McIntosh and Cherokee Nations versus Virginia. It's easy to sort of either just condemn and then dismiss Chief Justice Marshall and his work, or on the other end, to simply forgive him as a man of his times. But today I would actually like to challenge us to engage him and his work, not just as the work of a racist man, but as the result of his deep financial investments, his personal investments in an institution that required the existence and the persistence of labor extraction and the legal, cultural, social, cultural, and religious systems of oppression that premised the supremacy of the slaveholder over the enslaved person, and that did so as a form of justification for that institution of labor and financial extraction. When we do that, okay, we can then sort of accept that Chief Justice Marshall was definitely intellectually dishonest, because in many of his cases he deplored the institution of slavery, and perhaps also racist. But what is actually more interesting for me as a scholar and as a teacher is to sort of discuss and explore the ways in which his jurisprudence was actually racializing, right? In the ways that his jurisprudence actually created race, right? And how the impact of his decisions, right, actually impacted how geographies and political economies continue to reproduce and renegotiate race through space and place and personhood to this very day. So, if you ever take my Race and the Constitution class, as some of the people in here have done and are doing, you will know that sort of at the very first part of the semester, I will tell you, racism is actually not about feelings, okay? Certainly, it engenders passionate feelings. It relies upon feelings for its survival. We know this. However, racism is a system that is designed and that is redesigned as necessary to protect an absolute economic advantage over certain haves and to ensure that they do not become the have-nots, and to ensure that the have-nots do not become the haves. Thus, it guarantees a permanent disadvantage and dispossession of those who are racialized as not white. Race is not endemic to a person. It is not foundational. In fact, racial classifications have changed in this country and in other countries around the world across time and space, and this largely depending upon the labor economies in place. Okay. To highlight this point, I'll show you, like this is a redlining map of Richmond, Virginia, right? That sort of dictated to lenders where they could invest or allow people to buy property and thus become, right, empowered citizens within the city of Richmond, okay? And so my thesis, my scholarly thesis about racism is that it's actually a history and a system built around land, labor, and resources, much more so than it is around interpersonal animus. And that it simply weaponizes psychology and sociology and animus to keep itself going. Okay? So, I would say this is how race actually works, right? Again, it's not biological. However, it becomes biologized, right? I often tell my students that race is a real myth because of this. It doesn't exist biologically or necessarily hereditarily, but it reproduces itself in a very real, material, and tangible way, having impacts on people's DNA, on their health, and every aspect of their lives, including their deaths and the things that happen to them after they die. Okay? So a part of dehumanization and disenfranchisement is determining where people have to stay and where they can or can't go or be through processes and structures that are governed both by public law and, very importantly, but often invisibly, private law, as the redlining map shows. Okay. So here I'll say a little bit about something that I am sort of introducing, it's just starting to work on, that I'm calling the anti-social contract. If you have ever been familiar with any of my work on race, you know that I write about something called racial contracting. And I'll just say a little bit about that here. By social contract, we're talking about theories of how people built society with the rule of law. So I certainly did not create the theory of social contract. You can thank Jean-Jacques Rousseau and many other classical philosophers for that. But in the 1990s, a philosopher with whom I had the pleasure of learning as an undergrad named Charles Mills said, you know, this is a great theory and it's a great way of understanding how liberal democracy works, but it says nothing about the role that race plays in excluding people from this body politic that we formed through our social contracting. And so from there, Charles Mills wrote a book called The Racial Contract. And he had borrowed the title from a feminist work called The Sexual Contract. Okay, so if you take my state power class, you hear all about that, right? And so what I came into the academy with was this idea of, okay, I get social contract. I get that the racial contract is an anti-racist intervention into the social contract. But let's think about how the race actually impacts how we actually do commercial, but also political and social contracting. And what I came up with was this theory that we are actually bargaining, right, within our social structures. We are bargaining all the time in the US and elsewhere for our positions, right, as members of the body politic. If you have been raised as white, right, you likely were a successful bargainer for that position, either by simply being born or by lobbying for that, as, right, Irish and Italian people in our country had to bargain for positioning as white over time. And if you were never able to successfully bargain, right, in the ways that so many petitioners in the late 1800s and early 1900s before the Supreme Court were unsuccessfully able to petition for whiteness, then you became excluded from that body politic. And the Supreme Court was very clear about this, right, in cases such as Ozawa versus US, Bagat-Sindin versus US, and others. The result of not being able to successfully petition the United States government through the Supreme Court for whiteness, you would either be denied or even stripped, in Thin's case, of your US citizenship, okay? And when you were stripped or excluded from US citizenship, that meant a number of things. You could not bargain for your citizenship at the polling booth, right? You could not bargain for those rights that we all bargain for every election day. And you could not contract for property. So you found yourself at once both socially and politically disempowered, but also financially and economically disempowered, and this for generations. So now I'm thinking about an anti-social contract, because I'm trying to figure out, what do we do with all those people who have been kicked out of the social contract, who are excluded? And I'm arguing now that those people are part of something like an underworld of contracts called the anti-social contract, such that they exist within our society and their labor is essential, right? Their work is essential workers, right? But they are never to be anything other than contingent rights holders or participants in public and various private spaces. Okay, so now I'd like to go into my first case study with you all. Huh?
Can you speak up, please?
Oh, okay. Can you hear me better now? Okay. I think it's because I'm pacing. Thanks. This is my first case study. Forced servitude. Okay. Forced servitude is illegal. We don't do that anymore, right? Except for this infamous loophole in the 13th Amendment that allows for you to remain, right, effectively enslaved, to have your labor extracted against your will if you are imprisoned, okay? So then I want to pose the question to you all. Is this a vestige of the Confederacy? Or is it an afterlife or a reincarnation, okay? In December of 2023, so exactly 4 months ago, a large number of presently incarcerated people and formerly incarcerated people sued the state of Alabama. Governor Kay Ivey, the Limestone Correctional Facility, and many of the officials working therein, alleging that they were being effectively trafficked, okay, because the prisons were sending them to private corporations to work effectively for free. This is a practice that's happening now. Okay. People who said, actually, I don't want to work, or I have COVID today and I can't work, would be sent back into prison, right? And in many cases, sort of physically punished for refusing to work. Okay? And the allegations are that this is actually a holdover from convict leasing, which is an institution or a practice that took place immediately after the eradication, the formal eradication of slavery. So I don't know that you can see the text very well, and so I would actually like to read just a small part of the complaint, the federal complaint that was brought in December. Okay. It is no accident that plaintiffs, like individuals who were enslaved and forced to work Alabama's cotton fields, and those forced to participate in the sharecropping and convict leasing schemes that followed the end of the Civil War, are Black. Alabama incarcerates a grossly disproportionate number of Black men and women in its prisons, and the state has long used its prisons to perpetuate the racial subjugation that existed before the Civil War. From 1875 until 1928, Alabama maintained an extremely profitable convict leasing system, a system of bondage targeting Black people widely acknowledged to be one of the harshest and most exploitative labor systems known in American history. This scheme, whereby Black laborers were forced to work for private companies, who in turn paid substantial fees to state and county governments, covered 73% of Alabama's budget by 1898. And they say that defendants here have resurrected this practice. Okay. So now, I'll take us back here to Fair Richmond, right? And what I want to describe is a more subtle practice. It's easy to understand and see, right, the oppression at play when people are behind bars. But what about residential segregation? What about constraining people to certain neighborhoods and certain school districts, such that if they find themselves in other places, they're regarded effectively as trespassers? Residential segregation here in Richmond is stark. So, and with this residential segregation and the assumptions that are attached thereto, come various expectations. So if I went out to Glenside Road, as I often do after class, to go get Starbucks or Chipotle, it would not be surprising to me or anyone else to see the group of young Black teenagers that prepare my burrito bowl, right? Or hand me my coffee, even though this is in Henrico or the far West End. But what if those kids were trying to attend Mary Mumford Elementary? How would you feel? How would their parents feel, right? Why is it, right, that we expect certain people to attend Mary Mumford and William Fox and others to attend Overby Shepherd, right? Why is it that we buy our homes with the expectation, right, that our kids will go to school with certain type of people and not others? Is that not also an afterlife of the Confederacy? And what does that do if you have the power to choose where you're going to buy and send your kids to school to the children who don't have the choice of where they live and send themselves to school? They're not imprisoned formally, but they're certainly constrained. And when they find themselves, right, walking through West Hampton, right, and people start sending things through the chats, there's someone suspicious here, then they become trespassers and their lives are immediately at risk, right? Is that a vestige of the Confederacy, or is that a reincarnation? Something to consider. Give me 1 second. My computer keeps freezing out on me, and I was not smart enough to print my notes. Here we go. Okay. So, we're down to my last two case studies and examples. I know. Congratulations, yes. And here I'd like to deal with the so-called migrant crisis that's taking place in the US, and particularly at the southern border, okay? So in response to the arrival of migrants via the southern border, many hundreds of thousands at this point over the last 2 years, a couple of Republican Congress members have introduced what they call the Equal Representation Act. And this is a proposal, it's a proposed legislation that would introduce a citizenship question on the next US Census. This was something that people tried in 2020. Ostensibly, it's a banal question, just to get a sense of how many US citizens are in the country. But in effect, it's meant to keep certain people from filling out the census, right? It preys upon the fears that immigrants have of being sort of deported or surveilled or otherwise harassed, and it assumes that they will not fill out the census. Why is this important? Well, because the census is used for many things, right? The census is used for congressional reapportionment. It's used for redistricting purposes, and it's used for electoral college votes apportionment as well. And there are financial benefits as well, right? Based on the census, right, governments will send funds, right, as needed based on the proportionality for any number of things, right? Funding for projects, but certainly also emergency funding in cases of disaster. So there again, you see this duality between, right, the government, the political proprietorship that's at stake, but also the material and economic proprietorship that's at stake when we start talking about personhood, race, and space. So the Equal Representation Act is not only meant to use, like sort of employ this new citizenship question on the US Census, but it's also meant to remove from the count of the US Census all migrants, including green card holders, US residents, right? The census is meant to count the number of people present on the territory, right? So by removing those people, you're not removing them physically from the space, but you are removing them in the sense of legal and political personhood, okay, from our body politic. We've seen this before. In 1787, right, when we were bargaining, negotiating for our body politic through the formation of a constitution, right, the delegates had to vote, basically to come to a compromise. They voted to adopt proportional representation in Congress based on the whole number of white and other free citizens and 3/5 of other persons. Okay? So again, not removing people physically from the territory, but making sure that they did not exist fully in a legal sense. In November of 2023, the 8th Circuit, which includes a number of plain states but also Arkansas, ruled that only the Attorney General can sue regarding minority vote dilution under Section 2 of the Voting Rights Act. This decision specifically blocked Black Arkansas voters who had made a strong claim in the lower court that Arkansas was purposely redistricting in order to dilute Black voters, right? So now those voters and the organizations that represent them are explicitly precluded from bringing Voter Rights Act claims for vote dilution. Again, these people will continue to live in Arkansas. They just can't do anything about the aggressive efforts to suppress their votes and dilute the power of those votes. Meanwhile, illegal child labor, which is overwhelmingly migrant labor, rose 40% from 2015 to 2022. The U.S. Department of Labor found that nearly 6,000 underage children are working for major private corporations between 2022 and 2023. Child labor violations are up 50% in fiscal year 2023 from fiscal year 2022. The overwhelming majority of these children are from Central America. And as this is happening, we've seen attempts to roll back child labor protection laws as recently as 2023. Right-wing groups, notably organizations owned by the DeVos family. If that name sounds familiar to you, it's because Betsy DeVos was our Secretary of Education, are advocating against these child labor laws. And the reasoning is the most cynical reasoning. They're saying, if you have child labor laws, you are depriving Black children of the opportunity to work as opposed to going to school. Okay? So, basically what I've been trying to communicate with you all is that the presence of racialized people here has never been a problem. It's the terms of that presence that continues to separate us and divide us. And that's what remains up for constant debate and renegotiation. And until we come to some terms of actual equality, I'd like to make the case to you that we should not be talking about the Confederacy in the past tense. And that should make us upset. I will conclude my presentation by invoking Arthur Ashe. At the beginning of my presentation, you saw the picture of his monument that's on Monument Avenue. And if you know anything about the history of the installation of that monument, you know it was highly controversial. No one objected to Arthur Ashe being a fantastic tennis star and bringing glory to Richmond that way. But his placement, the placement of his statue, by this time he had passed away for a couple of years already, was highly controversial because it was considered to be out of place. The placement of his statue on Monument Avenue alongside Confederate generals was not considered disrespectful to the Black community. It was disrespectful to the white community, right? And so in 2020, during the Black Lives Matter uprisings and our most recent serious racial reckoning, a number of progressive activists, or, I don't know how else you might want to call them, were spraying Black Lives Matter on the Confederate statues. And so the Washington Post came down one day to sort of do some investigating, and they saw a white man with an American flag bandana over his face, spraying the Arthur Ashe statue with WLM, or White Lives Matter. And a group of ladies, right, maybe who lived on Monument Avenue, sort of run out and they're like trying to scrub the graffiti off as he's like spraying other parts of it. And so the Washington Post reporter who was there said, well, why are you doing this? And he said, well, they defaced our statues, so I have the right to deface theirs. That pretty much says it all, right? Again, Arthur Ashe is not the issue. Number one, he's dead. Number two, right? He didn't do anything to anybody. It was about the placement of his statue and the symbolic nature, right, that it held, not necessarily for Black Richmond residents, but what it meant and the threat, the psychological threat that it posed to the white people, the white Confederates of Richmond. And so I want to just leave you with that there, and I'll close out my presentation. I hope it hasn't been too much of a downer. I hope it actually inspires us, right, to consider these geographies of race and what we might do to make all of our space fair and just. Thank you.
Thank you so much, Professor Jackson. If you could stay up there, yeah. We will now have some time for questions and answers.
Anybody have any questions? Raise your hand. I'll bring the mic.
Hi, Professor Jackson. So thank you again for your work and for being here today. As you described sort of these two contracts, the social contract and the antisocial contract, and this sort of active bargaining that is going on kind of continuously, I was really interested, or it made me think about how sometimes people make the argument that poor white people, like economically, have more in common with black people and other racialized people, more than they think, and certainly more than they, I think, like themselves accept, and the way that they express that, like, politically and stuff. So I was just kind of interested, like, if you have any thoughts, like, on what are these people bargaining for? What are they getting, in not aligning themselves, I think, as bargainers with black people and with other racialized people?
Mm-hmm. Thanks, Caleb. That's a great question. And it's one that I think about a lot. But there's actually a lot of literature out there and a lot of theories out there already. And certainly you've all heard about this idea of, right, white people's economic anxieties and how that pushes them to support, Donald Trump or other populist white nationalist candidates. The idea being that it is because of the financial disempowerment, it's because of their exclusion or their dispossession of capital that they are instead appealing to whiteness as capital, right? Whiteness is capital, right? And that's what they're bargaining for. I studied and lived in one point in London, England, and I lived with a family of people that my dad thought were his friends. But you can be friends until you live with someone. And the reason why we didn't get on is because they were obsessed with the idea of proper white people. So in the context of England, there were proper white people and there were like less proper white people, right? Like people from Spain, right? And, when I was living there, pretty much every weekend I was like getting a $19 flight and I was just hopping around Europe. I attended LSE, the London School of Economics, but the acronym really means Let's See Europe. So that's what I was doing. And the couple that I was living with, the wife, she said, "Wow, you travel so much. Like, I'm a proper white woman and I can't do that." Right? They're plenty rich. I don't know what she was complaining about. I was like, "I'll buy you a $19 ticket, Ann Barbara. We can go," right? Except I hate you. But, I think that's what's happening here, right? Even within race, there's always been tiering of whiteness as well, right? And so people who sort of benefit from the racial categorization of white, but not all the trappings of whiteness, i.e. wealth, right, will continue to bargain for that whiteness using their vote, right, as opposed to seeking solidarity with their classmates. Does that help?
Yes. Thank you.
Hi, Catherine.
Hi. Thank you so much for your presentation. My question is just, how do you think that we can move forward? Like, is there another level for renegotiation? Is it protest? Is it voting? Like, what is the solution to, overturning the antisocial contract?
Mm-hmm. I strongly believe so. Carla's here. We were kind of talking about this yesterday, right? This idea of sort of solidarity and collaboration. So if you are someone who benefits from the privilege of whiteness, you have a big part to play in this, right? And there's got to be some collaboration and organizing across all these races, right? There's got to be, when you hear about multiracial coalitions, there's a reason for that. Those are powerful, so that people can sort of use their privilege, right, where other people lack privilege, to sort of tear down these systems and these structures and these prejudices, right? But beyond that, to sort of answer your question very directly, Catherine, it's not going to be either voting or protests. It's got to be, I was going to say both and, but it's not. It's all of the above. Visual culture matters, right? So keeping the monuments up is violence, right? And it does, right, keep the Confederacy in place. It does keep white supremacy in place. Vote suppression is also state violence that keeps white supremacy in place. But so does, right, really aggressive real estate tactics, right? I've been trying to buy a house in Richmond for like 3 years. And you can't, because everybody wants to live here because it's amazing, it's cool and everything. But also there are these practices that happen in the real estate market where it's like, we're moving fast, so there's no time for an inspection. There's no time for an appraisal. You've got to come in with cash. You've got to waive, contingencies. If you are any kind of middle-class person, you are losing out on property purchases. And most of these are happening in historically black neighborhoods in Richmond, right? So people are being pushed out. They're also not able to buy, right? And so that's not redlining, but it has the same effect, right? So there are economic and financial things in place too that have to be questioned under those terms. So I would say all of the above.
Hi. So my question sort of relates back to Caleb's and what you were saying about like tiers of whiteness, and it made me think about the Race Unequals book that you introduced me to. But in that she argues that, or the author argues that overseers were bargaining for their whiteness because they couldn't be property owning. And I was thinking about the Alabama case that you put up, and do you think that there's an overlap there with the vestige of that sort of overseer contracting and bargaining that's going on?
I think it's very obviously there, such that the sort of the prison wardens and correctional officers are getting a wage in order to keep everyone in place, right? So they're reproducing that brutality that the overseers and the day laborers on plantations were that role that they were playing. Where the overseer was doing the whippings, the correctional officers are placing people in solitary confinement and having other prisoners beat them up, right? But there's a difference that I think is important. Many of the correctional officers are people of color, right? Just like many police chiefs in our major cities are people of color. They're African American. Many of our mayors, including here in Richmond, right, are African American. And so there is some subcontracting that's going on. You delegate the work of the contract enforcement to people, perhaps regardless of their race, right? And those subcontractors can be convinced that because they hold these roles and are collecting a salary, that they are closer to accessing the capital, and they are confused. And they will always be disappointed. When the lawsuit comes, they're the ones who are named in the complaint. They're the ones whose jobs are at risk. The police officers, right? The police officers who tend to be a police officer of color statistically are more likely to be convicted of police brutality than the white police officers. And even the white police officers remain constrained economically, right, to the blue collar work and the relative dispossession and disempowerment that comes with that.
Hey, Professor. Thanks for speaking. That was wonderful.
No problem.
I also wanted to ask about the Alabama case. What are the main precedents that you think the court will use in that case, and what do you think the court is likely to focus on? The main thing how they make the decision.
I don't know why you do that to me this morning, but I've always been good to you. Honestly, I have no idea. The case was just brought. The claims are brought under the Alabama Constitution. the Trafficking Victims Protections Act, so it's human trafficking claims. There's 14th Amendment equal protection of the law claims, and I believe there's also 8th Amendment cruel and unusual punishment claims. For me, the case is very well pled so far, and it should, I would think that it would, if I were the judge, I know how I would rule. However, Alabama has responded that this is actually rehabilitation. By sending them to work, they're preparing them for life on the outside. And so here is where, right, something else I always like to teach in class, that, and I think Justice John Marshall embodies this. The financial investments of the judge will matter. They shouldn't. But that's inevitable, right? If you've got a practice that is making up 75% or 73% of the entire state's economy, it's hard for me to imagine that the state is going to let that practice go without a fight. Assuming that this went up to the Supreme Court, also I couldn't tell you. I remember when law used to matter at the Supreme Court, but now laws, I don't want to get in trouble, but it's more partisan than ever before. And so I honestly couldn't tell you what the actual outcome would be.
Good morning, Professor Jackson. So thank you. My question is, and it kind of relates to what you was explaining to Catherine, and so that you think there's a host of things that needs to be changed that will lead us to the solution. And I guess my question is just more so your opinion and your thoughts on whether we are just being optimistic and hopeful that change will actually come, or do we think that the world would just continue to present the same issues but under a different name? Mm-hmm.
I am perhaps the most pessimistic optimist you've ever met, and so it just really depends on what day you catch me. I'll tell you, before I came to the academy, I was a policy girl, right, and worked on policies that I've seen have sort of impact people like in their daily lives, and I would say that policy really has a power to change material outcomes. Policy, once implemented well, also changes people's perspectives and opens up for them an imagination. Okay, so in many cases, because we are sort of in the United States and we are supposedly the best country in the world, we think that if it hasn't already been done, or if we don't have it, it's not possible. That's a lack of political and legal imagination that I would like us to get past, right? So what I think is, if we don't adopt that political imagination, yes, we are doomed to continue to reproduce the same systems, the same oppressions, the same failings. But for me, the height of the pandemic was very enlightening, right? Because when the pandemic happened and our social life pretty much fell apart and the economy stopped, the government rushed in with all these solutions. And I don't know if you remember what happened, but for African Americans, many African Americans came into amounts of wealth that they had never had. And when I say wealth, I mean like financial liquidity that they'd never had before, right? They were also working from home, and they said, this is the first time I haven't experienced bullying at work. I'm no longer at threat of being pushed out of my job, right? So there were all these immediate sort of positive impacts. There were also sort of bureaucracies and hurdles that had existed for all, like everyday American life, that were sort of let go. They said, we don't actually need to make people's lives that hard. It's just not necessary anymore. And so you started to really be able to feel and imagine, while in your house, what life could actually be like. Child poverty, right, sort of went down precipitously with the child tax credits, right? And I will never forget, even with my family. So first of all, we were able to buy our first house because interest rates were 2% all of a sudden, right? We were not like suffering or anything like that, but every family in Maryland, which is where I was living, got an EBT card with like hundreds of dollars every month for groceries per child. They didn't ask you how much money you had. You just got it. And as someone who didn't really have a problem, I mean, I was just able to just buy so many like wonderful fruits and vegetables, you know, for my own kids that I had never done before, right? And I can only imagine what that did for people who had less privilege, right? So just to use that as an example, Tanisha, of once the policies are in place, right, then you can develop the imagination that allows you to push for more. Does that help?
Yes,
okay.
thank you.
Hey, Marissa. Thank you for the presentation. It's fantastic. So you start with the image of John Marshall, and you talk about the courts in cases on a couple of different occasions. And I'm wondering how central you think law is to the project of renegotiation. In the civil rights movement, of course, law and challenges to practices through the courts was a primary option that was used. We obviously have a very different court, very different orientation, but we still have the Reconstruction Amendments on the books, and potentially available depending on how they're interpreted. Where does law, I know that you mentioned all of the above options, of course, and law would, I assume, be a part of those options, but how central do you think it should be in terms of that renegotiation project in these times?
That's a great question, Bertrall. So I would say law is important, and I think law should be central because I do believe that we are supposed to be a nation of laws and not of personal interest. That's what I believe we should be doing. But I do believe that given the current circumstances, the current makeup of the court, the current sort of orientation of the court to sort of recreate law to meet politics, I think that makes the politics even more central. And I think that's where we come in. So voting is definitely a part of that, but I think other forms of organizing, and I think that's why policy, right, particularly local policies, local elections and local laws are perhaps even more important at this time than the federal laws, because you've got to get people in place who are actually going to give good faith interpretation of those Reconstruction Acts, right? And not people who are going to rule according to whoever gave them their latest vacation, right? That's very important. So to answer your question, I don't think that law will necessarily save us, and we can't rely on it, but I would love to get us to a place where we could.
Up here in the balcony.
Hi.
Thinking of the Alabama case, and maybe this is broader than what you've really been able to talk about, but do you think that our entire institution of incarceration is a vestige of the Confederacy? For example, like disenfranchising felons here in Virginia. Can you expand on that, or maybe that's sort of beyond the scope? And I'm interested in your thoughts on that.
No, I mean, the only issue I might take with the question is the use of the word vestige, right? Because I just think vestige means that something that like no longer exists. Mass incarceration is a replication of enslavement, of the institution of slavery. The expansion of the carceral state is a way of keeping the people who were enslaved in place on new plantations, right? So I think we must grapple with our carceral state and our general carceral zeitgeist, right? Our bloodlust as a society, our desire for retributive justice. But we also have to deal with all of the pipelines that are in place that are meant to funnel people, right, out of school and into prison, right? Or if you're Betsy DeVos, right, out of school and into the factory, and if you're not going to do the factory, then to prison.
Well, I actually have a question, if that's okay. This might be something that you don't know, and that's totally fine.
Sure.
The Alabama case, I know it's really hard to sue the government. Do you know the cause of action, and do you think that they will be able to overcome that hurdle?
Well, I think the cause of action, so again, like there's equal protection, the claims, and the cruel and unusual punishment claims. So it will be interesting to see if someone raises a qualified immunity defense. And if they do so, then you obviously have to overcome the hurdle of, like, did you have a fair warning that your actions were a violation of the constitutional amendments? So I could imagine if I were defense counsel or like representing Alabama, I would probably invoke that immediately. I don't know what will happen with that because we have some really, really mind-blowing qualified immunity jurisprudence, such that, like, the Fifth Circuit, like, again, this is back to race in the Constitution, some of my students are here, 6 days in a feces-covered cell was not considered enough of a violation for the Fifth Circuit because they said it was only 6 days, right? The Supreme Court, of course, said, like, are you mad? Like, this is obviously a violation. But even then, right? Clarence Thomas dissented without comment, you know, as he did in the case of Hope versus Pelzer, where you had a member of a chain gang, again in Alabama, hitched to a hitching post and left out in the sun for hours without water. And when and the wardens actually brought water and spilled it out in front of the inmate to mock them. Right? That's what's going on today in the United States, today. So, right, the facts seem to indicate, oh, this should be cut and dry, and yet our jurisprudence does other things. So I really don't know what will happen with this case at all.
One more question.
Good morning.
Good morning, Seth.
So my question has to do with Nazis at CPAC, right? And particularly the extent to which the Confederacy, as we're talking about, is a unique and exceptionally American phenomenon, or the extent to which it may not be, and it may be broader human phenomenon, right? And the Nazis at CPAC example is really influential to me because the Third Reich and Nazi lawyers leading up to the Holocaust were very much inspired by the Jim Crow American South and by the response to Reconstruction, the white supremacist aftermath to Reconstruction. So I'm just going to tag a question mark at the end of that. Are we talking about something that is uniquely and exceptionally American, or is it somehow broader than that?
Probably yes and no, right? There are parts of this that are uniquely, maybe not uniquely, but sort of prototypically American, from which others are borrowing. There's also a lot that is not American that our Nazis are borrowing, right? There is an incredible amount of global organization on the very far right. There are conferences, there are lectures, there are trainings. There's tremendous amounts of money flowing to create this sort of global right-wing populism wave that we're seeing. And a lot of that is flowing up through the United States. So Steve Bannon was doing a lot of that work. Steve Bannon was Jair Bolsonaro's campaign manager for a point in time, going back and forth across the Atlantic Ocean to do trainings with Jean-Marie Le Pen in France, just fomenting this, what Frantz Fanon called these Nazisms, right? For Frantz Fanon, this is a global phenomenon, right? And it is meant not to just secure liberal democracy, but to secure capitalism, right? And I don't mean that liberal democracy is bad. The problem is that We have been using white supremacy as a way to make liberal democracy more perfect for people raised as white. And it's done explicitly on the backs of everyone else. And that is happening well beyond the United States and always has. But there's a lot of communication happening and a lot of influence going back and forth between the US and other nations.
We have time for like one or two more questions, if anyone has one. Okay, if not, just to make sure that we stay on schedule, let's take a 10-minute break, and then we'll be back at 10:15. Thank you so much.
Hi there. Hi again. We're going to get started. If you don't mind taking a seat, thank you. Hi again. My name is Alyssa Harrison, and I have the pleasure of introducing Professor Bertrall Ross this morning. Professor Ross joins us from the University of Virginia School of Law, where he is the Distinguished Thurgood Marshall Professor of Law and the Director of the Karsh Center for Law and Democracy. Professor Ross's research and teaching include constitutional law, constitutional theory, election law, administrative law, and statutory interpretation. Professor Ross focuses on ensuring his research and pedagogy is collaborative and engaging, and Professor Ross seeks to create spaces where students and colleagues alike can feel comfortable in academic and political spaces too. We're excited to have him with us here today for the symposium, and please join me in welcoming Professor Ross.
Thank you. Well, talk about making folks feel comfortable. I have an admission to make. I spilled a little egg on my pants. That wetness is me trying to clean off the egg from my pants, not anything else. So let's just put that all out there. I can try to pretend like you all won't notice, right? I'm standing right in front of you, so you're all going to see us when I explain what happened. Okay. So thank you all. This is great to be here. Coming here marks my third of the Big Five visits to the Big Five law schools in Virginia. I'm new to Virginia, just joined UVA faculty last year. This year I've had the honor and opportunity to go visit at William & Mary, Washington and Lee, now Richmond. I'm still waiting for my George Mason invitation. I'm sure it's forthcoming very soon. So thank you for having me. I thought I would spend the first part of my talk just telling you about who I am and what moves me and what motivates me. So, as Alyssa mentioned, I am the director of the Karsh Center for Law and Democracy at UVA Law. And one of the things that I've created at the Karsh Center is the Designing Democracy Project. And what this project is really focused on is trying to get students involved in the process of correcting democracy's defects. Democracy, as you may have seen, in America has several different defects. And yet, if we have this mindset that this should be left to the so-called experts to resolve, to come up with different ideas and solutions to resolve the problems of money and politics, inequality and representation, turnout gaps and deficits, and so on and so forth. My mindset is that what we need are new and fresh ideas, and we need an investment into our democracy by the newest generation of folks who are going to be taking over our democracy soon. And so we have three different projects of students that are working on different elements of democratic defects, from the participation gap between the rich and the poor, the representation gap between the rich and the poor, and the problem of populism, polarization, and inequality. And those projects really stem from my own interest in what's going on in democracy in America. So I entered into the academy really focusing a lot on voting rights. And my real interest and my passion at the beginning was racial discrimination and inequality in voting rights. But I then started to see something else I wanted to explore that's directly connected to this racial inequality in voting rights. And that had to do with the economic class-based inequality in voting rights. And what we see, if we kind of go back to 1964, which was the first census to collect data on turnout by different economic groups, is a persistent and consistent 30% gap in voting between the upper income quintile in the United States and the lowest income quintile in the United States. And that has corresponded with a massive representation gap, in which political scientists like Martin Gillens and Larry Bartels and others have found that representatives in Congress are highly representative to the wealthy, as you might imagine, somewhat representative to the middle class, but not at all representative of the poor. So when you see the surveyed interests of low-income individuals, and you try to assess and see what the correlation between that surveyed interest of low-income individuals and the actual actions of representatives in Congress, there is no correlation. There is no linkage. It's only when the interests of the poor align with the interests of other classes do the poor get represented. And so what we see here is this vicious cycle that has emerged in our politics. A vicious cycle in which the low-income individuals do not participate in the political process because they see their representatives as non-responsive to their interests. And we see representatives that are non-responsive to the interests of low-income individuals because those individuals do not vote. And the question is, and the question I've been trying to struggle with is, how do we sort of intervene? How do we break that cycle? How do we create a more virtuous one? Now, some may think that, why does this matter, right? One theory is that non-voters and the voters represent the same interests, so it doesn't really matter who votes and who doesn't. But that has been debunked in many social science studies. The other, more cynical account is like, well, that's their problem. That's the problem of the poor. And if they don't want to vote, they're not going to get represented, that's on them, right? But when you see events like January 6th, you start to recognize that there are these broader social costs to non-participation, marginalization, and alienation. When you have a marginalized group of individuals in a society, in a democracy, that feel disaffected from politics, that is a reservoir. That's a pool from which authoritarian, anti-democratic forces can recruit. And to the extent that we have authoritarian, anti-democratic forces recruiting from that pool, it serves as a threat to American democracy and democracies worldwide. So that's kind of where my interests are sparked and focused. And I really appreciated Marissa's comments. I've seen Marissa on Zoom, presenting on Zoom during the pandemic. This is the first time I've seen her present in person. And it's really great to see sort of the dynamism that she brings to the table with her ideas. And in some ways, I seek to build off of those ideas, perhaps as a pale second course to this particular symposium. And what I seek to introduce is a discussion of where we are with respect to inequality, and really focusing on the states of the former Confederacy. And here's where you see inequality and the racial inequality nexus to be particularly strong and powerful. And then I seek to go back in time to explore a counterfactual of what could have been, what Southern politics could have looked like if things had gone a little bit different. And that Southern politics, and that difference in Southern politics is based on this dynamic that just seems crazy right now, in which African Americans are the pivotal vote in that democracy, in which both parties, or all parties that are in play at that time, are vying for their support and are seeking to be responsive to their demands, right? That counterfactual reality could have led to a different future for the South from what it is right now. And so I'll engage that project here, and I, of course, welcome your questions afterwards. Okay, so let me sort of get started in terms of where we are right now. And then start to reimagine where we could have been. I was supposed to turn this off. Did I turn it off? No, it's off. Okay, good. All right. This is very high. I'm very short. I'm short, not very high. But anyways. Okay. So there are 11 states in the former Confederacy. Right? And here is kind of the map of the former Confederacy from Virginia to Texas. Now, what do we know about these 11 states of the former Confederacy? Well, we know that 6 of those states are in the bottom 10 in welfare spending. We also know that 6 of those states are also in the bottom 10 in terms of education spending. We know that of the 10 states that have refused to adopt Medicaid expansion, 7 of those states were in the Confederacy. Now remember that deal under Medicaid expansion? I don't know if you all got into Sebelius yet in your first year of common law class. But the deal under Sebelius was the federal government would pay 100% of the cost of Medicaid expansion until 2018, and then 90% thereafter. If I'm a politician in the state out, sign me up immediately, if not sooner. And I'm going to go ride my horse into those communities and tell them, I got that for you, right? And secure those votes. But many states made different choices. And several of those states that made different choices are members of the former Confederacy. So maybe you're thinking, well, maybe it's because, why do we have such low welfare spending? Why do we have such low education spending? Why didn't they expand Medicaid? It's because these states are wealthy and they don't need it. Right? They're doing so good that they don't even want this government money. Well, then you start to look at the data. And you realize that 5 of the states of the former Confederacy are in the bottom 10 in terms of poverty rate. So how do we get here? And what can the past tell us about the state of the present? For me, the symposium represented an opportunity to learn more about an overlooked decade between the end of Reconstruction and, take that off. Excuse me. Between the end of Reconstruction and the beginning of redemption in the 1870s on the one hand, and the constitutional conventions from the period of 1899 to 1901 on the other. Now, what's the sort of separation going on here? Well, the myth that I was told, or at least what I remember, I should not blame my teachers. It was probably my fault. Probably stopped paying attention, right, when they were telling me about what happened between the end of Reconstruction and the constitutional conventions in 1901. But I just missed that day. I might have been sick, might have been ditching school, who knows. But what I have remembered was that with redemption came the wholesale disenfranchisement of African Americans. That's the story that I remember. And I thought a little bit about it at the time. I was like, well, when did Reconstruction end? Around 1876. When did we have this wholesale disfranchisement of African American? About 1899, 2000, 1901. I was like, well, that's 23 years. What happened during that 23-year period? What's going on? Is this kind of a gradual disfranchisement? And why is it gradual? Are African Americans just passively accepting their fate and saying it's going to come and we're just going to accept it? Or is there something else going on during this period? And what the symposium provided me the opportunity was to really kind of learn about what's going on in this period. Now, this curiosity led me to exploration of some historical sources, and there are many historians that have covered this period. J. Morgan Kuzer, Gunnar Myrdal, C. Van Woodward, V.O. Key. You also have the accounts of this period from folks like W.E.B. Du Bois, who are talking about this era, thinking about it in terms of different perspectives of hope and possibility while recognizing the realities at the same time. Now, those accounts, they offer detailed and sweeping accounts of Southern history. And it has provided me with some opportunity to understand the 1860s, 1870s, 1880s, and 1890s. But what even brought me closer was really focusing on sort of Constitutional Convention debates. Constitutional Convention debates that are occurring during this period in Southern states. What are they saying? What are they concerned about? And what struck me in reading these Constitutional Convention debates is a fear and a concern that white supremacy could fall. And that just kind of blew my mind. Because I'm thinking, once the troops left, y'all got this, right? But they didn't feel like they got this. They felt worried. And it's that worry that led to massive disfranchisement. That worry based on a fear that the so-called inferior classes would somehow take over. But my starting point is a question. Why didn't the Southerners, when they took over their state legislatures at the conclusion of Reconstruction, immediately disfranchise African Americans? And I think that there are two primary reasons for that decision, or maybe more. There's certainly more. First, there was the U.S. Constitution. Now, although we have been conditioned to seeing the 14th and 15th Amendment as having limited constraining effects on Southern behavior after Reconstruction, that account appears to at least be partially wrong. The Southern legislatures were very concerned about violating those two amendments. And one concern arose out of Section 2 of the 14th Amendment. It's not something that we talk about a lot in law school, right? We're a Section 1 people, right? We go with number 1. We don't go to number 2. But number 2 has a lot to say. And number 2 is a pretty innovative device that was put into the Constitution designed to force states to enfranchise African Americans. And what is said is that to the extent that you do not enfranchise African Americans, you will lose representation in Congress. So it was a bit of a carrot and stick approach, right? You enfranchise, you'll get these representatives that you're entitled to. You don't, you won't. And during this period, you saw white state legislators expressing concerns about this provision, that this provision would be invoked to the extent that they enacted discriminatorily disfranchising laws. Now, during Reconstruction, this tool was neither used nor necessary, as black office holders in Southern state legislatures and military occupation of the South blocked any effort to disfranchise African Americans. But again, even after the military had left, and even though after black office holding had diminished due to the actions of white Democrats, Section 2 continued to have a deterrent effect. Now, white Democrats successfully used tactics of fraud, intimidation, and violence to secure control of state legislatures and reduce black office holding. But once in office, for the most part, they declined to enact laws designed to disfranchise African Americans. They feared the return of the Union Army. And they also feared a potential loss of representation in Congress. Second, there was the 15th Amendment, which functioned as another important deterrent to black disfranchisement. African Americans during this period exercised tremendous agency. They weren't passive recipients of discriminatory laws. They were active resistors. And to resist at this time means something very different than to resist in these times. To resist at this time meant putting your life at stake, meant a potential lynching or killing by white forces without any retribution or without any consequences for those who had committed these violent crimes. Nonetheless, African Americans, in the face of this potential of violence, exercised agency and actively exercised the right to vote, such that even during post-Reconstruction, a majority of African Americans continued to participate actively in the political process, and some held office even in spite of the efforts of white Democrats. And African Americans also exercised agency with respect to bringing matters to the courts. They relied on the 15th Amendment to counter Southern efforts to reduce their voting power. And while their success rate wasn't high in courts, it was high enough to prevent the full-scale legal disfranchisement that we would see at the turn of the century. Finally, something that is often overlooked is the fact that white Southerners were not a monolith. There were certainly a fair share of white conservatives, racially regressive, white supremacist Southerners who held considerable power. They tended to be the old plantation owners and their heirs from the antebellum South, merchants and owners of capital in the newly emergent industrial South. These Southerners had everything to gain from the preservation of the racial hierarchy. Such a hierarchy is not only comported with their sense of social, civil, and political superiority, but also very much served their economic interests. As tenant sharecroppers or cheap forms of labor in factories, many African Americans were indebted to white members of the creditor class. And that status of debtor contributed to a cycle of racial economic exploitation that blurred the line between slavery and freedom. But there are other whites who also held racially regressive views and also rejected notions of black social, civil, and political equality, but they also suffer from the same economic vulnerabilities that ultimately align their economic interests with those of their black counterparts. These whites were the small farmers and factory laborers who often stood in the same debt relationship as vulnerable African Americans with the wealthier white creditor class. And many of these whites, like their black counterparts, were merely an economic crisis or panic away from economic disaster. In the late 19th century, economic crises and panics were a frequent event. The emerging industrial capitalism was subject to minimal regulations, and the social welfare state was in its infancy, with charity serving as a primary source of social support. The South as a region comprised mostly of poor and vulnerable farmers and laborers. And as that site, it could have been the site of a progressive and redistributive policymaking apparatus. If farmers and laborers organized, and if racist feeling could have been subordinated to economic self-interest, then a cross-racial economic coalition could have taken the South in a progressive direction. In the 1880s, farmers and laborers did begin to organize in response to the economic exploitation that they suffered at the hands of large landowners and owners of capital. A regional farmers' alliance emerged in the mid-1880s that, according to one historian, spoke of voluntary cooperation so that working Americans could free themselves from demeaning dependence on the men who handled the money in Gilded Age America. The Farmers Alliance established state and local exchanges for their products and cooperatives that allowed for the sharing of tools and resources. The Alliance also tried to pressure politicians into adopting policies more protective of farmers, including the ambitious sub-treasury program, which was a mechanism designed to maintain a floor on the price of farm products. In one respect, the Alliance was more inclusive than other farmers' organizations that came before. Women were allowed to be members of the Alliance. But in another respect, the Alliance retained the old ways of prior organization in its exclusion of African American farmers. But again, African Americans did not just passively hope and await entry into this Farmers Alliance. Instead, African American farmers organized on their own. They organized in 1886 and created the Colored Alliance, which was eventually renamed the Colored Farmers National Alliance. Through this alliance, African Americans set up their own exchanges and cooperatives that function as institutions of mutual support. They also sought to influence policymaking towards two ends. First, towards laws that would protect and advance farmers' economic interests. And second, towards laws that redress the discriminatory practices in southern states, particularly those practices of violence, intimidation, and fraud that reduce the voting power of African Americans. The two farmers' alliances were important political innovations that provided some protections for farmers against the vagaries of unregulated capitalism. But as separate organizations, their efforts proved much less effectual than they would have been if the two organizations had combined forces. In the 1880s South, racism proved to be too much of an obstacle to sustain a robust collaborative and coordinated actions between the two alliances. But on the labor side, there was much more progress towards a cross-racial alliance. That might seem weird. We understand labor history as one of exclusive racist history. But in this blip of a moment in the South that represents kind of a counterfactual existence that makes you think, what if? The Knights of Labor, recognized as a leading labor organizer in the South during the Redemption era, that racially exclusive organizing would be counter to the interests of the movement. A cheap reservoir of unorganized black labor would directly serve the interests of the owners of capital and undermine the goals of the nascent labor movement to secure better wages, hours, and better working conditions. As a labor historian describes it, the Knights opened their door to black members and declared that racial divisions must be overcome if working people were to advance in the new era of Gilded Age capitalism. But although the Knights of Labor, as an organization, knew that interracial solidarity was necessary to advance the interests of the movement, they still couldn't entirely get over the deep-seated racism of its members. And one result of this deep-seated racism was the continued segregation of most black and white members into separate local assemblies. Despite this segregation, the Knights did achieve some successes through tactics such as support of boycotts of companies that use convict or non-union labor. But ultimately, the organization's choice of racial divisions and choice not to engage in politics more directly limited its capacity to achieve greater successes. And then one of those panics hit. And this was the Panic of 1890. And that change matters significantly for both the Farmers Alliance and the Knights of Labor. The panic had broad impacts on Americans, but those who bore most of the brunt were the small farmers and laborers. Many small farmers had their lands confiscated due to their inability to repay debts. Tenants were kicked off of their lands for the same reasons, and laborers were left jobless as factories shuttered their doors. And those who kept their jobs had to suffer the hardship and indignity associated with low wages, long hours, and poor working conditions. Now, the panic increased the urgency on the Farmers Alliance and the Knights of Labor to more effectively respond to the vagaries of capitalism. And one response was to engage more directly with politics. Now, the political scene in the 1880s was a bit complicated. There's a lot going on here. You have a Democratic majority that held a majority of the seats, legislative seats, in most gubernatorial mansions throughout the South. But Republicans maintained a stronghold in some areas of the South and in some states. A problem emerging for Southern Republicans, however, was growing disaffection with the party from African Americans. The Republican Party's roots still remain staunchly in the industrial North, and its leading party officials aligned themselves much more with commercial and trade interests than it did with farmers and laborers' interests. And since most African Americans in the South were farmers and laborers and not commercial factory owners or traders, there was a misalignment between their economic interests, the interests of African Americans, and those of its long-standing partisan partner. Thus, African Americans, a majority of whom remained voters even after Reconstruction ended, were ripe for recruitment from a party alternative to the Democrats and the Republicans. At the same time, partisan divisions start to emerge amongst the white Southerners. The differences that resulted in small farmers and laborers being on the opposite side in economic disputes from large-scale landowners and owners of capital also opened the door to such partisan divisions amongst white Southerners. The large-scale landowners and owners of capital controlled the Democratic Party, its platform, and its agenda, meaning that the small farmers and laborers would have to look elsewhere to secure political power. And it was into this vacuum that a populist party gained strength in the South. Now, I'm almost hesitant to sort of raise populism because I think that it connotes a current-day populism with red hats and MAGA on them, right? But this is a different populism with a different orientation. Whereas the populism of the moment has kind of a cultural, social dynamic to it, and it seeks to appeal to cultural, social, race, right? The populism here was really more focused on the economics. And what they sought to do was actually subordinate race to economics. Now, the Farmers Alliance and the Knights of Labor emerged as the dominant elements in this new Southern populist party. And they engaged in the practice of contesting executive and legislative elections throughout the South. But the Southern populists knew that they could not win without the black vote. And what was a weak and mostly non-existent alliance between black and white farmers and labor groups developed into something a little bit stronger. I don't want to be too Pollyannish, but it was a little bit stronger. The Farmers Alliance, while not yet opening the doors to black members, collaborated closely with the Colored Alliance on matters of politics. And the Knights of Labor developed into the closest thing to a cross-racial labor union that the United States would see until the 1930s, when the Congressional Industrial Congress organized large numbers of black workers. And the populists directly appealed for the black vote on the basis of shared interests between black and white working men and farmers. In 1892, Tom Watson, a white leader of the Populist Party, made an appeal to black voters on the basis of shared interests. In a speech, he said, "There is no reason why the black man should not understand that the law that hurts me as a farmer hurts him as a farmer. That the same law that hurts me as a cropper hurts you as a cropper. That the same law that hurts me as a mechanic hurts you as a mechanic." Another white populist who signed off as Hayseeder, who was from Georgia, questioned, "Why is it that Democrats are hallowing Negro supremacy so persistently?" That was a strategy by which to invoke fear within the white populace, that African Americans are taking over the joint. And because of that, we need to engage in solidarity with respect to political action. Hayseeder asked, "Are they not citizens of the state holding the same rights under the law that the white man does? If so, isn't it better to give them representation in the convention that they may know for whom they are voting, thereby getting them to vote with the white people at home than to ignore them till the day of election and then try to buy or force them to vote, thereby driving them into the Republican Party?" This was 1892 Georgia, right? This is not 1992 Georgia. This is not 2022 Georgia. This is 1892 Georgia. And 1892 Georgia was a very racist place. White supremacy was a dominant methodology and ideology amongst white Southerners. And yet there was a recognition, right, that we need to engage in concerted political action with our black counterparts if we are to have any chance of securing the protection of our own interests. You have a white populist labor organizer and farmer recognizing African Americans not only as humans, right, but as political beings entitled to some respect. Now, that's not a story of redemption that's typically told. But don't get it twisted. The populists were not racial egalitarians. Watson and most other populists still consider African Americans to be their social inferiors. As Watson declared in his speech, "They say I'm an advocate of social equality between the whites and blacks. That is an absolute falsehood. And the man who utters it knows it. I have done no such thing, and you colored men know it as well as the men who formulate the slander. It is best for your race and my race that we dwell apart in our private affairs. It is best for you to go to your churches, and I will go to mine. It is best that you send your children to your colored schools, and I'll send my children to mine. You invite your colored friends to your home, and I'll invite my friends to mine." So for populists, the relationship was one of political convenience and opportunity rather than true partnership. But ultimately, as one historian explains, the political exigencies of the populist revolt put good Orthodox white men in the position where the racial injustice of their society suddenly appeared to them as injustice as well. Black voters did not simply just fall in line as supporters of the populists. They were an appropriately skeptical group of people. They've been lied to, they've been harassed, they have been subjugated by white Southerners of all political stripes throughout Reconstruction and into Redemption. But some certainly did join the populist efforts. However, others remained open to political pitches from Republicans and Democrats. And in these strange times, even Southern Democrats found themselves appealing for the black vote as a way to blunt the rise of the populists. And for a time between 1892 and 1894, African Americans were the pivotal vote in many Southern state elections. They were as close as they would ever come to be kingmakers. And the South was as close as it would ever come to being the site of cross-racial party advancing a progressive class agenda and seeking to advance the interests of laborers and small farmers. Just think about that. And just think about what could have been. Would the South, with an interracial populist party competing against Democrats and Republicans, have been the home of states with the most regressive social welfare policies in the Union? It's hard to imagine that being the case, and yet here we are. So what happened? Well, there are many things. The populists, despite their growing strength, were only able to make minimal inroads politically, only winning state-level control in North Carolina and some control and power in Arkansas. Democrats retained control over elections and used that control to their advantage as they engaged in various forms of fraud to ensure that the populace came up short in most states. Further, Democrats, apparently recognizing that their appeals to black voters would likely yield little in terms of a favorable vote, turned to the traditional tactics of violence, intimidation, and economic retaliation to deter African Americans from voting at all. And the combination of these tactics not only secured Democratic continued control in most of the state's elected institutions, but also so disheartened white populace that they sought from their Democratic opponents a partnership focused on defeating Republicans at the national level. So in the 1896 national election, the populace endorsed and put Democrat William Jennings Bryan on the populist ticket, even though he never agreed to be the Populist Party nominee. And in the populist decision to join the Democrats that they could not beat, they abandoned the black farmers and laborers with whom they shared so many economic interests. And by the end of the decade, the Democrats reassumed full and complete control of state legislative and executive mansions throughout the state. And they were not going to take any chances that some party might unseat them with the help of the black vote in the future. It was thus the populist movement, in that brief window in which African Americans emerged as pivotal voters, that triggered those state constitutional conventions that comprehensively disfranchised African Americans. And the harm from such comprehensive disfranchisement did not only fall on African Americans. Those white laborers and farmers who sold out to the Democratic Party found themselves neglected and marginalized and unable to do anything about it once their former political partner, African Americans, were banned from voting. An era of Southern economic regressive politics associated with the region's one-party politics began and continues to this day. Now, there certainly have been occasional populist revivals, such as that associated with Louisiana Governor Huey Long, but that remains very much the exception to a dominant period of nearly entirely unfettered race-class capitalism. So why do we have Medicaid expansion, and with most of the states of the former Confederacy rejecting it? Well, I would argue that it is a legacy of this moment, the legacy of the construction of the one-party state. And even though it's not really just about the one-party state that's the problem, I think that what has emerged as something else that we should be mindful of is the lack of need to compete for the black vote or the low-income vote. That they are either seen as entirely loyal and captured by one party, as in the case of African American votes, or they're just kind of irrelevant in politics, as is the case of low-income voters. Either scenario, either arrangement is bad for the future development of democracy in any sort of egalitarian way. Because democracy and economic inequality are fundamentally incompatible. And as economics and resources get more and more concentrated at the top, it will very much undermine the operation of democracy in the long run. And what would need to be changed, or what would need to be shifted, is a change in orientation in terms of who is entitled to representation and who should be engaged. And I'm wondering if we'll get to that moment and whether we could sort of come back to the 1880s as that counterfactual in which we could reimagine what our politics could be. Caleb asked a question about cross-racial alliances with respect to politics. Is that a possibility now? It's very difficult, right, for both sides. For African Americans, it's very difficult because racial discrimination is such a big thing still and should not be subordinated to anything. We need to respond and we need to redress it. Its difficulty on the white side is we've always felt that they were our nemesis, our enemies. We have been told and conditioned into thinking of them as other, thinking of them as inferior, and really deriving, as Marissa describes, racial capital from that notion. These are difficult things to overcome, to imagine. But can it be, and is there a linkage between sort of the economic interests of the two different classes and societies of people? Can that be a coordinating force? Is there a way to come to some sort of agreement or collaboration or recognition of the harms that each face, such that we can move productively together towards a better democracy? And so I will leave it at that. I thought this was hopeful, but maybe it's not. I don't know. I was like, I'm going to sort of bring a hope where Marissa comes in, right? I don't know. I think I might have failed in that regard. But it's just what's on my mind, and I appreciate the opportunity this symposium provided me for immersing myself in a history that I knew very little about before. Thanks.
Can you all hear me? Great. Thank you again, Professor Ross. Really appreciate it. I'm going to take advantage to start off the next few minutes of Q&A with a question of my own. If you had more time to go into this topic, or maybe 3 more hours to talk about it, what is that hopeful idea that you would want to maybe research or talk about a little bit more to point us in that direction of hope down the road?
What I would have liked to explore a little bit more deeply is the views and voices of Black people at the time. It's really much harder to derive these sources because the voices and views of Black folks many of them are not recorded, and to the extent that they're recorded, they're not recorded in outlets that are easily accessible. So you have to go sort of deeper into archives and deeper into people's libraries to really get a sense of what's going on here in their thought process. Because it's not just the white populace that are thinking about these cross-racial coalition opportunities, it's African Americans as well. They're thinking about this possibility. They are, again, I want to emphasize, they are agents. They are very strategic, intelligent, brilliant agents. And they're thinking about, how do we survive in this milieu? And I would love to learn, and I will engage in that continued process of learning how they thought about this. Because from learning about how they thought about this, we could sort of see, and take advantage of the things that African Americans did well, and strategic thinking that we may have overlooked in this moment because we're tired, right? When there's been centuries of subordination, subjugation, the fatigue hits, and it leads to sort of a different way of thinking in response, right? You may not want to sort of engage in those compromising anymore because you're tired of compromising. You're tired of sort of subordinating the values and interests and views of your people, right? And I'm sure in terms of at that time, as African Americans are facing the brunt of white violence, that they are tired of it then as well, but they have to think strategically and with some savvy about how to survive. And I'd be curious in terms of learning more about their thinking of survival and what we might learn from that thinking in terms of moving forward in this moment.
Thank you. Appreciate it. I think we have a question in the back.
Hi, Professor. Thanks so much for your time and for your presentation here today. I was curious, you mentioned at the beginning that in the 1870s or so, the white Southern Democrats were concerned about the second clause of the 14th Amendment and the 15th Amendment, but then you alluded several times to the convention in the early 1900s. So I'm curious kind of how their legal calculus changed at that point, that they went ahead with those amendments and disenfranchised so many people.
Great question. National politics changed, and judicial decisions had come out. So at the national politics level, it became clear. It became clear that Republicans, there was an element of abandonment with the removal of troops from the South. But then they took it to a whole new level when we get to the 1890s, when the Republican Party just starts prioritizing matters that have nothing to do with civil rights, right? Civil rights just falls on the agenda. And so the Southerners start to feel insulated a bit. Congress has to enforce this provision, and they become much less worried about Congress. First of all, Democrats gain control of Congress in a few years over the 1890s, and even when Republicans control Congress, they are not particularly inclined to prioritize this matter. In fact, they see opportunities in recruiting white voters in the South. And they recognize that greater attentiveness to Black voters would undermine those efforts, right? So they're not worried about Section 2 anymore. And then you have the Supreme Court with respect to the 15th Amendment. And the Supreme Court had issued decisions over the course of the 1880s and 90s and into the early 1900s that made clear that the 15th Amendment would not have the force and effect that those who adopted it meant it to have. And so they became just less worried about adopting literacy tests, poll taxes, different sort of mechanisms to disfranchise. So long as they kept it from being explicitly about race, they had the sense that they would be insulated from any legal challenge. And so the calculus just evolved, and that provided opportunity to engage in wholesale disfranchisement.
Good morning.
Good morning.
My question is, if you think, I know that you stayed away from the current election, but I'm wondering from a perspective of campaigns, if there's anything in this history that can inform campaigns, especially considering the importance of the black vote in the 2024 election, can help them to better move or target and account for black voters' preferences.
I'm kind of I don't sort of seek to avoid this election because I talk about it all the time, right, in my day job. But one thing that's curious, and it brings me a source of worry, but also a strange sense of possibilities, is you do see, these really odd efforts by Trump to claim black support, right? And you do see movement with respect to black support from black men. And what's this about, right? Is this about the Trump platform adopting a racial egalitarian message, right? I don't see any evidence of it, right? Is it about sort of a campaign that is speaking to men? Right? There is more evidence of that. And you could see an effort to, in a sense, drive a wedge between our intersectional identities and seek to attract the men part of black men, right? Without really responding to sort of the blackness part of black men. And so that is creating an interesting dynamic that I'm concerned about because, I'm concerned about democracy's future. But I also see possibilities too, because if you go back to this moment, what do I think would be most valuable to African Americans in terms of political power? Is if they became pivotal voters in elections. If they became the voters that both parties are seeking to vie for support and neither party takes for granted, right? That would be the pinnacle of political power. But the path to getting there worries me, right? Is the path to getting there having sort of African Americans subjugating their interests to the interests and platform of the Republican Party that's not responsive? Or does it mean sort of black voters who kind of force the Republican Party to move in a different direction that's more racially egalitarian, right? That would be the ideal, right? And they're both converging, trying to seek out the black vote. Right now, I don't see elements of the latter yet. I see more of the former, and that worries me. And I don't know how we get from the former to the latter. So in terms of thinking about the 1880s, I just think about sort of that dynamic of pivotal vote, and I think about sort of the pivotal votes in American society today. And there are small minorities, relatively small minorities in American politics today that have a considerable amount of political power and political responsiveness because they stand in the location of being pivotal to elections.
Thanks, Bertrall. I was wondering if I could follow up on that point. On the other side of the aisle, what do you think, if anything, that it means for the Democratic Party to sort of be, perhaps they're losing this vote, or maybe just the Republican Party is picking up people who weren't voting before? I don't know.
Yeah.
But there's been a lot of discourse on the left of, black people are getting tired of being just sort of courted with, like fish fries and days of action before every election, and then met with, well, if you don't vote for us, you're going to die. But there's nothing actually being done. So again, the labor is being extracted with nothing in return. Do you see possibility there, or is it just prayers and sorrows?
Or as Fannie Lou Hamer just shouts of, I'm sick and tired of being sick and tired, right? I mean, I think that we are, in probably, year 70 or 80, depending on how you count it, of rather consistent and solid Democratic support for the Democratic Party, right? You can associate with perhaps the end of FDR, maybe you do it with Kennedy, maybe you get to Johnson, however you kind of view it. It's been a long period of black support. And initially it bore some fruits, right? It bore some real significant fruits. Civil Rights Act of 64, the Voting Rights Act of 65, Fair Housing Act of 68, right? These are blockbuster pieces of legislation. And we've had reauthorizations of the Voting Rights Act. And then you start to think, what have you done for me lately? All right? And one of the things that I get concerned about is that it's a Democratic Party that feels that if it starts to be more responsive to the black vote, it will lose centrist votes. And since Clinton, the calculation has been, let's focus on the centrist votes because the black votes aren't going anywhere, right? And I don't know what changes that dynamic other than competition, right? You could protest, you can sort of call your representative, you could say you're not going to vote, and maybe that will have some effect, I don't know, but I think competition is ultimately what needs to emerge. And my ideal scenario would be competition in such that we have a multi-party system rather than just have to rely on these two damn parties to do everything, right? But that's going to require major structural change, so we're kind of stuck within this two-party apparatus. And so, although it brings me great consternation to see African Americans shifting some modicum of support to Trump and the Republican Party, maybe that's just the thing that gets the Democratic Party to start to do something, right? And do something more than the symbolic things that you described, engage in the substantive policy making that we saw in the 1960s.
I'm so glad you mentioned that because I want to invite you to talk about the two-party system and this brief period after the Civil War where we didn't have a two-party system. And that's it, question mark.
Yeah, absolutely. And I think that that's a major mover, right? Because even at the time, we're starting to see Republicans in the South act like Democrats right now. In the sense that, we got that. Who are they going to go? Vote for the Democrats, right? No, yeah, right. And so that's where the disaffection is giving rise. And you see this populist party emerging, taking advantage of that, right? The challenge is that the two parties are just much more strong these days. They have power over electoral rules in ways that will advantage the two parties. They have power over districting. They have choices, although some states are pushing back against them, about how they aggregate votes, right? We have a winner-take-all system that favors a two-party system, but we don't have to have that. We could have districting schemes that are fair. We could have ranked choice voting schemes. We could have cumulative voting. We could have limited voting. We could have different ways in which would provide lower entry points for other parties. But it's certainly not in the interest of either of the parties to do that. And so where we've seen the changes are in those states that have referendum, in which the people can say, this is what we want, right? So they can shift how the primary system works. They can shift how the aggregation of voting works. But it's only happening in bits and parts, and maybe it'll pick up steam. In order for a party to emerge in any substantive way, I think it has to be, it has to be that enough states adopt and embrace these rules that lower the barriers to entry for third parties, such that third parties can be viable, right? It's to be viable at the state level is different than being viable at the national level, and I think that a broader lowering of the barriers could help. The Congress and the Fair and the For the People Act that didn't get anywhere in the Congress, had some innovations in there that could have been helpful. But I think you could go further in terms of thinking about innovations that could bring a greater diversity of party representation in our democracy.
Hi, Professor. Just following up on kind of that line of thinking, I'm curious whether, reform to the two-party system is one way, perhaps another is kind of along the lines of education, because from my understanding, at least with regards to white voters, the effect of once you control for education, it's really predictive of support not only for Republicans, but a certain subsect of those. I'm just curious whether you think that perhaps it's a change to our politics or our framing of politics, or whether perhaps efforts on the local level and changes, I guess, in our education system could be helpful, or just thoughts on that.
I appreciate that question. You're not even a plant. You're like, I'm like this. That's the question. That's what I want to talk about, right? We're just meeting right now. This is awesome. All right, so a lot of my focus in my scholarship and in my sort of advocacy has been around the information problem in our democracy, right? And the information problem in our democracy arises from huge disparities in education. What do these disparities of education result in? They result in disparities in the ability to obtain and process political information. And that means that to the extent that you have lower education, you're less capable of, because of the lack of information education, to differentiate between the two parties in terms of which one would best represent my interests, right? You're less able to ascertain the logistics of voting, right? Where, when, and how to vote, right? And that information disparity has huge consequences for our democracy. What it leads to and contributes to is misinformed voting and non-voting, right? Both are very problematic practices and such. And to the extent that you have misinformed voting and non-voting that is concentrated at the lower income scales, right, it's going to lead to a politics that is very much distorted. So one could imagine that we can respond to this problem by providing for better education, obviously, but here's where I kind of pull out my Marissa's, I'm a very, very pessimistic optimist, right? Do I think that there's going to be a wide scale shift in our education system such that we bring equal education to everyone at the K through 12 level? Not in my lifetime, probably, right? That's kind of a cynical account. But are there other ways in which you can provide information delivery, both through campaigns and technology, that could change the dynamic? So what we see with respect to campaigns have been an important source of information, in terms of their canvassing efforts. And canvassing kind of took off around 2000, 2004, and then kind of really exploded in 2008 with the Obama campaign. And what do campaigns do with their canvassing? They go and they send you a mailer, which is helpful, right? I'll read that, right? They give you a phone call, right? Say, hey, you should vote for this person, this is why, or they knock on your door. And what's been found is that canvassing efforts, particularly knocking on people's doors, increases the likelihood of voting by 8 to 10%. Now, why does it increase the likelihood of voting by 8 to 10%? Well, through the canvassing efforts, you provide information to voters about the candidate and the logistics of voting. All right? The problem is campaigns don't reach out to everyone. Campaigns have limited budget, but they're also strategic. And so they make choices about who to reach out to on the basis of an algorithm that combines facts or information about whether the person has voted in the past and the likelihood that that individual is going to vote for me. Whether they voted in the past is a very heavy weight in these algorithms. And as a result, those who have not voted in the past are less likely to be contacted and less likely to receive this information. And so therefore, the information gap even gets worse as campaigns are engaging in canvassing. Now, can we fix that, right? Well, one opportunity that I've been kind of puzzling through is there a role for technology here? Now, I am not a tech guy, and what I may be describing is completely ridiculous and impossible. Maybe I'm living in sci-fi land, but just imagine with me. Go with me on this a little bit. Imagine there's a person who enters into sort of some computer program on their cell phone or whatever, their demographics, right, their income, where they live, how many children they have, etc. And this program, powered by AI, can provide them with a sense of whether this candidate's policy proposal will benefit or harm them. And they could give a set of estimates about what the effects will be on their children, their likelihood of graduating from school, their livelihood, or whatever, right? And then equipped with that information, that doesn't require anybody to knock on your door, people can make choices about whether they're going to vote for a candidate or not. And even if we don't think people are going to use this information, the possibility that this information could be used could mobilize campaigns to engage in the outreach of these communities, seeking to respond to them, and they're equipped with that information as well, and say, look, this is how we better represent you. You should vote for us. So there are ways to kind of break this sort of information blockade that has advantaged, disadvantaged low-income voters. I think that could be part of the answer to create more responsive parties within the two-party system.
Thank you very much, Professor Ross. We really appreciate it. Let's give another hand for Professor Ross. we're just going to take a couple moments to get our next presenter ready, so don't go anywhere too fast.
All right, everyone, we're going to get going with our next presentation. If everyone could go ahead and take their seats. My name is Callie Loveland, and I'm the current managing editor on Law Review, and our next speaker is someone I've personally had the pleasure of working with, Professor Rachel Kincaid. Professor Kincaid is currently an assistant professor of law at Baylor University, but prior to joining academia, she worked as a civil rights prosecutor at the U.S. Department of Justice. Most notably, Professor Kincaid participated in the prosecution resulting from the 2017 Unite the Right rally in Charlottesville, Virginia. In 2020, Professor Kincaid left the Justice Department to join Mountain State Justice, a legal nonprofit providing civil rights litigation representation to formerly incarcerated individuals in West Virginia. Her research now focuses on criminal law reform and civil rights. Please join me in welcoming Professor Kincaid.
Thank you so much. My disclosure at the beginning is I almost never use a clicker, and I find that when I do use a clicker, sometimes I accidentally click nervously. So if there's some back and forth on the screen, it's all me and my inability to use the clicker instead of my mouse, which is what I typically do in class. So thank you so much for having me. It's really an honor to be here, to get to participate in a symposium on such an important and timely topic. I've already learned so much today, and I'm looking forward to continuing to learn with the rest of you for the rest of today. So I'm going to talk a little bit about an article that the Richmond Law Review has agreed to publish of mine, this article is about law professor hiring and public service work experience. It explores the idea that hiring more law professors with public service work experience can help encourage and support more law students to pursue public service, or at least more pro bono work upon graduation, thus helping to bend the arc of the moral universe towards justice. So you've already heard a little bit about me, so you can tell I'm personally invested in how we can better support law students interested in public service, because I went to law school wanting to work in public service. I went to law school because I wanted to learn the tools to defend vulnerable populations from abuses of power. So as Callie said, I ended up working for the Department of Justice, where I prosecuted hate crimes and official misconduct cases, first for the Civil Rights Division at Main Justice in D.C., and then at the U.S. Attorney's Office in the Southern District of West Virginia, before I moved on to a nonprofit in West Virginia where I worked on behalf of incarcerated plaintiffs and low-income individuals facing consumer protection issues. So the journey of law students interested in public service is something that's very familiar to me, and part of the reason that I wanted to become a law professor in the first place, because I wanted to help support students like me who wanted to enter public service. So since I joined the faculty at Baylor, I've been working on finding ways to support students interested in public service inside the classroom and beyond, and that's led me to this research. So a little roadmap of where I'm planning to go today. First, I want to talk about persistent systemic inequities and law school pedagogy. I'll talk about the role of lawyers in bending the arc of the moral universe towards justice, and how law schools are failing to deliver to public service-minded students. Then I'll talk about what I think are the benefits of hiring law professors out of public service jobs, and some perception and process interventions for hiring more public service lawyers as law professors. So my ultimate goal is to encourage more social justice teaching and more social justice lawyers into existence, but to also help to demystify the law professor hiring process for students and practitioners who might be interested in pursuing that path, to explain what it looks like to become a law professor and how that process works, and also to reassure those of you who might be entering public service and wondering if that path excludes you from legal academia, or if there are ways to make both work in the end. Okay, so we're living in momentous times. Our speakers already today have made that clear. The list of crises facing the world today is long. It includes demands for change after the murders of Tyree Nichols, George Floyd, Ahmaud Arbery, and Breonna Taylor, the crisis of mass incarceration and the criminalization of poverty, the bungled response to COVID-19 and resulting economic precarity of many across the globe, threats to our democratic institutions at home and abroad, the erosion of reproductive rights, the environment and tribal sovereignty, attacks on LGBTQIA+ people and their rights, attacks on public education, including challenges to the kinds of conversations that we're having today about our history of racism and racial oppression, and persistent and devastating levels of gun violence. So many people are calling for systemic change, including many people in legal academia who recognize the role that law schools can play in response to these crises. And many law schools mention social justice and service imperatives in their mission statements and elsewhere. So now is an excellent, in fact, an urgent time to think about how we can deliver on those mission statements and figure out how we can better prepare and inspire our students for becoming change makers in our communities. I'm not the only one pointing out the role that law schools can play in bending the arc of the moral universe towards justice and shortcomings in law school pedagogy and structure that are preventing us from playing a bigger role in this realm. As you can see, AALS, the American Association of Law Schools, hosted its annual meeting in January of 2023 with the theme, How Law Schools Can Make a Difference. I want to talk briefly about a few of the other scholars, but there are many, doing work in this space and the kinds of conversations they're having. So Professor Capers wrote The Law School as White Space, arguing that law schools function as white spaces in what they teach, in how they teach, and even in their architecture, and exploring what it would mean to create law schools where, in his words, intellectual curiosity thrives, where change and challenge are celebrated, where education itself is a practice of freedom, and where there is no need to tout inclusivity because everyone already belongs. Professor Toussaint recently wrote The Purpose of Legal Education, observing that law school has historically been doctrinally neutral, racially homogenous, and socially hierarchical, and arguing that anti-racist, democratic, and movement lawyering principles should not be viewed merely as aspirational ideals for social justice law courses, but instead that asking whether legal systems and political institutions further racism, economic oppression, or social injustice must be viewed as essential to the fundamental purpose of legal education. Professor Griggs, similarly in Race, Rules, and Disregarded Reality, argues that exploring issues of racial bias and social injustice in the law school classroom is a modern imperative, but that these issues are rarely integrated into core doctrinal courses. Professor Pham, in the Critical Case Brief, similarly observes that conversations about race, gender, class, ability, sexuality, and other identifying characteristics are largely missing from students' first-year courses, but they are inextricably tied to the legal doctrine they learn in those courses. So impacted students are aware of them when they come through, but leave their classes feeling at the very least frustrated with the ignoring of their lived experiences. And students not impacted often leave unaware and ill-equipped to serve their future clients who are affected by these inequalities. In this essay, he introduces a practical approach for law professors to integrate critical perspectives into the 1L curriculum. And Professor Augustine and her co-authors wrote Making Public Interest Lawyers in a Time of Crisis, an Evidence-Based Approach, considering what role law schools should be playing in movements for social transformation, and how law schools can successfully produce public interest lawyers. What I'd like to add to this discussion is a consideration of how hiring professors out of public service jobs interacts with these ideas and problems, and how adding these types of professors and their experience can help resolve some of these problems. So, let's talk about the role of lawyers in bending the arc of the moral universe towards justice. Charles Hamilton Houston said, "A lawyer is either a social engineer or a parasite on society. It's only one or the other." Since the 1950s, lawyers working in public service have played an integral part in creating systemic change in the United States. Their goals haven't been easy to achieve. They've been confronted with political opposition and financial constraints, shifting political priorities, and they've had to wrestle with the proper role of lawyers in social movements. But these lawyers have nevertheless persisted in forging a distinctive field of practice that lifts up the voices and builds the power of groups that have been pushed to the margins of our society. They have, among many things, used laws to fight against discrimination and other exclusionary practices, like the lawsuit on behalf of James Meredith on the left here, who sued the University of Mississippi in 1961 after being denied admission to the school. He was represented by Constance Baker Motley in the center here, an attorney for the NAACP Legal Defense Fund, and R. Jess Brown on her other side, another civil rights lawyer. And like Constance Slaughter Harvey here, who was the first black woman to earn a law degree from the University of Mississippi, and then in 1970 joined the Lawyers Committee for Civil Rights under the law. These public interest lawyers have also used laws to fight for expanded social benefits and rights for low-income workers and the unhoused. They've used laws to fight for the constitutional rights and humanity of those on the margins, like Brian Stevenson and his tireless advocacy on behalf of the poor, the incarcerated, and the condemned, among many other causes. These public interest lawyers have demonstrated the importance of lawyers who protest unjust laws and advocate for legal reform, not just work within the systems that already exist. But of course, the work of public service lawyers in creating systemic change is far from over. Our legal systems, criminal and civil, local and federal, continue to perpetuate inherent and systemic inequities that victimize our most vulnerable. So as discrimination and exclusionary practices persist, low-income workers and the unhoused continue to struggle, and those at the margins of society continue to suffer. There are insufficient lawyers to advocate on behalf of affected people. Everyone agrees that having a lawyer makes a difference in legal outcomes, which is why ensuring that all citizens facing injustice have adequate representation is essential to the legitimacy of our democracy. But for many, merely finding a lawyer who can represent them is a major obstacle. So Professor Wolf Townsend has found that as many as 12 million out of the roughly 16 million civil cases filed in state court each year involve at least one unrepresented party. Plaintiff-side civil rights lawyers are in especially short supply. Professor Schwartz has said that few civil rights attorneys practice outside of urban areas, and civil rights attorneys are particularly in short supply in the South. She says you can count on one hand, for example, the civil rights attorneys who regularly bring cases against the Houston Police Department and its officers, which is the 5th largest law enforcement agency in the country. And as we all know, in criminal law, anyone sentenced to incarceration or facing a felony charge is constitutionally entitled to an attorney, an appointed one if they can't afford one. But indigent defense systems across the United States are in crisis, often unable to provide meaningful representation to many of the people assigned to them. And according to Professor Primus, for many indigent defendants, if they get representation at all, it comes from assigned counsel or flat fee contract lawyers who may have very little criminal defense experience and who often have financial incentives to get rid of their cases as quickly as possible. So all of this means that justice through the legal process is not attainable for many, simply because of a lack of an ability to get meaningful representation. At the same time, many students go to law school because they want to be change makers in their communities, either through working entirely in public service or through significant pro bono practice. And law schools seem to understand the role that they can, and I argue should, play in creating change. But modern law schools have consistently failed to rise to the occasion of preparing their students to combat systemic inequity. This is evidenced through persistent systemic inequity itself, right? As long as it persists, then clearly law schools aren't doing enough to fight it. It's also evidenced by the shortage of attorneys to meet the legal needs of underprivileged litigants. It's evidenced by public interest drift. I'll talk about what that means in a little bit. And it's evidenced by law school curriculum's reinforcement of systems of inequality. I focus on the final two categories here, public interest drift and law school curriculum's reinforcement of systemic inequality, but they're related to the other two, and I think the interventions that I propose can help with the other two problems as well. So let's talk about public interest drift, not to be confused with this much cooler kind of drifting. So research consistently shows that large portions, sometimes more than half of entering students in law schools, want to work in public service when they graduate. Students come to law school full of idealism and passion, hoping to make a difference by using the law to serve the public, helping disadvantaged people, challenging unfair systems, and brokering solutions to difficult social problems. But then less than 3% of law school graduates actually work in public service when they graduate. So that's the public interest drift that this gap is. It's easy to assume that public interest drift can be explained by obvious causes: crippling debt taken out to attend law school, and a shortage of public interest jobs. In many job markets, public interest jobs are highly competitive because there are so few of them. And though these realities clearly matter to the reason that students enter wanting to pursue public interest and then in large droves end up not, studies on public interest drift also consistently find that these economic factors are not necessarily determinative, and there are other forces at play. Research shows that the drift is also a function of the acculturation that happens during law school, especially during 1L. This acculturation comes from the way law schools roll out the red carpet for law firms, hosting countless firms on campus for interviews, some schools even requiring students to go to law firm receptions, even if they're not interested in working for a law firm. While students interested in public service are left to vie for only a handful of on-campus interviews and otherwise have to fend for themselves in locating potential employers. It comes from the way that law schools often hire career counselors with little insight or information on public sector hiring, making it easier to interview for private sector jobs and giving less assistance to students who want to work for public service employers. But this acculturation also comes from the way law school professors strip cases and laws of their political and social context. So instead of finding support for their passion for becoming change makers, students often encounter a pedagogical and cultural environment hostile to those goals. New law students find their ambitions of wielding the law as a sword of justice blunted by the shield of neutrality, objectivity, and color blindness dominating the judicial opinions they study in their first-year classes. And professors teach students to make the best arguments on every side of an issue, even going so far as to frame moral commitments as antithetical to good lawyering. Now, I'm definitely not saying that identifying the best arguments on every side of an issue isn't a worthy endeavor for future legal advocates. It certainly is. But if it's done exclusively in a way that divorces cases from their context, it also teaches students to ignore problems with the legal system itself, and especially problems of systemic inequality. This acculturation teaches students that their personal identity and beliefs, what likely motivated students who want to work in public service in the first place, are irrelevant. Law school pedagogy also emphasizes formal and procedural issues in individual cases. So discussions about systemic inequality in the law and legal profession are siloed to the periphery of the curriculum in small, specialized, often clinical classes, seemingly granting permission to doctrinal professors to ignore the social context of the cases that they teach. And this disconnect, in turn, again sends the message to law students that questions of policy, justice, and equality are peripheral to the law, just like they're peripheral in the curriculum, and thus less important than the topics that are the focus of their required law school courses. So for law students who know about systemic inequity when they get to law school, especially through their own lived experiences, this disregard of their lived experiences can result in disorientation and alienation with the law. And law school pedagogy focuses on appellate decisions that contain extensive reasoning. This makes sense because this reasoning allows students to learn how to pull legal rules out of court opinions so that students can focus on the rationale behind the court's holding, so that they can then predict how a court might deal with similar facts in a future case, like they'll be asked to do on their exams, and like they'll have to do in practice on behalf of their clients. But this focus on these extensively reasoned appellate court opinions fails to present a realistic view of the way our legal systems actually work. Nearly 90% of merits decisions in the federal courts of appeals are unpublished, non-precedential opinions with little reasoning. Never mind the trial level opinions that actually decide most cases, and never mind especially the state courts where most cases are brought. Most of these appellate decisions pertain to indigent litigants, and there are even more indigent litigants who never make it that far because they get an adverse ruling at the trial court level and don't appeal, or because their cases are dismissed or default judgments are entered against them on procedural grounds. These disparities are mostly hidden from law students studying these appellate decisions with extensive reasoning. But these realities lay bare the two-tiered nature of our legal system. So the stylized traditional teaching techniques of law professors pull students away from grounded moral judgments and fully contextualized consideration of human conflict. They conceal the ways in which legal outcomes are reflective of existing power dynamics. And this acculturation creates the misimpression that our legal decision-making is all thoroughly reasoned and researched. These teaching techniques also contribute to public interest drift, I argue, by communicating to students that those who are interested in public service, that their moral and ethical passions are irrelevant to the practice of law, and that the legal profession doesn't value careers in public service, and it reinforces inequality by hiding the realities of our legal system from our law students, essentially training students to defend the systems as they exist rather than dissenting when law furthers injustice. So, professors have written about these problems in their particular fields. Professor Ristroff has written about how traditional criminal law curriculum might reinforce mass incarceration because it envisions criminal law as neutral and egalitarian, with defendants presumed innocent and constitutional rights for all, and only the most dangerous of individuals being punished for only the most heinous of crimes, obscuring the realities of disparate impacts on Black, Latinx, and Native people, impoverished people, unhoused people, and people with disabilities, and the lack of rights for many criminal defendants, and the way overcriminalization grants discretion to discriminate and means that almost every person has committed criminal offenses. Okay, so what do I think that hiring law professors with experience in public service can do about these problems? So first of all, of course, there's benefits to law school governance of having more people with direct experience in public service as faculty members who can push for more summer funding for students in public service, financial assistance with loans to students who enter public service to push back on that crippling debt that drives some students away from public service, and hiring public interest career counselors who can better help students secure these jobs. But professors with public service experience can also serve as ready mentors for students who want to pursue a career like theirs. Modeling public service careers for students, reassuring students that their public interest goals are valid and worthwhile, helping them to maintain their dedication to public service during law school. For example, in 2012, during my 1L required legal writing course at the University of Virginia School of Law, my legal research and writing professor, Professor Sarah Stewart Ware, who had worked in public service before law school, or before becoming a law professor, told our class to think carefully about what we wanted to do after graduation. She told us it's easy to step on the conveyor belt and end up at a law firm, but a career in public service might be more in line with the reasons we came to law school. Over a decade later, I still remember her advice. I think that alone speaks volumes about how rare it was to hear something like that in the classroom, especially in a required class, and the importance of what she said, especially to students like me who went to law school to pursue a career in public service. Faculty with experience in public service can also help better contextualize lived human experiences of students and the effects of the way the legal system works. Faculty members with professional experience in public service are more likely to be able to contextualize substantive concepts through discussions of actual lived experiences of people affected by the inequities in our criminal and civil systems, because public service organizations focus on serving people who have experienced some kind of injustice. This ability to contextualize and understand the realities of the inequities inherent in our criminal legal system is one of the many reasons so many of us were excited about Justice Jackson's addition to the U.S. Supreme Court and her experience as a public defender. But the ability to contextualize, I argue, is equally important for effective law teaching. So what kind of contextualization am I talking about? Professors have written how they do this in their courses. So Professor Ahrens, in his article, A Nuts and Bolts Approach to Teaching for Social Change, A Blueprint and Plan of Action, talks about how he incorporates social justice issues into his courses. But this contextualization can mean lots of different things. It means humanizing the people in the cases that are studied, which can happen through things like the Stories series that are available for lots of different courses. It can also be discussions of more systemic issues that cut across cases. For example, the distributional effects of Fourth Amendment doctrine, where someone living in a house has more protections than someone living in an apartment. because apartment dwellers are unlikely to have curtilage surrounding their home that will be protected by the Fourth Amendment, where someone living in an apartment has greater protections than someone living out of their car because of the automobile exception to the warrant requirement, and where someone living in a quote-unquote high crime area, which itself is fraught with racism and classism, automatically has more suspicion surrounding them every time they leave their home, because the Supreme Court has said that someone's presence in a high crime area can contribute to finding reasonable suspicion that criminal activity is afoot with them. It can also mean talking about the realities of indigent defense delivery and ineffective assistance of counsel, asking whether, when we're evaluating an ineffective assistance of counsel claim under the Sixth Amendment, should there be a presumption in favor of defense counsel's decisions as reasonable, like the Supreme Court has insisted that there should be? If public defenders are often overworked and underpaid, and the majority of indigent defense actually doesn't even come from public defenders, but instead comes from people whose full-time job is not working in criminal defense at all. And it can be other discussions about access to justice. Anytime you're talking about a complex legal doctrine in a class about a topic where someone is not guaranteed counsel, and how people who can't afford to pay someone to help them work these things out is supposed to actually deal with the way the law has developed. Talking about these things matters for students interested in public service because it validates the importance of working in public service and highlights the realities of the inequities in our systems. It's not only important for students interested in public service, of course. It's important for every student who will enter these legal systems to understand exactly what the effects of them are on the ground. So hopefully I've convinced you that there are benefits to students and society as a whole in hiring faculty with lived experiences related to systemic inequity and with public service experience. But the demographics of law professors has changed some in recent history, but as a whole remains surprisingly uniform. And many law school hiring committees continue to favor candidates from privileged backgrounds, including by putting little stock in public service experience. So, I want to talk about law professor hiring, how it works, what conventional wisdom says about it, how that conventional wisdom differs from the reality of hiring, and the consequences of that distortion. And then I'll make some suggestions about what I think we should do that could help with more public service hiring. So apologies to the professors in the room, but not everyone knows how law professor hiring works. And I hope to those of you who don't know how it works but might be interested, this helps you to understand the process a little bit more. But I'm also happy to talk with anyone individually or during the question and answer session about this a little bit more. So, law professor hiring often happens through the American Association of Law Schools Faculty Appointments Register. People submit their materials to the FAR. They fill out a form and provide documents like their CV, their research agenda outlining what law review articles they intend to write, articles that they've already published, and a draft article called a job talk paper. They submit this information in late summer, typically the year before they'd like to begin teaching. And then the FAR sends those materials to member schools to use in their hiring process. It is also possible to directly apply to law schools without using the FAR, but many schools utilize the FAR, almost exclusively, in fact. Law professor hiring for doctrinal positions involves 2 or sometimes 3 rounds of interviews at a school. The first round used to happen at the AALS Faculty Recruitment Conference hosted each fall in Washington, D.C., where candidates had to pay to attend the conference themselves. But since the beginning of COVID, this has been handled individually by schools, often via Zoom. Second round interviews typically occur on campus, with schools reimbursing travel expenses, but often candidates have to book the travel themselves first and then are reimbursed after. And these second round interviews typically involve small group interviews with professors and the dean, in addition to the big feature, which is the job talk, a short presentation by the candidate about a scholarly work in progress, followed by a period of discussion with the faculty about their scholarly work and their scholarly interests. Some schools do instead, or in addition, I had one do it back to back, a teaching demonstration where you actually teach a concept to the faculty, not to students, to demonstrate how you would be in the classroom. During the first 2 years of the pandemic, most schools actually conducted the second round virtually as well, but most schools have gone back to in-person. So a quick note, I focus on full-time doctrinal professor hiring, first because the professors who have the most contact with first-year law students are full-time doctrinal professors, and also because I support efforts of schools to shift to unitary hiring, and most schools that have shifted to unitary hiring, where clinical and legal writing professors are on the tenure track as well, have just used the same process, sometimes more often with a teaching demonstration, for their hiring of everyone. So this hiring process can be difficult for people working in public service. Litigators in public service are often the only attorney on their cases, so it's difficult to take time away from work and go on interviews. And to the extent that schools expect candidates to swallow any costs or front the costs initially, that can be more difficult for someone working in public service, who often will have a lower pay than someone working in a private practice. Okay, let's talk about the stereotypical path to a full-time tenure track professor position at a school. Conventional wisdom dictates that to be successful in this hiring process, you should go to an elite law school, the more elite the better, and you should be on law review while you're in law school, and you should graduate at or near the top of your class. Conventional wisdom also dictates that you should clerk when you graduate, typically a federal clerkship, and the more prestigious the court and the judge, the better. Conventional wisdom dictates that after clerking, it doesn't much matter what you do, except that you should not practice for too long. Conventional wisdom dictates that having too much practice experience may actually hurt your application when you go on the market. So often aspiring professors head to big law to claim the clerkship bonus they're entitled to after clerking, or opt out of practice entirely and instead pursue a PhD. Conventional wisdom also dictates that candidates should have published at least one scholarly article since graduation, in addition to having that unpublished job talk paper to present during their interview process, and have completed a teaching fellowship or visiting assistant professor position, which is a 2 to 3 year program at law schools for aspiring law professors, during which fellows write articles and often teach courses, often required writing courses, often for very low pay. And then finally, conventional wisdom dictates that a candidate is ready for a tenure track teaching job, or at least to go on the market. The AALS website, where candidates apply for law professor positions, is understandably viewed as an authority on how to position yourself for a tenure track teaching job. And it has a number of CVs that reinforce this conventional wisdom. 2 of the candidates in the model CVs have fellowships, and then the other has a PhD. 2 of the 3 have multiple scholarly works already published before they're going on the market. They each have given multiple scholarly presentations. One appears to have 5 years of practice experience, all in private practice. One practiced at a law firm and clerked for a year, and the third worked for a law firm for 3 years before joining academia. My first argument is that the importance of this conventional wisdom is actually overstated. These steps have come to be viewed as de facto requirements to becoming a law professor, when in fact they don't actually reflect the reality of law professor hiring. So my next set of slides use data and graphs all collected by Professor Sarah Losky, who does incredible work collecting information and analyzing entry-level law professor hiring each year. So first, here's her graph tracking reported law professor hiring, entry-level hiring from 2006 to 2023. As you can see, we're not talking about very many jobs. There's a peak in 2008 of 167 hires. It dipped to 73 in 2021 and was 129 this past fall. So this is certainly a very competitive market. I'm not pretending that it's not a very competitive market, but it's still not quite as uniform as the conventional wisdom dictates. So the first step in the stereotypical path to law school is to attend an elite law school and graduate at the top of your class. This graph shows where law professors hired in 2023 to entry-level positions graduated from. Yale has by far, Yale has by far the most of any schools with 27, followed by Harvard with 13, Stanford and NYU both have 6, and 8 schools had 3. But the largest bar on the graph is schools with fewer than 3 hires. So even if every school in that graph or in that bar had 2, there's still 27 additional schools that produced law professors in 2023's hiring pool alone. So over 40% of the hires didn't come from any of the schools listed. And 2023 is not some kind of outlier. You can see the hiring from 2011 to 2023 here. And again, the largest bar on the graph is from schools with fewer than 5 hires, which means that more than 50 other schools, besides the ones that are explicitly listed, produced at least 1 law professor from 2011 to 2023's hiring class. Conventional wisdom also dictates that the next step is to get a clerkship. But this graph shows that many hires do have clerkship, but it's nowhere near all hires. It was only 46% in 2023, and it peaked at 62% in 2019. The next stop is a big law job and or PhD. Now, Professor Losky, unfortunately, right now doesn't actually track the type of work experience that hires have, but she does track the percentage of higher degrees, which includes other graduate work besides PhDs. As you can see here, it's not an insignificant portion of hires who have completed other graduate work besides law school, but it's by no means all of them. This year it was only 55% of hires, and it peaked at 75% in 2020. Of the 55% of hires with some degree in higher, or with some higher degree, in addition to the JD, 43 had a doctorate, 21 had a master's, 6 had an LLM, and 1 MD. So only 33% had a PhD in 2023. And then the next step is that fellowship or VAP. Professor Losky tracks fellowships and VAPs, and this graph shows that well over a majority of hires had in fact done a fellowship or VAP across 2011 to 2023. And the number has remained well above 50%, but it's still well below 100% of hires. And Professor Losky tracks the percentage and numbers of hires who have some combination of clerkship, advanced degree besides a JD, and a fellowship or VAP. And here you can see that when you look at all 3, it's most people who have at least 1. But there were still 5 folks hired in 2023 who had no fellowship, no clerkship, and no advanced degree. Finally, I want to talk about the conventional I'm going to skip this one. Sorry, I'm running a little bit behind on time, which is not a problem that I thought I would have. The last point of conventional wisdom is that Professor Losky tracks relevant data for is not to take too long to getting to the point of applying for a professor job. And in particular, don't spend too much time as a practicing attorney. This graph tracks the graduation years for professors hired in 2023, although it actually doesn't track how many of those years were spent in practice versus a VAP or an advanced degree. But 27 of the 129 had only been out 4 years or fewer, 50 had been out 5 to 9, 48 had been out 10 to 19, and 4 had been out even longer. This is out of step again with the conventional wisdom. For example, Yale Law School's Guide for Becoming a Law Professor says candidates who have practiced for more than 5 years often have a difficult time transitioning to academia. and that's echoed elsewhere. But even if all of the 2014 to 2018 graduation group of hires in 2023 were 2018 grads and had only practiced during that time, not done VAPs or advanced degrees, so they would be at the top of Yale's 5-year cutoff. That still leaves 40% of people with more than 5 years experience, which is typically considered or conventionally considered too much. And that trend has remained true across time. While it's always the smallest group that has lots of practice experience, consistently the next smallest group are the people who are only 0 to 4 years out from graduation. So let me be clear. I'm not arguing that the stereotypical path to becoming a law professor has no basis in reality. It clearly does. But it's not as dominant as we talk about it being. It's not as much a required process of steps that must be followed to get the job. And I think that the story we tell, and by we I mean people in legal academia, creates a feedback loop where high achievers think I must do these things in order to get this job because conventional wisdom says I must, and so they then go do those things before even attempting to get this job, which makes it look more like these are requirements and less like they are just potential options. But maybe that's not a huge deal. It also means that maybe people are gathering more experiences than they need to get hired, and that's not that big of a deal, right? But what's potentially more troubling is the way that this inaccurate narrative about law professor hiring can actually discourage candidates who would be excellent candidates as law professors, because it is impossible or incredibly unlikely that they'll be able to gather these qualifications in order to go on to the market. So Professor Mira Dio highlights stories from women of color who note that they ended up as law professors almost by chance because they never considered legal academia as a real option because of these viewed de facto requirements and these host of elite qualifications. I think it's not a stretch to think that these women are discouraged because of the perception of these things being required to be a successful candidate on the hiring market, even when that perception is not backed up by reality. And I think that these same perceptions cut against public service lawyers going on the market. And I think that this is because often public service lawyers don't go to the highest ranking school because they want to minimize their debt when they graduate so they can afford to work in public interest, or because they're drawn to a school's particular program in public service, not their overall rank, because they might not be on law review when they're in law school because instead they're spending time on pro bono work and public service programs, because they might not graduate at the top of their class because instead of focusing exclusively on schoolwork, they're working on pro bono and externships, because they might not clerk after law school because they're eager to get to the kind of public service work that drew them to law school in the first place, because they don't have time to write articles, because they're passionate about the work that they're doing and taking intellectual time and effort away from their cases almost feels like cheating on their clients, because they don't get paid a big law salary so they can't save a bunch of money in order to go work a low-paid fellowship for several years before going on the market or go pursue a PhD. When in fact, maybe they don't need to do all of these things, or maybe any of these things, in order to get hired. So I think this discouragement of non-traditional candidates creates a feedback loop in hiring, and it discourages people from even trying. Okay, I'm going to skip to my proposals. First of all, I think we should stop talking about law professor hiring as though it's uniform when it's clearly not. The data right now backs that up. And as though all candidates have to have the same set of qualifications. And I think we should demystify law professor hiring by talking about it in forums like this. But also, it's not just we should talk more realistically about what hiring is like. I think we should adjust the way we evaluate candidates for law professor jobs to a more holistic evaluation, and importantly, one that recognizes the value of public service work experience itself as an asset to law schools instead of only emphasizing these traditional paths to a law professor job. And I'm going to leave it there. I really thought there was no way I had 45 minutes. So thank you very much for your patience. I'm sorry I was rushing some. I look forward to your questions.
All right, any questions? We've got one over here in the front, Carl.
Okay, so as a 1990 graduate of UVA Law School, it sounds like not much has changed. In fact, I remember a certain professor who later became dean telling my civil procedure class, "We don't teach you how to get to the courthouse." So I'm wondering, why should law schools help change oppressive systems when they benefit so much from them?
I think that's a great question, right? And I think that's part of the rub. I mean, part of it is because if we're going to send students out into these systems, I think we're responsible for ensuring that they're not just reproducing inequality when they're working in these systems. And I hope this doesn't feel like a cop-out, also because law schools say they do this, right? Law schools say in their mission statements that they promote justice. They might not do it actually, or they might do it in very limited ways, but law schools say that's what they're doing. And finally, I think it is because many law students come to law school because that's what they want to do. And so to the extent that we're supposed to be providing a service to our students, we can't be driven exclusively by what they want, because then I wouldn't assign any reading at all, right? But we should be giving them the tools to do the kind of work that they want to do. I also want to say I did graduate in 2015, and my understanding is that there have been vast improvements in public service lawyering at UVA since I graduated. I think some professors have really taken seriously some of the deficits that were there when I was there, and I still got a fantastic education and ended up working in public service. So this is not an indictment of UVA law itself, but I think it's because it's what we say we do, right? I mean, and there are many other reasons.
Hi, good afternoon. First of all, really appreciate this presentation. Definitely identified a lot with the public interest drift issue. And my question goes to that a little bit, and I hope this isn't kind of outside the scope of your research, but I was curious if you have any thoughts on not only just like the way that on-campus interviews happen and all of that, but also just the timeline of hiring for law students and how that contributes to public interest drift, because as a 2L, I've already been offered or given many opportunities to do on-campus hiring for big firms, and then there's clerkship applications, and I'm constantly told, oh, but public interest doesn't hire until maybe like end of summer before your 3L year, if not like later into the fall. And it's tough to wait for those opportunities and hope you get one when all these other opportunities are coming first. So I'm curious if you have any thoughts on kind of how that process contributes to public interest drift, and whether law schools can play a role in adjusting that, or if that's up to judges and firms, or just kind of what that looks like.
Yeah, and thank you for that. That's actually the reason I clerked, because I came back at the beginning of 2L, and all of my friends had law firm jobs lined up, right? They all did on-campus interviews, and suddenly everyone knew what they were doing when they graduated, and I was like, uh-oh, what did I do? And I was in one of the years when judges were hiring pretty early, so I was like, you know what, I will apply for a clerkship, and then I will have a job for 1 year when I graduate. But I think that's absolutely true, right? And that's something that I talk with students about a lot who want to work in public service. It's really nerve-wracking, especially for the type A folks who come to law school. We're planners, we work hard, we think I do the input, I get the result. And it can be difficult to watch all of our classmates successfully planning and just sit and wait for a public service job. I don't think law firms and judges are going to solve this for us. I think law schools can try, right, by trying to bring more public service employers to campus earlier and making it clear, like, we want to make this accessible to our students, but they're not going to be around later. I also think public service jobs need to think about what they're doing to students by hiring so much later. And if you get a public service job and you have some say over when they hire, to the extent you can encourage them to try to provide opportunities earlier, that's better. I had a student in my office really recently who just got a job she's very excited about, but 2 months ago she was emailing me over the holiday break desperately saying, I still haven't heard from anyone, give me more places to apply for. And I had to say, unfortunately, it's still really early. I think it's fine. And it turned out to be okay, but she had to be patient and be nervous during that time. So I think public service employers as well can be thinking about what they're doing. And, you know, there's lots of budgetary reasons that it's difficult for them to hire early, but to the extent they can move up their timeline, that could be helpful. I forgot I don't get to call on people. So weird. This is like went straight into classroom.
Hi, Rachel. I found your discussion really interesting as one who just recently lateraled, right? And like seeing the path and expectations. And I'm wondering how student evaluations may influence the expectation of the track. And so the research had shown that student evaluations are discriminatory towards people identifying in systemically excluded communities, right? And so if your professor hasn't followed this track or are in a systemically excluded community, how the student evals and their expectations of what their professor should look like or be like then steers law schools away from hiring anyone outside of that track.
Yeah, and I think that's a great point. And I think so. I have a lot of thoughts on course evals, mostly that I don't want to look at them because they're mean and it's not nice what you guys say. So first of all, I think that law schools should be priming students about that kind of thing, right? And to the extent that's going to make a difference, I don't know. But you should at least be naming it. And I think it's important to train students on what role implicit bias has in evaluations of their professors, and in what role implicit bias is likely to have in the way they evaluate people who they end up supervising, right? Because most lawyers are going to eventually end up supervising people. And so this is a practice-focused thing we should be talking with our students about. But I think it's really important to be priming students on those issues. I also think that having professors observe other professors is much more valuable in evaluating how professors are doing in the classroom than what you all say about us and how we're doing in the classroom. And it's not as though professors don't have implicit biases as well, right? That's another problem. But at Baylor, we have teams of tenured professors who come and observe us junior folks, and that's not fun, and it's very nerve-wracking, but I feel more confident about their ability to evaluate what I'm doing in the classroom, and in the promotion and tenure process, their evaluations play a much greater role in the evaluations of my teaching than what the student evals say. But I think you're right that that's a great point, and that's a real problem that law schools need to be thinking about dealing with.
Okay, I think we have time for one more question.
Oh, no, I definitely do not.
We'll go to Professor Ross.
I just want to focus on the one aspect of the traditional track that you didn't focus on, and maybe that's the thing you skipped over, and that's publishing law review articles. I think that why many folks do a VAP, do a PhD, is to build up a publication record, and to the extent that you have a lot of folks that are doing that, those who do not and are working in public interest jobs don't have the time to build up a publication record. So do you have a thought about that and response to that? Because I do see law schools as putting particular emphasis on that.
Yeah, and I think that's right. I skipped over it because there wasn't a graph on it because Professor Losky doesn't track it, but I think you're absolutely right. It's really difficult to find time to write in practice in general, and especially in a public service job. One of the proposals that I make that I didn't have time to talk about is that although it might feel a little riskier, I really think that taking a close look at a well-developed research agenda, which is something that someone in public service practice has more time to get to than writing an entire article, and evaluating what they're saying they want to write about, and to the extent that it's related to their practice experience, how they're going to be able to make a meaningful contribution because it's related to what they've been working on, and being willing to accept that in lieu of a publication record, I think is something that law schools need to be thinking about. As long as as long as scholarship remains so important. I'm not saying it shouldn't be important, but I do think that considering a well-developed research agenda and considering the kind of writing, the kind of litigation writing that someone has been doing as representative of what kind of writer they can be and what kind of scholar they can develop into, instead of the articles themselves, is worth considering at the very least. It's a little heretical, I know.
Excellent. Well, thank you so much, Professor Kincaid. We're now going to break for 30 minutes for lunch. There are box lunches available to you guys in the atrium. Please make your way back to the moot court room at 12:45 for our panel. Thank you, everybody.
Hello, everybody. I think we're going to go ahead and get started with our panel. Welcome back. My name is Caleb Briggs, and it is my privilege to serve as the Editor-in-Chief for Volume 58 of the University of Richmond Law Review. I am pleased to introduce our distinguished panelist and moderator for our panel on race and the Fourth Amendment. Our first panelist is Professor Seth Stoughton. Professor Stoughton teaches at the University of South Carolina School of Law, as well as in the university's Department of Criminology and Criminal Justice. Professor Stoughton is also the faculty director of the Excellence in Policing and Public Safety program. Before joining the academy, Professor Stoughton served as an officer with the Tallahassee Police Department for 5 years. His research focuses on police regulation, police misconduct, and the use of force. Our next panelist is Professor Cami Chavis. Professor Chavis teaches at William & Mary Law School, where she also serves as the Vice Dean and as the Director of the Center for Criminal Justice, Policy, and Reform. Professor Chavis's research focuses on police and prosecutorial responsibility, federal hate crime legislation and enforcement, and racial profiling. Our final panelist is Mary Bauer. Mary has over a 30-year career serving as a civil rights attorney, which began with representing migrant farm workers in Virginia. Throughout her career, she has litigated countless cases throughout the country, served in leadership roles for numerous legal aid organizations, such as the Legal Aid Justice Center in Charlottesville, and she currently serves as the executive director for the ACLU of Virginia. Our panel will be moderated by our very own Professor Kevin Woodson. Professor Woodson joined the University of Richmond Law School faculty in 2018. Professor Woodson focuses on workplace diversity, education law and policy, criminal procedure, and legal ethics. He most recently published his book, The Black Ceiling: How Race Still Matters in the Elite Workplace, with the University of Chicago Press. Please join me in welcoming our panelist and moderator.
So good afternoon, everyone. I know that you're here like I am to hear and learn from our panelists, so I won't waste your time with a long intro. We're just going to have Professor Stoughton kick things off, and then we will proceed in order with your presentations. So.
Thank you. I'm going to start my timer. I pace relentlessly, so just brace yourself for a lot of it. It'll be like watching a tennis match, because I'm going to go all over this wonderful space. Thank you so much for having me. I want to start by talking about what we mean by legacy of the Confederacy, or at least offering one potential spin on what we could mean by the legacy of the Confederacy before I talk about what I actually know about, which is policing. I'm going to take you to where I work, the University of South Carolina, now the Joseph F. Rice School of Law. That's new, and I think I earned credit by saying it. In our courtyard, it's a wonderful, fairly new building, about 5 years old, with sort of a quad formation, right? We have 4 wings, a library wing, and a classroom wing, and an administrative wing, and a faculty wing, and in the middle there's this open courtyard. And in the courtyard, there are these large rough-hewn white stones, not quite as big as one of these tables, but fairly large, and they're rather liberally scattered around the courtyard. The students sit on them, eat their lunch. They kind of bake in the sun. It's a very it's a lovely little scene, right? Those stones come from the South Carolina Penitentiary. The South Carolina Penitentiary was built in 1867, and it stood until it was demolished in 1999. At the time of its demolition, it was the oldest still used maximum security facility, the oldest still used prison in the United States. I just want to focus in on those dates just a little bit. 1867. The South Carolina Penitentiary was built because disciplinary actions, and I'm using the words of some of the legislative history when the state funded the building of the prison, because the disciplinary actions that had previously been taken care of by plantation owners and slaveholders, well, now needed another place. So they built the South Carolina Penitentiary. By 1912, well, for all of its history, the majority of the inmates were black. By 1912, about half of the inmates were under the age of 12. Convict leasing there started in the 1870s. When the convict leasing program started, they leased out to a number of fairly dangerous industries. Between 1877 and 1879, the railroad, I think it was the Greenville and Augusta Railroad, leased 285 inmates. 128 died. Inmates died in the phosphorus mines in South Carolina. Today, in the 2020s, they still find graves of incarcerated people that they didn't have and don't have records of. We don't know how many people died in that prison. We sit on those stones that I walk by every day without being aware, unless we think about that history. And to me, I'm going to suggest that's the legacy of the Confederacy. You can understand it as political, you can understand it as geographic, you can understand it as ideological. But I suggest that we think about it as sociological, as the normalization of a particular set of values or realities that are deeply, deeply unjust. And when I say normalization, I mean it becomes normal to the point where it disappears into the background and we can accept it without thinking about it. The way that we accept sitting on those stones and eating our lunch in the law school courtyard. I don't want to sound like I'm calling for the removal of these stones. I actually think the presence of the stones is incredibly powerful because of the conversation it allows us to have. But it is a conversation that requires intentional effort to address. That's the legacy of fighting against the Confederacy. I'm not a scholar of the Confederacy. I am a policing scholar. And policing, I'm going to, you may have heard, how many of you heard something like policing grew out of Southern slave patrols? Great. I'm going to tell you why that's at best incomplete, and although it's a powerful piece of rhetoric, why it actually reduces what should be a very difficult, complicated, nuanced conversation into something that you can toss off and then ignore. So we're going to problematize that approach. Policing started in its modern incarnation in 1829 with the London Metropolitan Police Department. But when I say its modern incarnation, what am I talking about? Well, I'm talking about the formation of a police department. I'm talking about the institution of policing. An institution being a formally organized public entity that does this thing. Well, if we start to think about policing as an institution, there were earlier institutional iterations of policing. There was the Thames Police Force, also in the UK, if you couldn't tell that by the name. Except that was a private police force. Interestingly, Jeremy Bentham, a person of whom you may be aware, was part of the private financiers who founded the Thames Police Force. We've had multiple iterations of things that we could call police forces in some way, shape, or form. We've had shire reeves, which gives us the word sheriff. We have constables. In the U.S., we had night watches, we had day watches, we had city militias. Fun fact, the first uniformed police-like force was the Charleston City Militia back in the 1700s. And we had slave patrols. Institutionally, these are all the predecessors of modern policing. So if we think of policing as anything, maybe think of it as a thick nylon or woven rope with a whole bunch of threads. And it's not entirely clear to me how focusing on one of those threads as part of the institutional history of the policing really helps us understand policing. So I think we have to go beyond the institution of policing. Let's talk about the function of policing. What is it that policing is? What is it that these institutions do? This can be answered a number of different ways. It has been answered a number of different ways, but I think we can be useful. I think it is useful if we go back and look historically. London Metropolitan Police Department, 1829. Why did we need a police department in London in the 1820s? Because there were what I think would be fair to describe as race riots, particularly tension, ethnic tension, between the Irish and the English. And the English had to keep mobilizing the armies to put down dissent in the cities and countryside immediately around London. And it would be better, Robert Peel thought, British Home Secretary and well-known founder of the Peelian Principles in Policing, if we had a dedicated police force that could maybe treat citizens of the British Empire not like the military did. In the U.S., we see the emergence of modern policing in the 1830s, 1840s, in a few cities like Boston and Philadelphia, New York, but really expands into the 1860s, 1870s. By the 1880s and 1890s, every state has its own state police force. Most major cities have their own police force. Most mid-sized cities have their own police force. What was going on in the 1860s, 70s, and 80s? The aftermath of the Civil War. Mass migration from the south to the north, civil unrest, significant amount of immigration from Europe at the same time, which led into all kinds of racialized tensions. It was mentioned earlier, and this is entirely worth taking a few seconds to think about, right? At the time that we're talking about, when we're using police departments, the function of the police agency to deal with racial tension and unrest, it's not just black-white, it's not just northern-southern, it's also German immigrants, Italian immigrants, Irish immigrants, folks who are not considered white at the time, even if they are today. What does any of this have to do with the function of policing? Fundamentally, the function of policing is social control. It's getting people to do what we want them to do, and maybe more importantly, to not do what we don't want them to do. I want to pause for a second because I don't mean that in an inherently derogatory way. I don't really enjoy the experience of being robbed. If there's a government function that can prevent me from being robbed, I am pro that government function, even though that is ultimately an exercise of social control, right? So the function of policing is a matter of social control, at least broadly. But how do police go about doing that? This gets us to the third dimension that I think we need to address, and that's the form of policing, or the tasks that officers engage in as they engage in their function through the authority of their institution. Traffic stops, arrests, pedestrian interactions, Terry stops, Terry frisks, the whole panoply of consensual, legally consensual, psychological consent is an entirely different concept that we won't address here, but legally consensual interactions through the range of coercive actions. When we talk about policing in the modern era, and when we throw out something like, well, policing grew out of slave patrol, so it's obviously abusive, we're actually missing the opportunity to have a much more informed and I think important conversation. Partially because if you already disagree with that statement, there is nowhere for that conversation to go. And you can disagree with that statement, that policing grew out of slave patrols, by either saying, no it didn't, or, yeah, but that's not what they do now, and it's not what they've done for the last 100 years, so what? I think we need to have the conversation, and the way to have the conversation is to say, how are police exercising their institutional authority to engage in the social control function? What are they doing that seems problematic, and how do we get them to not do that? So, how does that refer to the legacy of the Confederacy? If we think of slave patrols as engaging in a social control function, if we think of loss prevention today engaging in a social control, these are the folks at the security guards at the stores who apprehend shoplifters, right? If we think of all of the different social control functions that institutional, government or private institutions engage in, or that you individually engage in, has anyone ever shunned an acquaintance for something? Just a little bit? A nod, a hand, something? Like, yeah, there we go. There we go. You know what that was? That was social control, right? It's an informal aspect of social control. Okay, so back to the Confederacy. Not only am I going to walk around a lot, but I'm also going to jump around in the talk. Back to the Confederacy. As we think about the legacy of the Confederacy, and as we think about making the world a better place today, I think the question is not, or at least it should not be, let us look solely backwards at policing, and there are plenty of historical flaws and problems to discuss in depth, but instead let's figure out what's objectionable about the aspects of social control and the form, the tasks that officers are engaged in, and how does that bother us now the way that the idea of slave patrols bothers us, hopefully now, and ideally back then too. Does that make sense? One last point. None of this is inevitable. There is a tendency in conversations about policing especially to just kind of assume a default status quo. And I find that very defeatist and a little alarming. Because policing should be, as society should be, what we make it into. And we cannot make it better if we admit defeat at step one and say the institution is fundamentally unfixable. The function is fundamentally unfixable. The form is fundamentally unfixable. The function and the form and the institution are all going to exist in one way, in one shape or form. I'm now going to go back pre-Confederacy. When did social control start? That's a legitimate question, not a rhetorical one. I will call on people whose names I know. Yeah, well, sure. I mean, maybe even pre-society, to the extent that you think that that is a pre-societal thing, right? What's the earliest font of written law? You guys learned about this at some point, right? The Code of Hammurabi. There were pre-existing laws, we just don't have them written on pillars in stone, right? What did the Code of Hammurabi say? Other than the eye for an eye stuff, ignore that. Like, contracts had to be fair. You couldn't mix couldn't put rocks in your wheat. Like, it had rules. It had social control. So, part of what oh yeah, good. I'm perfectly on time. Moment of panic. Part of what I want you to think about is not we need to do without social control. Let me rephrase that because it was horribly worded, aesthetically displeasing. I need you to acknowledge that if we have a society, we cannot be without social control. We will always have a social control function, formal or informal. The question is, what do you want it to look like as a matter of form and as a matter of institution? And how are we going to do it? And with that, I'm going to turn it over to Kim.
So, thank you.
You want the...
Yeah, I think... Can you all hear me? All right. Yeah, never been accused of not being able to be heard. And the one fatal mistake that I've already made is when we were talking about this. I've known Seth for a while, and I'm like, why did I agree to follow him? But anyway, so I'm going to kind of pick up where he leaves off, and thinking about, W.E.B. Du Bois said that Black Americans have this double consciousness, and so I think that Black police officers have a double consciousness, right? They are police officers, they've got a function to perform, but they are also dealing with the vestiges of the Confederacy and the legacy of racism in our society. So the query that I would just posit, and we'll come back to this, is we know that there are some disparities in policing, and there's some pretty profound problems that we have with our system of policing in the United States, and there have been a lot of suggested reforms. But I am asking the question of how can law enforcement agencies deal with the systemic violence and disproportionate violence against blacks if the police agencies, and by this, and racial minorities, my work specifically deals with African American communities, but we could broaden that to have any racial minority community. How can we deal with that if they can't address the systemic racial bias and retaliation against police officers in their own ranks that have persisted for decades, right? So, and I really appreciate Seth's this talk, because you do often hear that the modern police departments sprang from slave patrols. And again, I appreciate the fact that that is a very simplistic view, and so thinking about it in terms of the function is important. But if you look at the way slave patrols functioned in the South, there are a lot of analogies that we can make today. Walking around, making sure, do you have your papers, right? There are too many of you congregating in one space. Stop and frisk. All of these things showing us a little bit some analogies and why certain communities are targeted. The complicity with the KKK and lynching during Reconstruction. If you haven't read, and it's not a new book, but Devil in the Grove, has anybody heard about that book? I mean, that's just, again, one example of how a particular sheriff was in Florida, was very involved with complicit in terrorizing black residents, usually young black boys. But again, there's been a lynching, something's happened, there's someone dead, and the police officers, sheriffs, often knowing who did it and not bringing that person to justice or actively participating in it themselves. How do they get into the court? And usually you have a courthouse, and sometimes the jails were in the bottom of the courthouse. How did the cell get open? How did the mob let the person? How did the person get out and be vulnerable to this? So during Reconstruction and later, and then again, I'm just going to go to this. Remember, this is a really iconic photograph. And actually, I did not stop my time, so I will need. Didn't start that. You did, okay. But this is an iconic photograph. Who's that in the photo? Somebody? John Lewis, right? So, and that is a uniformed police officer beating John Lewis, who was just engaging in forms of civil disobedience, right? And then we can also think about, are we in our modern era? Maybe we have kind of surpassed this, but when I think about the war on drugs, it really kind of focused on, crack cocaine in the 80s and 90s. How was the policing function different there than it is now when we're in the midst of an opioid crisis? That's being treated as a public health epidemic. Was not crack cocaine a health epidemic? Why the disparity in the ways that things are being policed? So for a moment, so as we think about this, where does the black police officer fit into all of this and all of this history? And just pretend for a moment that I'm a really cool 90s rapper and, recently trained black cop to stand on the corner and take gunshot. This type of warfare isn't new or a shock. It's black on black crime, again, nonstop. And he goes on, Black Cop, if you've heard the song. And again, KRS One, he actually makes a reference to the black cop being, as Seth told us, this tool of social control used very much in the way that overseers, that plantation owners, enslavers would use black overseers in the field to exact that control over enslaved populations. So I'm going to start with it's not, I don't think I'm making this up. I think we have lots of evidence that we have a problem in policing. And I have a ton of slides, and I won't go through this to make my case. But we know that it does, and pretty much this is a study from California that talks about the racial disparities in police stops. But I could put almost any state there, and there are numerous studies. North Carolina has some of the best data on traffic stops because, and that's my home state, but North Carolina has had for years a law that says that police officers have to, that agencies have to track the race of the people that they're stopping. And this is pretty imperfect data, but again, it shows the very similar disparity. So black residents accounted for 16% of stops made by participating law enforcement agencies. This is from 2019, although they were only 7% of the state's population. And again, this is true in Missouri, it's true in Maryland. There are studies on this. So it's just not when you hear the oral histories of African-American, usually African-American men who have a story to tell about being stopped, it's not anecdotal, it is empirically sound. And then, so when you're stopped, sometimes there's a search. So I used to ask my students, how many people have ever been, had an encounter with a police officer? And then I stopped doing that for a lot of reasons. But then I could ask, how many people during that stop were you searched? African Americans, racial minorities searched more often. But what's interesting is that when you find, so thinking about, again, going back to the function of policing and a search, if it's a search of your person, this is not, even though it's supposed to be minimally intrusive, right, a pat down, oftentimes these searches are very intrusive, very uncomfortable, and so it's not a minimal thing for this to happen to you, and it's a pretty costly experience when you're not finding the contraband, not necessarily your hit rate isn't the greatest. So, and then racial disparities in the use of force. It doesn't matter what officers can use a number of different types of force in effectuating an arrest. It can go from the very loud, hey, wait a minute, to all the way up to using your service weapon. At every single point, right? If it's using your hands, being pushed into a wall, drawing your weapon, at every single point, blacks are more likely to experience force, okay? So again, and I'm just not going to keep going through that, but I think I've made my point that we have some racial disparities. So how did we get here? This kind of goes back to actually thinking about, does anybody recognize the name Rodney King? And right, okay, so some generations will have George Floyd. My generation, I had Rodney King, right, to think about. And a report that was the Christopher Commission report kind of came up with these things. And this, again, characteristics of modern policing in the U.S. really hasn't changed much since the 90s. But, and I'll talk about the code of silence, but this in a moment. But most officers at that time believed that violence was a necessary part of their job. How am I supposed to do my job without violence? That was in the psyche. And then lax supervision and discipline. And again, we've seen this time and time again when we think about, we can go back to George Floyd and looking at the officer who had a number of complaints but had never been properly disciplined and even was allowed to supervise other officers who were also later indicted and convicted in George Floyd's death. I'm going to skip those for a moment. So we have all these problems, and there's a whole menu of police reforms. And again, I believe that some of these are better than others. Okay, and so, but we hear this like the diversifying police departments. We can solve all of this if we just diversify our police departments. And I want to talk about why I don't think that is a panacea for reform. I don't think it is a bad idea. I think all institutions should be diverse, right? It should reflect our society. But when we start thinking about, well, this is what's going to fix the problem, because white officers who are policing black communities are seen as an occupying force, rather than being partners with the community. Maybe part of that's true, but again, it's a very simplistic way to think about fixing a really complex problem. And it's also complicated by this other, so the duty to intervene and thinking about whistleblower protection. And I'll talk a little bit more about that. But when we think about again, if we're all familiar with what happened in the George Floyd murder, multiple officers on the scene, some of them obviously knowing that this particular procedure was you were not following protocol, and yet did nothing. Why is that? Are they bad people? I don't know, we can reserve judgment. Were they scared? That is probably also, two things can be true at the same time, right? So, so when we go back, I just we'll come back here. You've got these these are the officers from Memphis, Tennessee, who were charged with killing Tyree Nichols, right? And it's just very stark to me that you have these uniformed officers, and now they're all defendants, right? And so we can also think about, there are a lot of different things that we can think about, but did they get the same process and that maybe many of us want to see accountability. There was some accountability in this case, but that's not always the case if they had, if there are white officers, and we can. There are other examples I have of that. Those are officers from long time ago with Katrina. Again, just kind of Hurricane Katrina, just showing how pervasive the cover-up was in the Danziger Bridge shooting, and then officers that were involved with Freddie Gray. So this is not a problem of white officers always beating up on black citizens. When we think about the racial makeup of our modern police forces, they are not diverse. We've had some increases, and larger localities are likely to have more black and Latino, Hispanic police officers. But still, like as many things, and then when you start going up the ranks in terms of who are the sergeants, who are the commanders, again, we are not seeing the diversity that you would expect to see in our society. So I go back to this question of how are we going to address systemic racial bias when we have a real racial bias and retaliation problem in police departments? So again, like other professions in the United States, policing was a segregated profession. When black people were allowed to become police officers, mid 20th century, they were often segregated and relegated to, you couldn't even arrest white people that you saw doing things. You may have to call another police department to effectuate that arrest. And so Kenneth Bolton had a study, again, illustrating that Southern black police officers face barriers within their agencies, limiting their advancement and impacting the longevity of their careers, right? So you can think about a police department is like any other workplace. So here's, I think, some very interesting statistics. You've got black officers in Chicago, discipline, and Chicago, by the way, is always my favorite policing example. It is just has been a notoriously corrupt police department. I've said it, am I being recorded? It's corrupt from day one. And black officers are disciplined at higher rates than white officers. In Philadelphia, more than 48% more likely to be disciplined than their white counterparts. Again, Boston, we can use Boston, although black officers, they're 22% of the Boston Police Department, 41% of suspensions, and half of all the terminations, right? And so, again, white officers, so it's very important if you do something well, you get this commendation, and usually that might result in more money for you, and getting a special medal. White officers receive those 3 times more, a 3-to-1 ratio when compared with black officers. So, and then there are case studies on the fact that when black police officers try to uncover the wrong or try to expose the wrongdoing of others in the police department, they are retaliated against and disciplined. The retaliation is another thing that is really important to look at, because it's not like the cost of the retaliation in the police setting are more dangerous and deadly as an officer, and that's when we talk about this concept of the code of silence. Like, what is the code of silence? And apparently, I was going to be silent about what the code of silence is. I don't know what it means, but so when we think about the code of silence, like this concept of I'm not going to tell on another officer. I see that you're not supposed to be kneeling on someone's neck, and if I didn't have this video camera or there weren't bystanders, or the case of Laquan McDonald in Chicago, I'm going to tell an entirely different story. He's coming towards us. That's why we're shooting him. Well, the body camera footage that was revealed a year later showed a different story, but I'm going to tell the story as long as I can that these officers here did nothing wrong. And the code of silence and this idea that we want to have, because I want my fellow officers to protect me in a situation. So when black officers don't have that same protection, their lives can be endangered as part of the job. So the last thing that I'll say here is, so what solutions do we have? I want to go back here. The first thing that I want to talk about, or just as I conclude here, is we really need organizational reform, right? If you are a police officer and you're working in a corrupt, at worst, or at best, just not under the best conditions, you don't have good supervision, you don't have good discipline, you don't have adequate policies or procedures, then you're going to take on the character of that police department. And that's what we see when we see things like what happened in Memphis. That police department had some institutional problems, and so diversifying it was not going to make it better. It's a very diverse police department. It's not going to make it better if the culture was problematic. So what I think we need is a duty to intervene, but it has to be more than an internal policy. We have to have actual laws, and we have to have discipline for those who fail to intervene. But this is much easier said than done, because I don't think that we have adequate whistleblower protection for police officers who do want to do the right thing. And another thing I'll say is that typically, and I've been working in a world of police accountability for a long time, but it's usually 5%, there was, at least in Chicago at one point, there was 5% of officers that were responsible for 95% of the complaints. And so, and when you think about crime fighting, a lot of times the police chiefs will tell you, well, it's the same thing. We know it's not everybody in this neighborhood. We're going to stop and frisk everybody in this neighborhood, but it's not everybody in this neighborhood. It's 5% of the people who are causing the most trouble. So that's why it's so important to find out who those officers are and make sure that there's adequate supervision, discipline, accountability for those officers, changes the culture. And yes, so there's a recent North Carolina law, again, establishing a duty to intervene and report. There've been there's some progress. There's been some thoughts at the federal level. It was in the George Floyd Justice and Policing Act, which of course passed the House, not the Senate. So we can think about that, but it's really legal formalism versus do these laws adequately reflect our modern policing? And I'm done. Right.
All right, there we are. Okay. Hi. I'm not a professor, so I'm not. My presentation is going to, be slightly less erudite than the distinguished folks who came before me. And I'm also not going to talk about policing as policing. I'm going to talk about voting, and you wonder kind of what is the connection here. But in Virginia, those things are very, very deeply connected because Virginia's criminal legal system imposes consequences on people who would vote. And so I'm going to talk about the history of that and the design, and that it really is by design. William Faulkner famously said, "The past isn't dead, it's not even past." And I would argue that it's hard to find a place where that's more true than in Virginia's Constitution, because we like to hold on to things and we make it very hard to change our Constitution. So I'm going to talk about the way that policing and our criminal legal system keeps people from voting and affects our electoral system. So we're going to go back to the Civil War and the aftermath of the Civil War, and the history of disenfranchisement of black people in Virginia. Before the Civil War, as I think we all know, only white men who owned property could vote until 1851. In 1865, we had the 13th Amendment, which importantly says that neither slavery nor involuntary servitude, a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So that's a very important provision. That is that slavery and involuntary servitude can exist in certain circumstances. Obviously, the 15th Amendment, the right to vote, was not denied by race. After the Civil War, there was a period of very robust voting by black men in Virginia. And all of this is about men, of course, because women were not voting at all. Black men were very active in the Constitutional Convention chaired by Judge Underwood. The Underwood Constitution institutionalized the right of black men over 21 to vote. And Virginia had very successful voting by black men over the age of 21 for a fairly brief period of time. In 1876, the state constitution was amended, and here we came to rely upon the criminal justice system, the criminal legal system, as a way to keep people from voting. So the Constitution was amended to disqualify voters who were convicted of petty larceny and felonies. The General Assembly also required that courts send a list of convicted people to the registrars. At that time, the poll tax was also imposed. Overwhelmingly, the people who were disenfranchised as a result of this were black men, although there were a number of white men who were also disenfranchised as a result. By the 1890s, a large proportion of black men and thousands of white Republicans were effectively disenfranchised. And this brings us to 1902 and the Constitution of 1902, because the Constitution of 1902 included a provision to disenfranchise people convicted of felonies, a provision that remains in our Constitution today despite many, many other revisions to our Constitution. And the 1902 Constitution and its process could not have been more clear that the purpose was to keep black men from voting, right? They literally used the phrase purifying the ballot box. And Carter Glass, who is from Lynchburg, drafted the voting rights provisions and blatantly acknowledged that the purpose was to disenfranchise black men. The elimination of every Negro voter who can be gotten rid of legally without materially impairing the numerical strength of the white electorate is what he said. That was the stated goal. And there was a wide consensus in this constitutional convention that that was an appropriate goal that should be codified in the Constitution. Discrimination was the purpose, and it was incredibly effective. So Virginia became very quickly the second hardest state in the country in which to vote, and the smallest proportion of adult population participated in elections. So you see this, 90% of black voters were not voting after 1 year after 1902. The racist origin of felony disenfranchisement. I do not believe in universal suffrage. I believe that Negro suffrage has been a curse to the white people and an imminent threat to the Negro. This was part of the discourse that passed this provision and that enshrined it in our Constitution. That remains to this day. So we've had modern changes, lots of modern changes, right? Poll taxes were struck down by the courts. Literacy tests were outlawed by the Voting Rights Act of 1965. But Virginia continues to disenfranchise a large number of voters. Virginia voters, 5% of Virginia voters are disenfranchised. 12% of black Virginia voters are disenfranchised. Virginia is one of only 3 states that still automatically takes away the right to vote upon a felony conviction unless the governor restores it on an individual basis. And of the three, Virginia is the only one that further requires that everyone with a felony conviction to individually petition the governor to restore that right. Still today, despite the efforts of governors in both parties, hundreds of thousands of Virginians are disenfranchised as a result of this constitutional provision. Interestingly, the Virginia Readmission Act of 1870, which I would concede was a law I just knew nothing about until several years ago, actually specifically prohibited Virginia from amending its constitution to deprive any citizen or class of citizens of the right to vote, except as punishment for such crimes that are now felonies at common law. Very interesting. So what were felonies at common law in 1870? There were 9. Murder, manslaughter, arson, burglary, robbery, rape, sodomy, mayhem, and larceny. No drug offenses, right? A huge percentage of the people in our carceral system are there for drug offenses. The ACLU and some fantastic co-counsel filed a lawsuit this past summer actually challenging the disenfranchisement of individuals who were convicted of felonies that were not felonies in 1870. That case, King v. Youngkin, is pending in the federal courts. I thought I had nothing to do with the development of the legal theory, but I think it's brilliant. I think it's incredibly important that we actually talk about why this is enshrined in our law, and I am hopeful that we'll see a good result as a result of this litigation. But what we discovered in kind of putting this litigation together is that overwhelmingly the people who are incarcerated for things that were not felonies at common law in 1870. So a successful result in this case would have a huge impact in our voting system and our criminal justice system. The modern era, Virginia was until recently the second hardest state in which to vote. We've moved up because there were a number of reforms in 2020, 2021, same-day registration, lots of other kinds of reforms that made it easier to vote, and so Virginia has made some progress. Of course, we have not changed the provision in our Constitution because Virginia makes it very hard to change our Constitution. So here's the steps to actually change the law. In 2021, we passed, the General Assembly passed a statute that would have put us on the road to removing this provision from our Constitution. However, Virginia's Constitution can only be amended by passage of a law 2 years in a row, or I guess 2 years with an intervening House of Delegates election. And it has to pass in identical form those 2 years in a row, and then it goes onto the ballot for voters to vote. So it passed in 2021, and it died in 2022 when the Republicans took back control of the House of Delegates. We are moving forward with a proposal again to pass a constitutional amendment. We are working very hard on that, and you really can't see those numbers, can you? In 2025, this coming year, we expect the General Assembly will pass a constitutional amendment that guarantees all Virginians over the age of 18 the right to vote. We expect that to happen. We think there's a good shot at that. Of course, there will be an intervening House of Delegates election, and we'll have a different House of Delegates in 2026. In 2026, the General Assembly would need to pass that statute in identical form again, and then in November of 2026, it would thus go onto the ballot and would need to be voted on by a majority of Virginia's voters. Oh, my people who put my PowerPoint together always make me tell people that they should join the ACLU. So that's my final point. Please become a member of the ACLU. We'd love to have you. So I will end there, and we'll talk about the relationship, I think, between policing and the electoral system. And thank you.
So I'm going to lead us off with some questions, and then in a few minutes we'll be taking questions from the audience. So please think about your questions now, otherwise I'll have to just keep asking. Can everyone hear me okay? So, one question, and I guess the one that I have to ask you all is, why haven't we had more progress considering how much change we've had as a society over the past, let's say, 60, 70 years? So one of the most striking differences between the contemporary landscape and that of Jim Crow Virginia is just demographically. If you look at which individuals hold positions of power in local government, in local police departments, who staffs the ranks of some of these departments in large cities anyway, it looks just unimaginably different than it had in the mid-1960s. And so I think, I don't want to speak for people who are what people thought 60 years ago, but I would imagine that many of them would have assumed that if these changes, which are just go beyond what they could have possibly imagined, had occurred, that life would be a lot better, that the police would treat black people a lot better, and that some of these criminal justice system disparities that we're all familiar with wouldn't be as problematic as they are. So I guess one just broad question is, why haven't we had more change and more progress, given the statistics and the stories that you all have shared with us?
I'll go. So, again, I'm going to cite another book everybody should read in their spare time, law students, sorry. Locking Up Our Own, James Foreman, Jr. So first of all, I mean, as a society, the United States, we're incredibly punitive. Again, that's all borne out in statistics in terms of the numbers of people that we incarcerate. There are a lot of, just the proliferation of crimes, because as Mary said, we started out with 9 felonies, and the over-criminalization, all the substantive crimes. Somebody in here right now is probably committing a crime. You don't even know it. And then federal crimes, right, have also increased as well. So I think that's one thing. I think also, even though we've had an increase in terms of enfranchisement and an agency for communities of color, and there has. So I'll take over the last few years. There's an incredible amount of changes that for decades people have been saying we need to effectuate certain changes in policing, and the Racial Profiling Act, John Conyers in the early 2000s, whenever this law had been proposed 11 or 12 times, it's part of the George Floyd Justice and Policing Act. This has been happening, but I think a large part of it is that if you look at what George Foreman says in Locking Up Our Own, he talks about how a lot of black politicians, they really took on this punitive. For our communities, we don't want to legalize marijuana because it's going to be a gateway drug for other things and cause other problems in our communities. And there were actually folks speaking about Washington, D.C., who didn't want to do that because they were afraid the implications for their community. But it was because when you think about, well, this is my toolbox, and the only tool I have is the criminal justice system, so that's how I'm going to use it. So I think our problem has been that just as a society in general, we're too punitive, and we don't want to think about the other ways. The other piece of that is that we've had some progress and some really at the local levels, lots of good local reforms in policing, and then we hear about the retail thefts and one undocumented migrant commits a horrendous crime, and now it's all undocumented migrants must have. So this is why we have to solve this issue. So it's fear mongering. It kind of goes back, I think, to again, some of it is just blatant racial bias and fear mongering and sound bites. We just we hear one thing and we just want to run with it. And we don't really think about really looking like empirically at what's happening during COVID, when you had less people. In some jurisdictions, there were less people being held in jails because it was a public health crisis. Crimes did not recidivate. So we can look at this and really think about. We have to study it and look at the empirical data, but that's not happening. And we're hearing sound bites, and we're not really studying what's happening or the implications of it.
I'd throw in just a couple of things to supplement. I totally agree with everything Kimmy said. First, we have as a society fundamentally over-conflated policing and public safety. I tend to think that policing has a role to play as part of public safety. But the Venn diagram is like the letter O, or maybe two close O's at the eye doctor where they're almost overlapping, but not quite, right? As a result of that, we have fundamentally underinvested in a broader, overarching public safety infrastructure that doesn't rely on ultimately coercive authority. And I want to emphasize coercive authority because that's the unique capacity of the police in social control. This is not me making this up. A guy named Egon Bittner, who was one of the early police sociologists, identified that there are lots of entities in society that engage in social control, that try and intervene when something that ought not to be happening is, and something has to be done. What makes the police different is the capacity for force. That influences very heavily the culture of policing. In the reform era, the professionalization era of policing, which started about 100 years ago when August Vollmer of the Berkeley Police Department started to say, hey, maybe we should actually provide training, which, novel concept, right? Novel concept. That's the era where we started to see police take on an identity as crime fighters first and foremost. And we fast forward into the 60s and the 70s, and the cultural terminology that we use in policing is a shift from enforcement-oriented crime fighting into more of like the community policing era. But I am increasingly convinced that that is primarily a shift in vocabulary, not a shift in underlying function or form. In fact, it's actually to the opposite. If we look at just one particular data point, and we should be careful about taking any single data point out of context, the International Association of Chiefs of Police issues an award every year, the Officer of the Year Award, and until the 1980s, it was almost always given for what we might call lifetime achievement. Long-time robbery or homicide investigators, entire investigative units that closed out hundreds of cold cases, things like that. Starting in the 1980s and up until last year, all but 2 or 3 officers were awarded Officer of the Year for essentially valor under combat-like conditions, right? Really bad shootouts and the like. Again, that's just one data point, but I think it tells us something about an underlying culture of policing when that is the highest ideal of policing. I don't mean to knock anyone who has gotten that award, because they probably did something extraordinarily difficult. But to say that that's the highest ideal of the profession, I think tells us something about it. I think we also have to recognize that policing in the United States, unlike every other country, or to the extent that we are like other countries, we are more so than any other country, is our hyper-localization. 18,000 police agencies, 12,000 city police departments, 3,000 county sheriffs, and then a mix of state and special jurisdiction agencies. That makes it really tough to change course. Because even if one agency starts changing course, other agencies in that jurisdiction may not, right? Richmond, Henrico, right? Is that right? Well, Virginia's weird because your cities are not part of your counties, but that's a total other thing. And finally, the last thing that I think makes it so hard to change is really this concept of privilege. And I'm going to botch the quotation, so someone please correct me. But there's a quotation that runs something like, the denial of privilege or the reduction of privilege feels like oppression. And when we're talking about policing and the authority that they've had, and we say, okay, well, let's start to do it differently. Let's start to change this. Let's start to not actually have you do these things that we're used to doing. That feels like you don't trust me. You're taking something away from me. I'm being oppressed. You add race and gender with a bunch of dudes who are like me, straight white males. It's a hell of a lot of privilege.
So I just wanted to follow up and change gear just a little bit, because I think to ask why things haven't changed in the voting space, I think that the answer is that for a representative democracy, Virginia is deeply anti-democratic. And that is deliberate, and that is part of our system for a very long time. Not only have we enshrined disenfranchisement into our Constitution, but we make it very hard to change laws and, in lots of other ways. So you see, for example, out in the world, other states are having ballot initiatives to protect reproductive rights. And in other states, you can get citizens of the state to sign, signatures and to put something on the ballot. You can't do that in Virginia because Virginia doesn't believe in that kind of democracy. And we have something called the Dillon Rule that says that localities can't pass laws that they want to pass because they're restricted. And we have a very sorry history of gerrymandering and terribly drawn maps, which now maybe finally we're getting away from, because we have finally in this election maps that were drawn in a nonpartisan way. But I would say that sort of, despite the fact that when we see polling that says that the disenfranchisement is unpopular and that a majority of Virginians want to see change, Virginia makes it very, very hard to do that.
And so I think we have time for one or two audience questions. No. You have time to keep asking questions. Oh. I apologize. I'm going to keep talking. So, I'm used to doing all the talking, but I'll get up. Okay, perfect. So, as I was saying, another question that I really wanted to hear all of you reflect on is a pretty obvious question, and that's, where do we go from here? So, we've talked about the problems that persist. We've talked about how some of this might be deeply entrenched in just how police understand and how society understands the function of policing. We're accustomed to laws that restrict voting access, and it's hard to change them. Where do we go from here in terms of making progress? And I don't want to limit answers or point you in this direction specifically, but I'm also curious especially about what role you see for possible solutions that involve defunding police, or maybe more accurately, reallocating some of their responsibilities and budgets to actors and institutions outside of the justice system, the criminal justice system. So, a broad question. Any of you can take it on.
I'll take a first crack. So a couple of general points. One, I think we need to be very skeptical of adopting technological solutions to sociological problems, right? This is a long-running panacea problem in policing. Pepper spray was supposed to solve the problem of excessive force. Then tasers were supposed to solve the problem of excessive force. Then dash cams were supposed to solve the problem of racial profiling. Body cams, as best as I can determine, were supposed to solve all of the problems. And I guess the question is, like, how's that going, guys? Like, how we doing? So I think we need to think of any solution as almost inherently multifaceted. I think body cams are a good example. Maybe they play a part in the overarching solution, but we need many parts because this is a complicated, multifaceted problem. If it was a problem that was simple to solve, we'd probably have solved it by now. Not to get all economist. You guys know the economist joke of, like, the $50 bill on the floor of the economy department, and everyone just walks by it because if it was real, someone would have picked it up by now, right? I'm not saying we have to go quite that far, but these are complicated issues. So I think we need to think long term. This is really frustrating. I'm not an inherently patient person, and I know, especially in the aftermath of an incident like the murder of George Floyd, or Breonna Taylor, or Tyree Nichols, or Walter Scott, or the names keep going, there is an appropriate demand for fixes tomorrow. But if we look at the history of change in policing or in society generally, I tend to think that there is more lasting change when we look for incremental institutional reforms, and it's damn frustrating to go 3 steps forward, 2 steps back. But in 5 years, that's a couple of steps in the right direction, at least, in a way that maybe it's not if we rush into something. We also have some examples of police departments that have rushed real hard into reforms and then gone exactly 2 steps forward, 7 steps back, right? So we need to be aware of that and think long term. It's tough to counsel law students, particularly, to be institutional incrementalists, though. It does not come naturally to me, or I think many of us. And I think we need to rethink the function of policing, right? Maybe not the social control component, because I think that's always going to be a part of it, but somewhere at the intersection of form and function, why do we have police engaging in, for example, traffic stops? When we have good empirical evidence that there are only a couple of types of stops, a couple of traffic violations that actually have a statistically significant impact on public safety. Reckless driving and DUI. So speeding violations, equipment violations, a bunch of other violations really don't affect public safety. Do we need police to be doing that? Do we need to have criminal traffic violations the way that most states, well, at this point I think it's just over half that have decriminalized, but there are still a lot of states that have criminal traffic violations. Do we need police responding to mental health calls? Do we need police responding to non-violent, non-criminal domestic disputes? There are ways to answer that yes. I'm not going to engage in them. I just think that's the type of conversation that I think we need to have. Do we need police, or maybe can we reallocate our public service infrastructure, our public safety infrastructure, and develop an alternative? But that is not something that I think we can do by next year. It's going to take a while to develop the entities, the individuals, the infrastructure to do that. And one more point that I want to make on that, it will make the police proportionally more violent. If we still have police, and they are smaller agencies who respond to a smaller portfolio of incidents, those that are more likely to involve crime and arrest, then the use of force rates will go from somewhere in the 1% range of threats and use of force to something higher than that. That might be fine because we're going to reduce an absolute number, but it's part of the conversation that we should be having.
Agree with everything Seth said, as usual, but a couple things. I'm really glad he mentioned the law enforcement and technology, because that's something that, again, it's probably one of those on the menu for reform. If we have less contact between residents and police, then we will necessarily have less violent interactions. I am a proponent of law enforcement and technology because technology improves our lives in so many different ways. Why not with public safety? However, and it's a big however, as in, again, all aspects of our lives, there are costs and benefits associated with that, and actually I think it was Rachel mentioned in her presentation, the distribution of privacy rights. And I always use myself as an example. Where I live is kind of out in the middle of nowhere, very protected. I enjoy much more privacy to do whatever I want in my backyard, rather my kids do. It's an issue, to do more there than somebody who lives in an urban area, an apartment building, closer. So we have to think about that. And with law enforcement and technology, I really worry about the over surveillance of communities of color, and our our cities have not always been very forthcoming with. We're going to have an aerial surveillance program, Baltimore, we're going to capture drone footage of your every move and then tell you about it later. The last thing I'll say is, I also think that we really need to think about, so I am not in favor of, I won't say the defund, reallocate, those are kind of loaded terms, but I do believe that there are functions that police officers should do in terms of, I work on gun violence prevention as well, and so I don't know what we need to do with police budgets. We probably definitely need to reallocate and look at that, but we absolutely need to invest in our communities and in our young people, because gun violence and those types of things, it's real when your son or your daughter is killed in that way. And we need to invest in our communities, because it is the hopelessness and the lack of jobs and education and nutrition, all of that is driving violence. And so it's not that people are inherently violent, but we need to invest in our communities.
And so are we out of... Okay. I can add in other questions or open it up now? Yeah.
We're going to go ahead and open up questions for the audience. We have about 10 minutes. Sorry for the confusion. We just were kind of modifying our timeline.
Thank you all so much. I have a question. Have any of the panelists given any thought to the implications of private police departments and the lack of sort of public accountability for what they do? And I ask because in Virginia, about 10 years ago, the General Assembly recognized the existence of about half a dozen private police departments, most of whom had come about as homeowners associations who had taken advantage of a state program that still exists that basically allowed them to hire special conservators of the peace, which are basically residents who have gone to 40 hours of training and are authorized to make arrests and use deadly force for those arrests. And so, as much as the police forces we're talking about so far have some type of public accountability, it's the private police departments that I think could cause some greater concern because they are private corporations.
Yeah, so I love this question. I wrote an article a few years ago that took this idea of the police as the thin blue line, right? And the article is called The Blurred Blue Line because it's about public and private policing. And what I do in the article is kind of what I try to do in the talk is say, look, if we define policing more broadly than institution, if we look at the function of policing, there are actually a lot of private agencies, private institutions, and explicit private police forces, right? So Tennessee has the Briarwood Presbyterian Church Police Department. It is a private church with its own police department. FedEx, anyone ever ship anything by FedEx? There is a FedEx police department authorized by Tennessee law. They wanted to be at the table with the feds when they were doing like international counterterrorism type conversations, so they created a police department. There's a private hospital system near where I live that has its own police department. And I have tried getting public records documents from them, and their response is some formal equivalent of, fuck off, we're not public. And it's really frustrating, right? So, yes, I actually think that's hugely important. There are also public officers who are working in private police capacities. St. Louis does this, for example. And the mix of public and private money in St. Louis, the police chief has a city salary of $175,000 and gets another $100,000 from the Private Police Foundation, which is primarily funded by the downtown business community in St. Louis, right? So the idea of private influence and the full-on existence of private police departments, I think, is something to think about, especially as we think about shrinking or defunding or changing the footprint of policing, because neighborhoods like the one I live in now will just create private police forces, leaving neighborhoods like the one I grew up in without access to police services that they might otherwise want. Maybe not, different discussion. But yeah, I actually think it's a really, really important question.
Right here. Good afternoon. So my question is somewhat on the same lines as hers. It's about accountability. And I think the question for me comes to, if we change the form, the function, the practices, and the policies, but we retain our current accountability model for police, which is essentially beat, kill, maim, do what you want, and your worst case scenario is to be fired and look for a new job, will we ever get a change? And if not, why are we not focusing more energy on accountability and less energy on trying to dress up their practices in their ways, as opposed to just saying, you need to go to jail for what you did?
I agree with you, and that's why there's been a lot of emphasis because again, it's technology that's allowed the world to see what many Black communities knew for decades, that police were treating them differently and more harshly, and so we see that, and then there's this call for these officers need to be criminally prosecuted, and again, it's interesting because as a nation, at some point, we're saying, well, we need to have less crimes and less criminals, but we want to reserve it for some of the officers, which again may or may not be the right thing to do. I tend to think that again, you can have criminal accountability, but there are all other kinds of accountability that you can have. But we haven't tort law that really has these wrongful death. Municipal liability really hasn't been a great thing. So I think I have always hung my hat on it. And Seth said this earlier. I look at it as, you can look at it as a toolbox or Swiss Army knife or whatever analogy. There are a lot of different things that we can do, and we need to keep everything in the arsenal. There is a place for criminal prosecution. There's a place for municipal liability. But I think the greatest thing that we could do is, if we're going to have police departments in the form that we're going to have them for the foreseeable future, we really need to think about the organizational culture and making sure there are police departments here that they can get millions of dollars for body cameras and then have no rules as to how they are going to implement the use of that. And that shouldn't be. They can get, and again, Obama tried to sign an executive order about it, but you can have lots of the surplus military equipment because, Williamsburg needs a tank, and then no rules on how to use it. So I think it's organizational reform, and I also think that we need to look at, this goes a little bit less to accountability, but we need to look at who we're hiring. Again, we're asking police officers to do all of these functions, and some police officers are going to be really good on the SWAT team, gang, whatever intervention, and then other officers may would better be used in other capacities. But we need to look at who we're hiring and again how they're being trained, but that's a whole other conversation because we're not going to train our way out of the persistent bias and violence that we're seeing.
We're just going to fit in one last question. I believe a gentleman had his hand raised.
So with respect to the private police departments, I'm going to make the suggestion that has been an improvement over the situation where you had special conservators of the peace, simply because those officers now have to go through a police academy and be fully qualified, and they can be decertified, whereas the special conservators of the peace had very little supervision. But I'm in agreement with some of the suggestions about what needs to be in some agencies a culture change, and there are some political solutions to this that don't necessarily look like spending a lot of money or mandates from above, but fewer than half of the police agencies in the Commonwealth of Virginia have accreditation. So accreditation is not the be-all and end-all, but it can be a starting point for an agency to develop a more accountable culture. And so, your elected representatives, they have a role in hiring the police chief. There's a little less you can do about a sheriff because he's directly elected. But if your county board of supervisors, hires the next police chief and says, one of your tasks is going to be to achieve agency accreditation within the next 4 years, that doesn't seem like a big ask for somebody who's seeking out that responsibility.
What I really like about that comment is the emphasis on what I would refer to as systems design or systems thinking. How do we develop a system? And I think we can think of systems at multiple levels, right? The system within the police department that is most likely to get the results that we want. But the accountability comment is the same thing. How do we develop a broader system, a legal and administrative accountability system that is most likely to get us the solutions that we want, right? The actions that we want and avoid the stuff that we don't want. Right now, we have a lot of holes in our administrative and our legal accountability systems for police. Some of them were maybe unintentional artifacts that have developed over time. Some of them are very intentional. And that's a bit of a problem.
All right, I think that leaves us just at time. So everyone please join me in thanking our panel once more. We are going to take about a 4-minute break before our next presenter, Professor Laroche, begins.
No, you're good. All right, good afternoon, everyone. My name is Samantha Owens, and I am the Senior Notes and Comments Editor for the University of Richmond Law Review. And this afternoon, I have the pleasure of introducing Professor Carla Laroche. Professor Laroche recently joined the faculty of Tulane Law as the Felder-Fayard Associate Professor of Law, where she specializes in criminal law and the prison industrial complex. Previously, she taught at Washington and Lee University School of Law, where she founded the Civil Rights and Racial Justice Clinic. Her most recent publications include Black Women and Voter Suppression in the Boston University Law Review and The New Jim and Jane Crow Intersect, Challenges to Defending the Parental Rights of Mothers During Incarceration, in the Columbia Journal of Race and Law. Please join me in welcoming her.
Can you hear me? Oh, yeah. Okay. Good afternoon. Good afternoon. Good afternoon. People up there, hello. Thank you for attending my discussion of Black women's voter emancipation in slavery's afterlife. I am honored to be here. This symposium has been lovely. Shout out to Zoe and the whole team for putting this all together, and it's been so organized. I've also have little reminders to myself to give people shout outs because throughout this symposium, people have said things that you will either see on my slides or I have been thinking about incorporating into my work on this piece. I am hoping to submit this article within the next week, and so I do welcome your feedback, your questions, comments, concerns, and of course your compliments. I will take that too, right? So I start with Pamela Moses. Pamela Moses is one of the co-founders of Black Lives Matter in Tennessee. She had a desire to represent her community and sought to run for mayor in Memphis, Tennessee. She filed her paperwork, got the requirements, filed her paperwork with the elections office, and the elections office said, no, you're not eligible to vote. You are still on probation. Pamela Moses, used to the bureaucracy and mismanagement of records, says, no, I'm done with my probation. Y'all are complicating things for no reason. I'm going to go to my judge, to the judge of my presiding case, the most recent case. The judge says, you are under probation. She says, that is incorrect. I'm going to go directly to probation and get a certificate from probation indicating that I can vote. Tennessee has a very complicated, what I call disenfranchisement maze in order to restore your vote. You can go to your court, the judge, and get a certificate saying you are eligible to vote, you've met the certificate, the requirements. You can go to probation and get the certificate. Depending on when you were convicted of your crime and what type of crime you were convicted, you could either be eligible immediately or have to go through this maze. And Ms. Moses goes through the maze, goes to probation, gives the form to the probation officer. The officer goes back to his desk, does his work, says she is eligible, signs the paperwork indicating she can vote. She files that paperwork with the office, and a few months later, she is convicted of voter fraud, registering to vote illegally, and sentenced to 6 years in prison. She indicates that she did not know she was ineligible to vote. The court, during her sentencing, she was held for between 80 and 90 days pending sentencing hearing. At the hearing, she testifies on her own behalf and says, I did not know I was ineligible. The video that is on YouTube from a news channel indicates that the judge yelled at her, you tricked probation, with no evidence. Simply, you tricked probation, and because of your actions, you were going to be sentenced. You must serve 6 years. If with good behavior, you might serve less, but you are going to serve prison time. A Guardian reporter becomes interested in this case. It goes viral because it seems unfair that someone who legitimately did not know she was ineligible to vote would get 6 years. The Guardian reporter does a FOIA request and receives all this paperwork, including email exchange that includes the internal investigation of probation that says very expressly and explicitly that it was the probation officer's fault. Ms. Moses the whole time was in the lobby, and he missed a step in the process to confirm that she was ineligible to vote. She still had a few months left. That was never turned over before the trial, and so that was the first time through this FOIA request that her defense attorney and Ms. Moses learned that this information existed. Based on that and some other material evidence, they file a motion for a new trial. The judge immediately grants it. The judge, who blames her for tricking probation, says, essentially, my bad, you were right. Ms. Moses is freed. She then proactively files an affirmative litigation malicious prosecution against the former DA, who lost her position, and the new DA, who was a former Memphis Law School professor and now is DA of Memphis. When the DA found out about this evidence, she said, just to be clear, that was in my office, about the email, and it was Ms. Moses' fault for not pleading guilty to a misdemeanor in the first place. And that the time served between conviction and sentencing was enough punishment, and so the office would not recharge her. Ms. Moses, with all of that information, files this malicious prosecution lawsuit. It was dismissed. She has recently, in the past month, filed an appeal, and she sought to file it without paying the filing fee. That was denied. And so she's still trying to get justice in terms of the fact that she wanted to hold other people accountable. She wanted to be in a position of running for office. They told her no, she does not have the right to, and then punished her for
trying to access the same rights that everybody else has. And so my thesis in doing this, in talking about Ms. Moses and talking about voting and talking about seeking access to things that people without convictions can access more easily, is that for Black women like Ms. Moses, there is a shadow of slavery's afterlife that keeps them unable to vote, unable to access, again, the same things that other people can. And so I talk about how Ms. Moses is the same shadow of Harriet Tubman. Harriet Tubman was known as Moses of her people. And so she's somebody who used the Underground Railroad to get to freedom and then turned back around and led other people to freedom. She was making a larger impact. For my piece, I talk about the afterlife of slavery, which is a term, a concept that Saidiya Hartman coined to talk about the shadow, that the ideas of slavery, the emancipation that was supposed to occur, was a non-event. Just like the release of individuals from incarceration, and post-punishment imposed on them is simply a non-event. There's simply too many consequences to that conviction for there not to be this afterlife and how it's connected in so many ways. And so in my first part, as you see up there, I talk about slavery for Black women and its afterlife. I will talk about the resistance, not only Ms. Moses, but other individuals, other women, Black women, who are resisting in different forms, whether that was in slavery and now in our afterlife of slavery. And then some ideas of how do we get towards this voter emancipation, this true emancipation that was promised so long ago, and yet we are still in its afterlife. So talked about how Ms. Moses could not vote. And how Tennessee has this winding disenfranchisement maze that is not only in Tennessee, but in jurisdictions across the nation. And it's called, as you know it, felony disenfranchisement. In certain states, one can be disenfranchised with a misdemeanor, right? And so there's already this incorrect conception of what this disenfranchisement is. I know disenfranchisement means what it means, but when I was starting to learn this information, I didn't understand what disenfranchisement meant, right? It's a big word that has such power, and so I decided, why not call it what we know? It is voter exclusion based on somebody's conviction. And so that is what I've started to call it, instead of felony disenfranchisement, because it also implies that it's only you're starting off with what a person did before to continue their exclusion from society with using felony disenfranchisement. So this voter exclusion depends on what state you're in, whether you can vote immediately in Vermont and Maine, DC, Puerto Rico, or you must wait until you're released from incarceration. In certain states, like New York, that is the case, or you're in Tennessee, where, again, depending on the year and your offense, you can vote immediately, you must wait, you must go through the maze. In Florida, there is Amendment 4 that was passed in I should know this because I worked on this, 2017, no, it's not 2017, it was 2018, there we go, passed a state amendment led by the Florida Rights Restoration Coalition, state constitutional amendment that was supposed to give people the automatic right to vote. It was huge. Passed overwhelmingly, surprisingly, way more voters supported it than expected. And then the legislature came in and said, it says, once you've completed your incarceration and your probation and parole, we're adding the requirement that you must include you must pay your fines, fees, and restitution. And that completely complicated the process. I used to run a clinic, a gender and family justice clinic at Florida State University, and I created this project, the Cloud of Consequences Project, where we wrote a Supreme Court brief to the Florida Supreme Court to indicate how reading the requirement for financial obligations also harms families, and connected that to the history of exclusion of families, especially black families. We also did individual cases, and my students would come to me and say, we're really smart, we know how to do legal research, we have no idea how much this person owes. Right? And so there's this maze that is still continuing, even if the words are simple. So, Mary, in her presentation, included the words of Carla Glass, and I also include them, but it's because of the ACLU case that I'm aware of Virginia's wording. It was not only Virginia, it was across the South, where states would have these conventions, these constitutional conventions, and be explicit about what they were doing. Trying to exclude black men at that time, women could not vote, so exclude black men from the vote. It wasn't until 1974 in Richardson versus Ramirez, which the Supreme Court took up this issue and noted that the ability of the states to ban people with felony convictions was not a violation of the 14th Amendment. And they looked at Section 2 of the 14th Amendment, where it says that states, how they read it was that states could deny people the right to vote, and it would not violate the 14th Amendment. Because the 14th Amendment says if the person participated in rebellion or other crime. And so they use the language of other crime to mean you can exclude somebody for that. You can exclude somebody from voting, and it would not violate this constitutional amendment. Okay. In my most recent publication, Black Women and Voter Suppression, I argue that the voter exclusion based on criminal convictions is another way of excluding black women. And so I start with the United States inception and how black women couldn't vote, and then Civil War happens, we get the right to vote, but only for men. The 19th Amendment happens, black women were excluded at every step, even though they were working towards it and expected, once the 19th Amendment passed, that they could vote. That was not the case with Jim Crow, and so we see the Civil Rights Movement, where women were part of the movement and sought the right to vote, and at so many steps they were excluded from either leadership or from the publicity and recognition for the work that they did. And then we had mass incarceration where black men were put into cages, and so black women were voting. Now we see that the highest rate of incarceration of individuals is black women. Let's see, I have a slide on that, so let me skip to that as I'm talking about it and go back. And so recently the number of black women has decreased in incarceration, but it's still higher, and it's still disproportionate to their actual rate in the United States, the proportion in the United States. I'm gonna go here. And so, as a result of that, black families are disconnected from access to policy, or access to laws, access to systems. They are excluded from citizenship or participation in the political process. And my recommendation there is to abolish the voter exclusion, right? But also to recognize intersectionality. I focus on this federal case that was part of the lawsuits to seek to eliminate the requirement that Florida imposed about the fines, fees, and restitutions. Rosemary McCoy and Sheila Singleton filed a lawsuit on behalf of women of color who had convictions who could not afford these legal financial obligations. They indicate, and the data shows that women of color, especially black women who have felonies, do not have the same access to income, to jobs, as other individuals. And so they make an intersectionality argument about the harm that this will cause, and say it's a violation of the 19th Amendment. The trial court found that the law in Florida requiring legal fines and legal financial obligations was a poll tax, but then said to the argument about the intersectionality argument that because there were more men in the system, the impact is actually greater on men than women. Even though the data and the experts showed that financially, which is what we're talking about, women of color, especially black women, did not have the same wealth. And so he was looking at the numbers as opposed to the actual impact. When the case went to the 11th Circuit, they held that the legal financial obligation was not a poll tax, and also, no, we're not going to talk, we're not convinced by the intersectionality argument in the 19th Amendment. In my piece and my argument, I talk about the slavery aspect, the gendered and racial targeting of black women during slavery. Y'all have probably heard about the Dred Scott case, but more than likely have not heard about a case that came out 2 years later, United States v. Amy, in which the same architect of Dred Scott, Chief Justice Taney, also heard this case. He was riding circuit, because at that time the justices would ride the actual circuit, and in Virginia, he heard this case. Amy was an enslaved woman who stole federal mail, and they wanted to incarcerate her, convict her and incarcerate her for doing so. Her attorney argued, if you incarcerate her, United States, that is a takings under the Fifth Amendment. Taney says, yes, black people are property. However, they are humans in terms of punishment. So we can punish them. They're legal humans for that aspect. So they have two statuses. They have the property for profit and people for punishment. And so Hartman talks about this, where they only recognize slaves' free will when it's in terms of the criminal legal system and not their actual humanity. I kept wondering, because I kept reading these cases about enslaved individuals, especially black women, which is what I work on. How did Amy have an attorney? Right? Like, this was before Gideon and the requirement for individuals to have attorneys if they can afford it. And so through my research and through a lot of the article by Higginbotham and Jacobs, it comes out that Virginia had a law in the 1700s that required slave owners to pay, either to pay or to represent the enslaved person so that they could ensure that their property was protected. So attorneys were part of the continuation of black people as property because they were representing the enslaved person for the profit of their owner. They wanted to make sure that the owner got their money. That's why it's a takings issue. In other cases where black women have killed their slave owners, the attorney would also talk about the value of the black woman because the jury would find a capital offense conviction, but also include a number. And that number was what the estate was owed by the state because they were killing the enslaved person. And so attorney was not protecting their rights and their arguments, but protecting their amount, their property value. So I make the argument that black women were experienced gendered racial violence during slavery, and then I come into today. I have often gotten the question, like the judge indicated in that case, why black women? Since there's so many more black men who are incarcerated, why focus on black women? For one, the idea that I can only talk about something if it's enough of a harm to certain people and what that charge, what that amount is, I reject. But also, there are many reasons why black women. We have so many narratives about black women, angry black women, Mammy, Jezebel, right? These horrible and incorrect narratives and caricatures of black women. But we also have the data which I showed you here, where, well, first I'll just say, Hartman asked, like, what does it mean to exist between no longer enslaved and not yet free? And for black women, that is a thing when they're still incarcerated at higher rates. When, even if they're not incarcerated, there's over 1 million women who are under probation. And so for many states, if you're still under probation, you cannot vote. But there's also this idea of black women trying to access rights for their families, for their communities, and being denied simply because they sought the same rights as everybody else. The idea that a black woman who I talked about were for profit or for punishment, seeking the same justice system for justice, were denied. And so we have the requirement of the hashtag Say Her Name because of the lack of recognition of black women who were harmed by police violence. We often, Kimberly Crenshaw has a TED Talk on this where she says the name of black women who have been killed by the police and asks people to keep standing if they know the name. And by probably the fourth person or fifth person, a woman, most of the audience is sitting, right? But we know the names of black men. There are more black men, but there are also black women who are also being harmed, that are being harmed. And so part of the reason why black women is because less and less people are talking about that, but expecting black women to fight for justice. In Black Women Versus Oppression, I talk about how in 2020, the media talked about black women saving democracy and showing up. And so to Professor Ross's discussion about like, what are the choices? Do black women sit out? Do they say we're gonna vote for somebody else? Especially when the narrative has been more towards men, what do black women do? I move on to resistance in slavery. And so the way that I just define resistance is the way Hartman does. It is not simply out and loud. It can be like everyday practices. And so someone who is enslaved, the black woman who is enslaved, who slows down their work in the field. That is resistance. Someone who refuses to heat up the bath for their slave owner and they go in cold. They have to go into cold water. That is resistance because they're simply trying to recognize that we have some agency, some control over this social exclusion, and this is how we're going to do it. The other idea is death, right? Like, either I die because I can no longer take this control, this racism, this gender, this sexism, this exclusion, or I kill my owner. And so there are stories of black women killing those who try to own them. There are also, Rebecca Hall has a graphic novel that talks about black women who are engaged in slave revolts because there's very little narrative about, and there's assumptions that black women did not engage in slave revolts. And so the erasure of that resistance is also erasure of black women's history. Here, next, I go into the afterlife today. So here we have Miss Mason in Tennessee. Miss Mason had been convicted of, I believe, of fraud in federal court, had served her sentence, had been released, and she had promised her mother that she would vote in the 2016 election. She had gotten released a few months before. So she went to her polling place and tried to vote. Her name was not on the rolls, and so she said, I will vote provisionally. It turns out that Ms. Mason, because she was still on federal probation, just like Ms. Moses, with probation, she was ineligible to vote, and so her vote was not counted, And yet in 2018, the prosecutor filed a voter fraud case against her. And the language of the statute reads, a person commits an offense if the person votes or attempts to vote in an election in which the person knows the person is not eligible to vote. Ms. Mason did not know she was ineligible to vote. In a bench trial that lasted a few hours, the judge found her guilty of voting while ineligible. Recently, I presented the same language to my students in crim law as we learned about mens rea. And as you know, the assumption is there is a requirement, a mens rea requirement at every step. And so they put in a knowing requirement at the beginning of a person commits an offense if the person knowingly votes without any knowledge of this case. The court said, however, that the knowing requirement was only if she knew she was on probation, not that she knew that her being on probation made her ineligible to vote. The judge then convicted her and then sentenced her to 5 years in prison. It went up to appeal, and then the Second Court of Appeals in County in 2020. So she voted in 2016. In 2020, they affirmed the trial court. In 2021, Texas changes this statute and says that it needs to be exactly what my students did. Person knowingly or intentionally votes, right? All of the information indicates that they did this because of Miss Mason, because her story went viral. During the hearings for this case, for the modification, they talk about Miss Mason. They even add another provision to the statute that says if you vote provisionally, it is not automatic. That is not enough for a conviction. So her vote didn't count. She didn't know she was ineligible, and she got convicted. So that was in 2021 when the Texas legislature changed the law. In 2022, the highest court, criminal court in Texas says, no. Because the Texas legislature made the change retroactive, it applies to Ms. Mason, but that provisional ballot protection doesn't actually apply for her. It's not enough. As they were recognizing that the legislature did this for her. But they do say the appellate court got it wrong. There is a knowing requirement. There is a mens rea. It is not enough to say that she knew she was ineligible, not enough to know that she was on probation. The government needs to prove that she intended to violate the statute. Went back to the appellate court in 2023, last year, April. There was an oral argument on this case again. We are now in 2024. She voted in 2016. And she, at any point, can get a phone call finding out whether she has to serve for 5 years, leave her family, or she's free from cage and capture. Ms. Mason had said, had she known that she was going to be away from her kids again, she never would have voted. And yet, she has also said that because of this process, she has leaned more into the idea of voting and the need to resist this exclusion of individuals from the ballot box. So what does Ms. Moses and Ms. Mason's cases mean? What are the implications? Ms. Moses is clear. She's unapologetically trying to get the state to recognize that they're not doing enough. She recently filed for her campaign to run for U.S. Congress, or for Senate. She is now eligible, and she's like, you will hear me. I represent the community. I am here. I am not going away. So we have that type of resistance. People have asked whether Ms. Mason's case is also resistance, and I say yes. Her desire to simply say to the courts, get this right. There are examples of individuals who knowingly voted twice, cheated in terms of fake signatures for their own campaigns, who've gotten probation, who've gotten 180 days. One of them in her own county the year before she voted. A woman pled guilty to having her son impersonate his father and try to vote. But the father had already voted, and so they saw that there was something going on. She received an alternate to incarceration sentence the year before Ms. Mason. And so her resistance is, I am here and I'm not going away. I could have pled like Ms. Moses's DA wanted her to plead, but I'm not at this point. I recognize that I'm going to be risking not seeing my family for 5 years if I don't. So the court, I didn't say this, the court allowed her pending sentence to be released, and so she served some time, but has been waiting for a final decision. And so she is taking care of her family and her brother's family at the same time. And so she's saying, I will not be captured. I want you to do what you have done for these other people, and until you actually admit and reckon with that, I'm going to be here. That is resistance. And the other implication is, what is the harm? What was the danger of Ms. Moses and Ms. Mason when they didn't even know they were ineligible? Besides the fact of trying to target Black women for the right to vote, and the idea of expressing their community voice or their community perspective through the ballot box. Some might say there is this risk of voter fraud, but that doesn't play out with the examples I gave you, because those individuals were all white. And Ms. Mason and Ms. Moses were Black and trying to get the community voice out there, perspective out there. And then I talk about allyship, right? So there was this podcast branded that came out last fall that follows a individual, and the podcast mentioned these two individuals. Virginia Senator Yvonne Miller, who was the first Black person to serve in the Virginia's General Assembly. And she was elected in 1983 into the House of Delegates, and then in 1987 to the Senate. First Black woman in both houses, in both chambers. Every year, she would introduce a bill or introduce something to change Virginia's constitution to allow people to vote. Senator Mamie Locke, and she's in Hampton. When she came into the General Assembly in the General Assembly in 2004, and when Senator Miller died in 2012, Locke has taken up the charge and filed a process. I think it's a bill. I don't remember that part, but like to change the legislature every single year. Black women who they don't have felony convictions, and yet they are stepping up and saying, we have solidarity, we think this is wrong. Right. So what does the afterlife look like when there is reform? So part of the argument that I make in Black Women and Voter Suppression and here is the continuation of my argument that we should abolish this, not only for people who are released, but for people who are incarcerated. They're still part of the community. Their vote and their decisions and their experience, as Ms. Moses keeps indicating, matters for the community. There are other issues simply from a direct point of view, directly address Ms. Mason and Ms. Moses' case, that the state needs to prove that they gave proper notice in the first place. The assumption that one should just automatically know how to figure out the disenfranchisement maze seems incorrect when there's so many steps to the maze. And unless somebody has an advocate or a lawyer going through the process with them, like my law students, they'll say, I don't feel comfortable telling them this person any number because I don't know. And so giving proper notice, showing that they knew what was going on, and then still voted. It's easy to prove that somebody voted twice. And we all know we can't vote twice. We don't know in what state we're in whether you can vote automatically or have to go through the maze. In terms of the legal representation and voter advocacy, when I think of Amy and that question of how did she have a lawyer and where did this lawyer come from, I also think about the cases where lawyers step in and represent individuals pro bono in these cases. And so thinking about the public interest lawyer piece is increasing the amount of people who represent individuals, especially Black women in this argument, on these matters. It is not stopping the system, but it's supporting those who we know are being targeted for what they represent and not actually what they did. And then let's see. I have gotten this question in terms of what would have happened if Ms. Moses and Ms. Mason could have voted, right? What would that look like in terms of the change? If they could vote, they would still be in the afterlife. They would still be in the shadow and still have to deal with the consequences of a felony conviction on their record. And so I recognize that the true voter emancipation is one that requires the addressing of the afterlife in the first place. So true voter emancipation is really a manumission, the release from enslavement altogether. And that won't happen only by allowing somebody to vote. It's a larger question, a larger opportunity to talk about what is the afterlife in this country and what we can do to get there. I thank you all for sticking with me, and I really welcome questions and comments, and again, compliments.
All right, so we will now have some Q&A, if anyone is ready.
Hi, I was a very eager beaver. So we learn in crim law, like in our 1L year, that there are different theories to justify criminal law. And one is deterrence and one is punishment. And the theory, as I understand it, is that the time you get in prison is your punishment, and that's it. But to me, the idea of voter exclusion and felon disenfranchisement is an additional punishment. And so I was wondering if you could talk about that.
Yeah. That is in flux. So I didn't mention there's this federal case out in the Fifth Circuit in Mississippi, Hopkins, where the 3-judge panel indicated that, or the Hopkins plaintiffs argued that voter exclusion in Mississippi, the permanent termination of one's ability to vote unless you have like 2/3 of both chambers to allow you to restore your voting rights, violated the 8th Amendment. And so they've made that, and the court has said it doesn't violate the 14th, but let's look at the 8th. The 3-judge panel said, no, we agree. That is punishment. And that came out in July or August of this past year. Recently, there was a en banc hearing on that decision, and in listening to the oral arguments, it sounds like the Fifth is going to reverse the panel. And so I agree that so many of the consequences to incarceration are punishment and not really about a civil aspect, which is what the court has indicated really, is that this is not punishment. This is a civil issue, and so we don't have to worry about the 8th. And Hopkins, when it first came out, that decision, so many of us were surprised by it. Because people have been thinking that, and been arguing, this is punishment. This is punishment. We weren't expecting it from the 5th. But even to your deterrence argument for criminal law, the question becomes deterring whom? This idea of de facto disenfranchisement is that people who are eligible to vote do not vote for fear that they were wrong and have the same type of situation as Moses and Mason. And so then you're excluding people from the ballot box by saying, do you want to be like them? Are you sure you can vote? I will not vote. And so the deterrence is not for violating the crime, it's for you to actually vote.
So thank you for speaking with us today. So at the beginning of your talk, you pointed out the case where with Amy, and when you spoke about how, it kind of like highlighted how at the time a black person in the United States was either a property or a human for punishment, and that really like captured my imagination when you talked about the first woman whose name was Moses, and how in 2020 there was this kind of sense that black women are going to save democracy, and then we have examples of women who are trying to vote, and the result is punishment. I guess my question is, I think I lost it. I actually think I lost the question. I'm so sorry.
I mean, I told you I accept compliments too.
Yeah,
So
no, so great, excellent. I love that you set that up. Great.
Thank you. Thank you.
Oh, yeah. A quick question. You spoke about attacking these particular, whether they're parts of a state constitution or statutory, based on 8th Amendment or 13th, 14th, 15th Amendment arguments. Given that political speech ranks as one of the highest First Amendment protected rights we supposedly have in this country, has there been any strategy or has that approach been taken at either the appellate level or state court regarding First Amendment protected speech as ability to cast a vote?
I haven't researched that piece yet, but I know people have made the argument. But I'm not sure if they've made it in cases. I know people have made it in law review articles and in scholarship. But that is part of the argument. It's like, this is political speech, and so you are excluding it. But then we go back to the 14th Amendment that says, for other crimes, we can exclude the vote, or how the Supreme Court has interpreted other crimes in this case. And so even though we have the first, the 14th came and said, if you exclude person's right to vote because of other crimes, that is not violating the political speech aspect. But I haven't seen if that has actually played out in an actual case.
No, I was just going to say, if the current court looked at the First Amendment as broadly as they do the Second, then maybe this would be a moot issue.
I'm going to take you up on your offer to ask an academic-y paper question. So first, I don't think that you need to defend a focus on black women. I think that's, that there are some topics where you just say, yeah, that's what I'm writing about because it's worth writing about. And in some ways, if you need to defend it to your reader, it almost devalues the need to focus on it in some. But leave that aside. I am curious about the way that you talked about resistance, and I wonder if you have a taxonomy of resistance, because some of the resistance that you talked about is sort of within system, right? Running for mayor is within system resistance. Some of what you talked about is outside of system, right? Killing someone, killing the slave owner, running away. Horrible system, but that act of resistance would be contrary to the system. So does the type of resistance matter to your discussion? And if it does, what wouldn't be resistance, right? Is resistance just being used here, I shouldn't say just, is resistance being used here as a way of establishing or reclaiming or claiming power? If that's the case, I'm giving you the complicated 7-part academic question. If that's the case, I think it would be useful for me, at least, to have a clear understanding of resistance from what or against what. And I think I know the answer, but I also think it could be a couple of different answers. So I don't want to suggest one. Yeah. But I'd love to hear you talk more about any of those 7 questions.
No, to the first part of how I define resistance, more generally is Black women's existence in this space, and simply saying, I am here, and I'm going to call out that you are not applying the same system for me as you do other people. And so, to a certain extent, it's whether it's within or without, it is resistance. I've been toying with adding a subsection on civil disobedience. So what would this resistance look like if Ms. Moses and Ms. Mason had intentionally voted? It would have been worse because they got 5 years and 6 years when they didn't even know. If their intent was to get more awareness of this process, that is still resistance because civil disobedience. But then people who already distrust the system are then having to face the system again. And what does that mean? Especially in my position as someone who doesn't have a record telling and is comfortable in a law school saying, here's an idea, you can do this intentionally, right? And so that's why I'm toying with how I talk about this, perhaps in the conclusion of civil disobedience was something that has been elevated for the civil rights movement. What would it look like here? So to your question about does it matter? I use both of them as a result. Technically, both of them aren't within the system, like these two examples. But what about civil disobedience when it's outside? And then it's the resistance. The purpose is to highlight the legal estrangement, which I talk about in my first piece, this inability to access voting rights and the ignoring of certain communities so that we can continue the white supremacist culture, that goal. I'll stop there and see if that,
I refound my path. The dichotomy you set up reminded me of the saying.
Wait, say again, I missed the first.
Sorry, the dichotomy that you set up between being property or being a human for punishment reminded me of the dichotomy of the saying, you're a pet or a threat. I don't know if you've heard that before, but I guess it makes me think of also how you have the sayings in 2020 of Black women are will save democracy, but then you have the statistics you shared where they're the most highly incarcerated based on the number in the United States. And then from other sources, just knowing that some of the reasons for why Black women are incarcerated are sometimes because they're adjacent to Black men and not because they actually committed a violent crime. So in terms of resistance, when you brought up the tropes, Mammy, Jezebel, how do those play into I guess your analysis and the crimes that they actually end up being incarcerated for? And I guess they resist when they try to re-enter humanity, not only as being punished. How does that keep them back?
Yeah. Great follow-up to your compliment before, so thank you for that. So it's complicated, right? Part of the holistic idea of Black women is there are many reasons why we're interested in certain things, and many reasons why courts or law enforcement or prosecutors will incarcerate them, right? And so there are many examples of the accomplice piece. A Black woman has a significant other or a child or some family member who they allow to live with them, and it turns out that that person has, or they might even be aware that the person has guns or drugs. Everybody is rounded up and incarcerated for that crime, and so they are not the direct participant. There are other avenues where women in general are reported to have higher rates of trauma than other individuals or than other genders, and so is it drug crimes? It can be, yes, right, addressing issues that they don't have access to, and so it could be for financial reasons, it could be for services, counseling, and how that is resolved is through criminal activity. But we also have Black women who commit violent offenses. We should also look at what was going on, right? Thinking back to the other pieces of why someone would commit a crime, but it's more holistic, the list that I give you, about why anyone would be ensnared in the criminal legal system. But as the graph that the image that you mentioned indicated, the image of Black women are very targeted. We don't have that holistic idea. We don't have this is more complicated than you are an angry Black woman who wanted to do this, right? And so having the understanding of what Black women are convicted of, but also knowing that it's way more complicated would benefit that. And that resistance is what I'm trying to highlight, being more complicated. It doesn't have to straight up be, you are wrong, court. Here, I'm going to sue you. It's, you are wrong, court. And you're going to keep, I'm going to wait until you hopefully figure out that you were wrong. But in my refusal to accept the discrimination, I'm holding you accountable.
All right. Well, unfortunately, that is all the time that we have. But please join me in thanking. And we are gonna quickly set up for a virtual presentation. So, 3 minutes. Be speedy if you need a break.
Hello there. Can anyone hear me? TV land.
Yes, we can hear you.
All right.
Good afternoon. My name is Abby Dreiling. I am the lead articles editor for Volume 58. I am pleased to welcome our keynote speaker, Professor Justin Hansford. Professor Hansford is a professor at the Howard University School of Law and executive director of the Thurgood Marshall Civil Rights Center. He is a scholar and activist in critical race theory, human rights, law, and social movements. The Biden-Harris administration nominated Professor Hansford to serve in the UN Permanent Forum on People of African Descent. As the only American representative in the forum, Professor Hansford advocates for reparation payouts to Black Americans. After the killing of Michael Brown in Ferguson, Missouri, Professor Hansford served as a policy advisor for proposed policing reforms at the local, state, and federal level, testifying before the Ferguson Commission, the Missouri Advisory Committee to the United States Civil Rights Commission, the President's Task Force on 21st Century Policing, and the Inter-American Commission on Human Rights. Professor Hansford is the co-author of Race, Racism, and American Law, the first legal textbook dedicated to race-related law courses. Please join me in welcoming Professor Hansford.
All right. Thank you. Thank you. Yes. First of all, I want to apologize. I am in Richmond, but I am at your hotel with a bad case of the flu. Can you hear me okay? Yep. So I have to apologize. I would love to be there in person with you. In fact, one of my co-clerks for Judge Damon Keith, I believe, Marissa Jackson, was there speaking earlier. Really sad I was not able to spend time with her. And I'm really happy and honored to be here this afternoon to talk to you about this very pressing issue. I have taken the pleasure of making full use of my virtual presence through the mechanism of PowerPoint and also through the mechanism of using some internet tools if they are going to work. So we're going to see if they work in a second here. But essentially what I'm going to do today is to take you through the beginnings of my argument that there is hope for reparations, specifically from a legal perspective and also from the perspective of racial narrative and the importance of racial narrative and understanding how reparations can become a reality for our communities. And one of the most interesting aspects of this invitation to me was that the city of Richmond plays a central role in why it is we have a legal path towards reparations under the Constitution. and why it is I can see a path forward for constitutional reparations in our lifetime. So if you'll bear with me for one moment, I'll see if I can do a share screen and show a bit of this PowerPoint here. What I actually want to do is go back and forth between the PowerPoint and some interactive visuals here. Can you see my PowerPoint now?
Yes.
All right, great. Okay, so this presentation, and I'm looking forward to your interaction. So I'm going to leave plenty of time for us to have discussion afterwards. But for us, and for people who have been working on the case for reparations, it's been indeed a long march. We should not in any way forget the fact that the claim for repair is something that has not only been in existence for our century. In fact, many people point to the work of Callie House, who was one of the first advocates for what she would call the Slave Pensioners Fund in the aftermath of enslavement. But there were many who are arguing for reparations even before enslavement was over. But never before have we had as much activity as we have had in recent months and years on the issue of reparations. But all this is taking place in the context of the Supreme Court's continued jurisprudence on the issue of race and American society. Most recently, of course, in the decision that we have bemoaned across the civil rights landscape, the decision SFFA versus Harvard and SFFA versus University of North Carolina. This decision led us to the ruling that race-conscious admissions in the university context are constitutional to promote diversity. Diversity is not, as in the view of the Supreme Court, the compelling state interest that it was on June 28th of 2023. One of the interesting things, this is Kavanaugh, one of the interesting things about that opinion, and I took some liberties of this picture from his confirmation hearing, as you may remember. But one of the things that was most interesting was a statement by Justice Kavanaugh during the oral arguments around this case, which took place on October 31st, 2022. There was a back and forth between Justice Kavanaugh and Cameron Norris, a lawyer arguing for the end of affirmative action, where Justice Kavanaugh said, "So today, a benefit to descendants of slaves would not be race-based, correct?" And there was a little bit of a back and forth, but Justice Kavanaugh did seem to be confident that in the same way that the Freedmen's Bureau and other instances of trying to provide remedies for enslavement in the immediate aftermath after the Civil War was not seen as race-based, but it was based on direct harm, provable harm by the state. So in the same context, would benefits to descendants of slaves not be race-based? So even in the dark sky of the Supreme Court's opinion, many of our advocates went back to these oral arguments to say, now, wait a minute, what can we do with this small piece of information? And so for many of us who have been reparations advocates around the country, this was a reaffirmation of jurisprudence that we had already been aware of. And we continue to believe that under the 14th Amendment, both universities and municipal governments have the constitutional authority to advance race-neutral and race-conscious reparations programs, if indeed those programs are narrowly tailored to an exact injury suffered by a group that is proven to be harmed by an act of the state. If you go back to Justice Kavanaugh's statement here, this idea that the Supreme Court is outlawing race-based remedies on the grounds of diversity would not be applicant to benefits given to descendants of slaves. Now, of course, some of us are curious as to what the difference would be when you're talking about descendants of slaves receiving benefits or, say, Black people receiving benefits. Seems like a distinction without a difference. Of course, there are people who have been the descendants of those who immigrated to the country, who were not descendants of those who were enslaved, who would still be beneficiaries under a race-based structure that would not be beneficiaries under a structure such as what Justice Kavanaugh justifies. I'll come back to that more later. But we did have this understanding in our analysis of the jurisprudence. And this understanding was something that came out of a case originated right here from the University of Richmond, excuse me, not the University of Richmond, the City of Richmond versus J.A. Crossan. I saw this this quick summary of the case on the internet from 1989. I thought it would be very interesting to look at a C-SPAN image from 1989, where you see the City of Richmond had a government set-aside program where 30% of the city's construction contracts were to be subcontracted to owners of minority-owned businesses. The J.A. Crossan Company lost this contract because of the 30% set aside, brought suit against the city on the grounds of the 14th Amendment. Like many of our 14th Amendment cases, it was brought on this concept of reverse discrimination. And we saw that the Supreme Court struck down the Richmond set-aside program as being unconstitutional, arguing that the program was not sufficiently narrowly tailored to respond to the compelling state interest requirement, which is necessitated under the 14th Amendment's strict scrutiny jurisprudence. But we did see from Justice O'Connor's opinion that, in her view, a subdivision like Richmond does have the authority to eradicate the effects of private discrimination within its own legislative jurisdiction if the city could show that it had essentially become a passive participant in that process. Justice Scalia, in his concurrence, reaffirmed his core belief that the Constitution is colorblind based on his reading of jurisprudence, including Plessy versus Ferguson, where the colorblind principle emerges from. And he spoke how, in this case, he saw the plan by the city of Richmond as the fulfillment of a prophecy. Now, what prophecy would that be? It's a prophecy of oppression, a prophecy that he spoke about in a very oblique way throughout the opinion, that in the aftermath of enslavement, in the aftermath of Jim Crow, in cities where there would be a majority of minorities or majority of African Americans, there would be a sort of a revenge narrative that would be enacted by these city councils or these cities. And there would be the implementation of what Justice O'Connor, in this opinion, called pure racial politics, pure racial politics. And that prophecy is one of the things that was most feared by Justice Scalia when it came to questions around racial set-asides. This prophecy of reverse discrimination, this prophecy of oppression, where a particular dominant racial group uses the law in a non-colorblind way to help some and harm others on the grounds of race. Now, this analysis is an analysis that emerged from a law review article from 1989 called The Richmond Narratives by Thomas Ross, one of the foundational law review articles in the critical race theory collection of scholarship. And in that law review article, brilliant law review article, Thomas Ross talks about the importance of understanding narrative in the reading of the law, specifically in the reading of judicial opinions. And in the view of Professor Ross, we see two things taking place in the judicial opinion here, Richmond versus J.A. Crossan. One, the narrative of symmetry, which I also would reinforce as being part and parcel of the narrative of colorblindness. This idea that racism, to ameliorate the harm of, any actions taking place to ameliorate the harm of Jim Crow or the harm of slavery is indeed racism, right? So racism to ameliorate histories of racial hierarchy is still racism and still should be outlawed. But this idea that our Constitution is colorblind and we have symmetry, so the use of race to create a minority set aside is just as racist as the histories of Jim Crow, which were experienced in the city of Richmond beforehand. Similarly is this narrative of racial innocence, this idea that those who would be the ones who would seem to be on the receiving end of this program, those who would be harmed by this program, white citizens of Richmond who would not be the beneficiaries of this set aside, in this case, the company J.A. Crossan itself. These companies, these groups are innocent and they are being harmed by these policies implemented by the dominant racial group here. So these two narratives, and I want to stop here for a second. These two narratives are narratives that have framed the way that the court has thought about supreme affirmative action jurisprudence ever since Richmond v. Crossan. Really, it goes back to a bit earlier, but besides Richmond v. Crossan, we don't see as clear and succinct an application of these principles, even outside of the context of education, but here in the context of minority government set-asides. So that gives us a bit of a lay of the land in terms of what it means to understand the legal case and a bit of the narrative case for why the Supreme Court, in its current stance, number one, has, of course, we know that the diversity rationale has been eradicated in a sense. And number two, we know that the narratives of racial innocence and the narratives of colorblindness and symmetry continue to exist in the Supreme Court jurisprudence, and in many ways was able to find its greatest representation in this most recent Supreme Court opinion. So that's where we stand. Now the second question becomes, where do we go and why? So in my work, and I'm going to pivot a bit here and show you a bit of some of the work that I've done at Howard University, and also at something called the African American Redress Network here in Washington. But at our institutions, we have found, and this is the website for the African American Redress Network, we have found that there is work happening all around the country that, of course, flies in the face of both of these narratives, while at the same time using Richmond v. Crossan as not a tool of oppression, but repurposing that case as a tool of liberation. So this is the website for our organization, the African American Redress Network. I was a co-founder. Thurgood Marshall Civil Rights Center was a co-founder in 2021, along with Columbia University. What we do is we provide multidisciplinary research to support reparations advocates around the country. And also, we have a program called our Redress Map, where we have mapped local reparations and redress efforts across the United States. We have found that there are over 450 local efforts to provide repair, redress, and reparation in whatever form. But many people, when they think about reparations, the first thing they think about is a check. But we have seen that all sorts of activities, including activities even of renaming buildings, renaming universities. I know that has happened even recently here at the University of Richmond Law School. Renaming monuments, eliminating monuments, official apologies by cities. All of these activities are part and parcel of the project of trying to find a basis to establish that there has been harm that's taken place in a particular community. And as we demonstrated in one of our most important reparations redress campaigns, our work in the city of Evanston, we also have been able to use these same campaigns through our research, our historical research, and through our documentation. We have been able to use some of the same work to support municipal reparations commissions. This includes our work at the Thurgood Marshall Civil Rights Center. We have, as I said earlier, we have students who have done research on transitional justice mechanisms. We found 90 different cities who are embarking upon the process of promoting reparatory justice on the local level. But and we also have a toolkit for local communities. But most interesting was our work in the city of Evanston, Illinois. Evanston, Illinois has been one of the first cities in the country to provide a reparations ordinance, to pass a reparations ordinance, which in 2021 began giving out reparations to victims of housing discrimination in the city. What the city of Evanston did was work on a report which outlined that from 1929 to 1969, the city participated along with the other actors in the housing sector, along with mortgage holders and others, to redline the city. And in our report on the history of segregation in Evanston, we outlined some of that history and explained how the case for reparations in Evanston was based on these specific findings, specific harms. And these specific findings and specific harms, you see some of the documentation. These specific findings and specific harms spoke to specific remedies that the city could implement. In this case, remedies that included housing vouchers, narrowly tailored to the harm of housing segregation. You see that we had to narrowly tailor that remedy to the specific harm in our discussion in order to find our way past 14th Amendment restrictions. So you see the history of redlining was so stark. You see the distribution along racial lines, African Americans isolated in this blue area, and white Americans allowed free reign to have housing in all of these areas around the city of Evanston. And as a result of our very close documentation, what we were able to do was not only to give a specific timeline of housing segregation, explain the effects on the wealth gap in the city of Evanston, but perhaps most relevant to our legal audience, we were able to help make the legal case for why this plan passed the restrictions of the 14th Amendment. There was a law firm, Boyden, Gray and Associates, that anticipated that the reparations program would be unconstitutional and announced their plans to bring a legal challenge to the program. And as a result of that announcement, we decided to do our own legal analysis and to work closely with the city of Evanston to ensure that the plan met constitutional muster. And after that plan was designed, we put out this letter to demonstrate our belief that the plan was indeed constitutional. But I mention all of this to say that the work that was done by advocates in the city of Evanston needed our help. It needed the help of lawyers to help us to frame the remedy so that it was narrowly tailored to meet the standards of Richmond v. J.A. Crossan. And that's one of the core legal takeaways that I have brought to the table to my analysis as a result of what's taken place over the past 2 or 3 years. And all of the discussion around whether or not reparations would be constitutional. So often people feel that the most precise analogy, the proper governing jurisprudence, is the affirmative action jurisprudence at the university level. But my belief is that, especially on the city level, it's actually Richmond versus J.A. Crossan, which is the most important case for us to look at. Because in that case, there is not a diversity rationale being made specifically for these set-asides. In many cases, there is a rationale based on specific remedies for past harm. Now, of course, Richmond versus J.A. Crossan was a case in which the program was overturned because, according to Justice O'Connor, the evidence was not specific enough in terms of the evidence of the harm that took place in the past in the Richmond construction industry. So the case is not a victorious case that we build on in terms of looking to build on that victory. But the case does outline for us what I believe to be our constitutional path forward. But perhaps even more importantly than our constitutional path forward, I'm going to pull up another website in a moment. I want us to think about the importance of our narratives and finding our narrative path forward to overcome the narrative roadblocks that continue to exist as a result of the Supreme Court's full embrace of this concept that, number one, both affirmative action and reparations represent reverse racism. And number two, that this so-called reverse racism is harming these racialized innocents here in the United States. So what I'm pulling up here is a website called the Reparations Narrative House, created by one of my most well-admired partners, Liberated Ventures. And what this narrative house does is, and I can give you more information on this, but it provides tools for reparations advocates who are seeking to respond to the narratives that are being weaponized against us all throughout the country. And it even goes to the point of giving us different examples of some of the narratives that have been mobilized to say that reparations is reverse racism. We have already progressed so much that we no longer need any sort of repair. You see who's making that claim. This idea that there are other Africans who were more responsible for the selling of enslaved people, and they should be the ones that should bear the brunt. Or this is just about financial compensation, or it's a cash grab. Or it happened too long ago. It's no longer applicable, or it's too complicated. Harm is everywhere. That if this is slippery slope. If we give reparations for Black Americans, then we'll have to give reparations for every group that's ever been harmed in any way, shape, or form. This goes against our country's commitment to meritocracy, and people should be pulling themselves up from their bootstraps. And it's just an example of one of the. See if we can get an example of one of the narratives in action.
Succinctly put it a couple of years ago, quote, "It is literally impossible to be racist to a white person." Pretty much the entire left now takes that as a matter of faith. They deeply believe that. But what does that mean exactly? Is there really an entire race of people so repulsive, so morally repugnant, that it is, quote, literally impossible to wrong them? You could do anything to people like that and not feel bad about it. In fact, why wouldn't you? They deserve it. They're not really human.
Okay, so here is the narrative of diaspora at odds. And now, and while you listen to these, I would love you to start thinking about, are there responses that exist in any of our critical race theory literature, in any of our advocates' arguments on the question of affirmative action that would apply here? So here's the argument that reverse racism is impossible. And if you were to make the argument that reverse racism is impossible, you are essentially in that case saying that it's impossible to have a racist thought against white people, or white people are so, what was the term? They were so intolerable that they can't be harmed. And I think that was the substance of the argument. I know Tucker Carlson is particularly, sometimes it's hard to follow his logic, but that was the logic here. So here's another one.
Well, I think you're right about reparations in terms of, if people want it, though, what they need to do is you always need to go back to the beginning of a supply chain. Where was the beginning of the supply chain? That was in Africa. And when across the entire world, when slavery was taking place, which was the first nation in the world that abolished slavery? First nation in the world to abolish it. It was started by William Wilberforce, was the British. In Great Britain, they abolished slavery. 2,000 naval men died on the high seas trying to stop slavery. Why? Because the African kings were rounding up their own people. They had them on cages waiting in the beaches. No one was running into Africa to get them. And I think you're totally right. If reparations need to be paid, we need to go right back to the beginning of that supply chain and say, who was rounding up their own people and having them handcuffed in cages? Absolutely. That's where they should start. And maybe, I don't know, the descendants of those families where they died.
Yeah, so here's our perhaps one of the more popular ones. This is the last one I'll do, is our Senator Mitch McConnell, soon to be former leader of Senate Republicans.
Reparations for something that happened 150 years ago, for whom none of us currently living are responsible, is a good idea. We've tried to deal with our original sin of slavery by fighting a civil war, by passing landmark civil rights legislation. We've elected an African-American president. I think we're always a work in progress in this country, but no one currently alive was responsible for that.
Okay, we'll stop there. So the election of President Obama was reparations, according to Senator McConnell. But here's one of the more interesting points, and I'm gonna cut this last part a bit short so that I can take some questions. But as we're thinking about this transition from affirmative action to reparations, and let's think about how we respond to these narratives that are designed for retrenchment of racial progress. And let's ask ourselves this key question: how can we move forward with reparations? And my belief is, would reparations actually be a more effective narrative to the arguments against racial progress than affirmative action was? So, for example, one of the key arguments in the Richmond v. Crossing case and also in SFAA is the argument of innocence, somewhat mentioned by Senator McConnell. No one alive here is responsible for the racial harms that may have taken place in the past. So these are innocents that are being harmed by affirmative action. But the beauty of the reparations project is that, as you saw earlier with the graph, it's not just about implementing remedies, it's also about coming to a reckoning for past harms. So the process involves talking about the history of race, and not in an abstract way, but as we are creating records to understand the harms done by specific institutions, harms done by particular cities, even harms done by particular universities. You then have a record of entity culpability, if not individual human culpability for harm, but the city of Richmond's culpability, the University of Richmond's culpability for harm, and how there's no innocence there when it comes to the entity culpability. So, and you could tell me more than I could tell you about the harms done by the University of Richmond. I know I'm an alumni of Georgetown University, and there has been the acknowledgement that Georgetown University was founded on the sale of 272 people into enslavement in Louisiana. And as part of their reparations project, Georgetown University has provided an enhanced admissions process, and I do believe scholarships for admission to the University of Georgetown for those who are related to people descendant from those original 272. And my understanding is that the University of Virginia has also done the same thing and created a process for reparations for those who were impacted by the university's involvement in enslavement. And not only that, the university has created a consortium of over 100 other universities who are doing a similar study on their university involvement in enslavement. And so it's happening in real time. The transition from from diversity admissions to admissions on the grounds of repair for past harm done by the individual institution, to me, is a viable alternative to the current or recent process of diversity-based admissions. And here's the website for universities studying slavery. So we see that this is something that's happening all across the country. So those are some of the narrative arguments. The question around symmetry is the other core argument I do want to mention very briefly. The question of colorblindness as the norm that we should be aspiring to as a constitutional framework for us to move our 14th Amendment jurisprudence through. To me, that idea of colorblindness as the aspiration or symmetry between the use of race to end racial hierarchy and the use of race to promote racial hierarchy, once again, falls apart as we have a more complete reckoning with our racial past, and we do so on the local level, on the individual level. My theory of change, with the work that we're doing at the African American Redress Network and also at the Thurgood Marshall Civil Rights Center, is that reparations is going to happen locally, and reparations is going to happen in our lifetime. And I just want to end with our most recent proposal, which is the creation of a bar association of lawyers to work on reparations cases all across the country, to train lawyers to work on reparations cases all across the country, to support lawyers in the city of Richmond, in the city of Washington, D.C., the city in California, the state of California, where they have a state reparations commission, in the state of New York, to assist them in legal analysis, to assist them in the identification of pro bono counsel, to assist them in drafting bills that can pass constitutional muster, to assist them in community outreach and education. So this project is one of the most important projects for racial justice that we've seen in our lifetimes. I believe it's just beginning, and I'm looking forward to learning more about your thoughts on this, and thank you for inviting me. And again, I'm sorry I could not be there in person, but I'm hoping to hear some of your questions in the next few minutes. Thanks a lot.
Great, thank you so much. Now we're going to move on to the Q&A session. If anybody has questions for Professor Hansford.
I realize your focus is on reparations, but considering the harm in the past and whether the Supreme Court wants to recognize a way to resolve that, what is wrong? And thinking, let's say, in the context of the Richmond case, making sure the mistakes of the past don't repeat, and having set aside simply based on approximations of minorities existing in an area, just to make sure we don't have future violations without having to justify it based on what may or may not have happened in the past.
It's a great question. So as was mentioned, I work at the United Nations, and the idea of reparations is one that is it's not unique to the United States. It's happening all across the world. Happened in Germany after the Holocaust. I think people think about South Africa after apartheid and the Truth and Reconciliation Commission there. One thing that you see, though, in that United Nations framework around reparations is the understanding that there is much more to it than simply financial compensation. The question of apologies are important. The questions of historical reckonings, and I said all this to say one of the key pillars of reparations in the UN system is guarantees of non-repetition. Guarantees of non-repetition. So the process of repair and healing is not complete until there is some structure put in place to ensure that the harms that took place before will never take place again. And so that is key to any process of reckoning and repair. Now that is something that, as you mentioned, should not necessarily be limited. So one of the problems with crossing was this idea that if you don't create a remedy that is very particularly tailored to the harm that was articulated, then let's just not do anything, right? You would throw the whole entire process out. Now that is clearly the wrong way to go about healing a community. You know, you have to have a community process that's inclusive. And if you don't get it 100% right the first time, you have to understand that it's not a one and done process. It's not something that happens overnight. It happens as a result of community conversation and understanding that racism in our society is a part of the heritage of slavery. And in many cases, you can make the argument that it is a question to be seen as more properly fitting under the 13th Amendment's dictates against ever repeating slavery again, and also eliminating all of the incidents of slavery and the legacies of slavery. And of understanding racism as one of the incidents and legacies of slavery, as opposed to understanding racism as a violation of this idea of colorblindness, is one of the most important steps that we can make as a society, and really coming to a place where we can say there's true justice.
Anyone else?
Hi, so you talked earlier about how when determining in Illinois if they were going to give or grant reparations, they had to find specific findings and specific harm. So I'm wondering if you could speak to how specifically identifiable that harm has to be. And to me, it sort of feels like you get into a position of quantifying and comparing harms, and so how you avoid that, if that's possible.
That's a great question. So in many cases, I'm going to say in all cases, we found corporation counsel, counsel for the city government, to be very conservative, just like most lawyers. They're seeking to avoid litigation at all costs. So they interpreted crossing to mean that the level of specificity necessary for a program of repair for a past harm, that the level of specificity in your report of the past harm has to go down even to the level of the individual. So the process of receiving reparations in Evanston involves individuals who have access to records of either their the impact on their individual homes or the homes of their family members. And as a result of that, the amount of people who have received the reparations in the city of Evanston has been limited. I think it's a little bit over 100 now, from what I understand. There are many people who are critical of that framework because it leads to an outcome that people think maybe, is it reparations if only 100 people receive it, right? So that is what I foresee to be one of the most important legal battles that we're going to be fighting the next 5 years. Because, as I said, 90 cities have commissions. California has finished its commission, and it had 1,100-page report. And New York's commission was just appointed yesterday, or this morning. New York appointed its commission. So we are at 3 states, about 90 cities. So all of these different cities will have different particular histories, and these different states will have particular histories. In Oklahoma, Tulsa, Oklahoma, you may be talking about one thing. Chicago may be something different, from Detroit, Kansas City. So in each of these situations, we'll see how specific the reports are. My argument is that by going on a local city level, you're more likely to have more specified reports. So there's been a long debate about what's more effective, HR 40, the federal reparations legislation that will reportedly pass a $10, $11, $12 trillion reparations package nationally, or we're going state by state and city by city. My argument is that you are more likely to have a more specified record going city by city, letting each city do an analysis of its own particular history, so that the reports will be detailed enough to survive any sort of scrutiny that may come from the courts. So that question of how detailed we need to be is an unanswered question. So it's a great question. But you know, the two parts, so there are two levers, so to speak, right? So you have the specificity of the report, you have the groups that receive remedy. You know, how specific are you in terms of the remedy? Is it going to be individual people? Will it be those people's descendants? How far out will those descendants go? You know, does it have to be children or grandchildren? Can it be nephews, cousins? You know, as you get to communities, is it geographically limited? So how do you frame who is part of that recipient class? And of course, the real hot debate has been, should it only be those who are descendants of those enslaved, or should it be people from other parts of the African diaspora, you know, who came after enslavement, who still experienced racism, but maybe were not descendants of those who were enslaved? Now, when you have commissions based on things besides slavery, so take Evanston, housing discrimination, you don't have that same problem, because a family member who came in 1960 from Ghana or from Jamaica still would have experienced housing discrimination, even though they weren't descendants of those enslaved in the United States. So they would be eligible in that case. But in another situation where the harms are more tied directly to enslavement, you know, maybe that's another conversation. So those are some of the really tough questions that we're still going to be answering, but I expect that it'll come out in the wash. You know, after like 90 cases of these, you know, we'll start to see some patterns that we can then begin to apply.
Awesome. I think we have room for one more question.
This may be completely too far out there compared, but I'm wondering whether the recent settlement with Henrietta Lacks's family and Johns Hopkins University could be influential at all, or have any impact on the goal of reparations in localities, since it was her property, her body was taken from her and profits were made, kind of similar to slavery. It may not. I'm just curious from your perspective.
You know, I think that question speaks to the liability of businesses, and of course, though that is in the middle of the conversation. I spoke mostly in my talk about municipal liability and a bit about university liability, but there's also the question of business liability. So businesses that profited off of Henrietta Lacks' DNA came to that settlement. Of course, we know there were businesses like Wells Fargo and Citibank that were directly involved in insuring enslaved people, using enslaved people as collateral for loans, who had profits. Lloyd's of London admitted, the bank Lloyd's of London admitted their complicity about 6 months ago. So that question of business liability is also a relevant question. Now we found that as we saw municipal bills passed, again, the municipal liability has been tied specifically to municipal actions, and we have that's another point of question, right? So are we going to only find a city or state liable for its specific involvement, things that it voted to do as a city council, or will there be liability for those things that it allowed to happen? So should the city of where the exploitation took place be liable for what it allowed? The city of Tulsa, Oklahoma, you know, was not Tulsa law enforcement who involved themselves only, there were some law enforcement officers who were involved in the massacre, but there were private citizens who were involved, and what law enforcement did in Tulsa was simply not intervene. So we believe that Tulsa should be liable, not just for its own actions, but for the actions that it did not prevent. Now that includes that, that's more liability for this city, but in some cities, Philadelphia and Chicago, another approach has been to create disclosure ordinances. And those disclosure ordinances mandate that whenever a company does business with the city, whenever a company gets a government contract, it has to disclose its involvement in enslavement, or its involvement in Jim Crow segregation, or its involvement in other racial harms, and if possible, do so on the road to providing repair and reparation for those harms. That has actually been done in the past, I believe, with companies involved who profited from the Holocaust, for example. So there's precedent for it. And one of the problems is that in the city of Chicago, only 6 companies have actually complied with that disclosure mandate, and it has not been very aggressively enforced. And I don't think it's been enforced at all in the city of Philadelphia. So one of the proposals that I have is to create RFPs so that private companies could explore their own research in auditing companies' involvement in racial harms. And then those private companies could disclose. So that has not passed anywhere yet. That's simply in the idea stage. But I do think that to get more of the business community to participate in this reckoning, there is going to have to be a lever that is going to need to be used by governments and by other actors to ensure there's some sort of accountability.
Amazing. Thank you so much, Professor Hansford, for joining us today. And now we will move on to the last presenter of the symposium.
Thank you very much.
Thank you, Justin. It's a pleasure to see you, man. A pleasure to see you. All right. Hello, hello, hello.
Can you see and hear us, Mr.
I can see you, and I can most certainly hear you. And
Great.
I'm wondering, I see movement. Are we on break time now? Or people are saying the last and the most boring presenter is up, so we're going to take leave?
No, I think we're going to go right into it, but we want to introduce you first. Thank you for being here.
My attempt at levity. I'm sorry. I'm trying to get a joke in already. Go right on.
Of the University of Richmond Law Review. I think you can already tell that I have the distinct honor to introduce Dr. Jonathan Augustine to you all. I have had the privilege of editing Dr. Augustine's piece for publication in our symposium issue. I have loved reading it, and I can firsthand attest to the fact that we're all very, very lucky to learn from him today. Dr. Augustine is a leader in the areas of race and reconciliation. After graduating from Tulane Law School, Dr. Augustine clerked for Justice Joshua Johnson of the Louisiana Supreme Court before working as an advocate in the ongoing post-Brown desegregation litigation. He has taught at Southern University Law Center and North Carolina Central University Law School, and served as a consulting faculty member at Duke University Divinity School, where he is a member of the Board of Visitors and the Duke Center for Reconciliation. Dr. Augustine currently serves as senior pastor at St. Joseph AME Church in Durham, North Carolina. And so please join me in welcoming Dr. Augustine.
Thank you. Thank you so much. I see you clapping. I love it. I absolutely love it. I absolutely love it. Thank you for your very kind and generous introduction, and thank you for your wonderful editing work. As I always leave in one of the final footnotes, any errors that remain are mine alone. It's an honor to work with you. It's an honor to work with the University of Richmond Law Review, and most certainly an honor to be here at this time. Now, Brother Carl, I am technically challenged, as you probably know from our interactions before. Were you able to get the slides that we shared?
Yes, yeah, I'll pull those up now.
All right, awesome. So, and I'm assuming I'll be able to see them as they're all, here we go. We are, as we say down in the deep south, we're cooking with grease now. We are cooking with grease. Absolutely. All right, we ready to go? Or you need to cue it up, I think.
Yes, sir, we're all ready.
Okay, wonderful, wonderful. So I am really honored to be a part of the distinguished panel of presenters that you've had. In looking at the biographies of the respective speakers, Justin, who I know personally, who I'm honored to succeed. I am challenged, obviously, in being the last speaker, so I better be lively, right? I'm the only thing standing in between you and happy hour. Okay, I missed all the fun and frolic last night, but I'm gonna do my best to make sure you have some fun for our time together before you go to happy hour. And I wish I could be at happy hour with you. But in looking at the distinguished speakers that you had, I think my vantage point and my perspective is arguably unique in that I am approaching this topic as an interdisciplinary scholar, but someone who is steeped in religious practice, but not so much from a perspective of proselytizing, but religion from a perspective of understanding how it motivates people and how it motivates social behavior. So the topic of the presentation I have for you is "The South Will Not Rise Again, the Religion of the Lost Cause Meets the Politics of Confederate Monument Removal." Next slide, please. All right. There are several pivotal moments in the history of the United States, two of which have everything to do with where we are with respect to this presentation, and both of them have to do with how religion undergirds social behavior. August the 6th, 1965, and January the 6th, 2021, are two polar opposites in terms of a movement to advance rights and a movement extending to a group that previously did not have rights, and I'm speaking specifically to African Americans. And the image on the right there, so the January 6th insurrection, in my humble estimation, is an attempt to reclaim rights or an attempt to reclaim power by a group that argues it's been displaced. So in thinking about the advancement of the Voting Rights Act of 1965 and Lyndon Baines Johnson signing it into law, he empowered a demographic that the 15th Amendment did not empower, right? It empowered it in theory, but there were all sorts of hurdles and hoops that were put in place to detour and to suppress voter participation and civic participation in general. But that means who has the right to speak in terms of governmental speech, in terms of participating in elections, in terms of having their voices heard. And I think this is going to become much clearer in a moment. But faith undergirded the passage of the Voting Rights Act. When we think about Martin Luther King Jr., when we think about the leadership of other clergy and laity, it was really a theological undergirding that extended rights. On the opposite side of the spectrum, when you look at the picture there, Jesus is my savior, Trump is my president. Okay, let me be clear. I have no problem with either of those statements individually, but when you conflate the two together, that brings us to a phenomenon that we call in this day and age Christian nationalism. It's a conflation of cross and country that is very hierarchical. And the hierarchical nature of it puts white Protestantism, particularly white Protestant males, at the top of the pecking order, and everything else somewhere subservient to it. That includes our Jewish siblings, that includes our Muslim siblings, that includes our immigrant siblings. But for our case in point today, it certainly includes minorities, and specifically the same African Americans who were granted the right to vote back in 1965. Next slide, please. So a little bit about the outline that I want to follow. I want to talk with you about my research agenda, if you will, in terms of this article's religious perspective and why I'm emphasizing sort of the uniqueness. I believe it's unique in terms of the symposium presenters. I then want to present to you really a legal question for the day, right? It'll be steeped in religion, but it really is steeped in law. And there is a fundamental First Amendment question about who's speaking in terms of the government speech doctrine, who's speaking and who's not allowed to speak, which ties into passage of the Voting Rights Act. I then want to walk you through just a couple of high points, the meat and potatoes of the article, "The South Will Not Rise Again." I'd like to discuss some future potential for further research and social impact, and why I think this is such an important area of law, an interdisciplinary aspect of law, and then obviously questions, answers, and comments. And hopefully I don't bore you to death, because the next thing up after me is happy hour, right? Okay, my attempt at levity, right? Y'all not laughing. Y'all like, man, I'm going happy hour. Okay, next slide, please. All right. In terms of my background, 2012, which is a mighty long time ago. 2012 was my first interdisciplinary article where I really found myself in the space of law and religion, a piece that was published on the First Amendment, a theology of civil disobedience, published in the Southern California Interdisciplinary Law Journal. Since that time, I have been much in the weeds on how the two intersect, again, how religion influences social behavior. There have been books that have followed and several law review articles that have followed. But my research focuses on social behavior and its influence through religion, whether it be in the form of civil disobedience, through the civil rights movement, whether it be in the form of Christian nationalism with respect to immigration. That's the most recent article I did, which was released just a couple of weeks ago now from the Howard Law Journal. And in this case, I want to focus on the religion of the lost cause during and after the period we know as Reconstruction. Next slide, please. My research has shown, and these are two books that I wrote, Call to Reconciliation, How the Church Can Model Justice, Diversity, and Inclusion, that was published in 2022, and When Prophets Preach, Leadership in the Politics of the Pulpit, published in 2023. My research in these two books highlight a polarity that says there really are two sides of Christianity in America. There is a very progressive side, which you certainly saw in the image there when Lyndon Johnson was signing the Voting Rights Act into law. That was the result of a very progressive side of Christianity. But there is also a very regressive side, a side that chooses to say America was set up as a quote unquote Christian nation. There's a hierarchical nature to America. And because of the way America was set up, if you don't fit within that hierarchy, you were not part of God's original plan. So that side is very regressive. And forgive me for the partisan overtone of the comment, but the slogan to make America great again is really an indication we want to take America back to another time, right? That's the regressive nature of what I'm attempting to illustrate. Forgive me if that comes across as partisan. I know it's popular, so I'm only lifting it up to hopefully stimulate your intellectual juices. Okay, next slide, please. Now, in preparing for this symposium, I'm a reader, I'm a voracious reader, and I had the opportunity to read several law review articles, several books. 4 of the books I want to lift up to you in case you're interested in knowing more from this perspective on how religion has influenced social behavior here, particularly this narrative of the lost cause. I lift up Charles Reagan Wilson's, the book in the top left there, The Religion of the Lost Cause, 1865 to 1920, if I can see correctly there. That time period very significant, with the Civil War obviously beginning, going on to a period where you had Confederate monument erections all over the place, an attempt to preserve what was and to regress, if you will, to go back to a legacy of diminutive power of who was in charge. My homeboy, I'm from New Orleans initially, and Clint Smith, I want to lift up How the Word is Passed, a wonderful book that notes the prevalence of Confederate iconography in the South, why it got that way, how religion influenced much of it, and specifically this religion of the lost cause I'm talking about. I lift up Robert Jones, a wonderful scholar who's written several books that I've read, but this one in particular really gave some meat for the article, White Too Long, in discussing the prominence of whiteness and the control of whiteness in American Christianity. And again, that goes to the hierarchical, the subservient nature of race, a social construct in our body politic, but certainly part of the religion of a lost cause. And then finally, I lift up the scholar, Dr. Cox, a wonderful, wonderful work with the imagery of her book there coming right out of Richmond, No Common Ground, as she highlights many of the differences between Southerners and other people from other parts of the country, illustrating a localized religion, if you will, this religion of a lost cause that created a myth of the Confederacy, of the fight not being about slavery, but being about Southern values and why the Southern gentlemen were heroes and why it's necessary to lift up monuments to deify them, if you will. So just want to share those books with you as a fundamental resource in case you're interested in knowing more. Next slide, please. Now, I shared with you, I want to lift up a fundamental legal question. This is what I'm going to ask you to wrestle with. You're going to hear from me in terms of theology. You're going to hear from me in terms of geography, but in terms of the law, here is the fundamental question that I want you to wrestle with. What happens when municipal laws conflict with the laws of their states? In other words, if a law in Richmond conflicts with what we will call a cultural heritage law or a heritage protection act from the state of Virginia, what happens when there's a conflict? Well, we understand that because municipalities are political subdivisions of their states, state law prevails. We get that. What happens, though, when statutes, did you catch that? Statutes, or preemptive state laws stifle municipalities and government or political speech that is inconsistent with prevailing Supreme Court law. Supremacy clause, is that at issue? I argue then that because there is a disconnect that we're going to talk about between the prevailing Supreme Court law and a state cultural laws or state protectionist statutes that prevent the removal of Confederate monuments or Confederate iconographies by municipalities, I think there is an inherent conflict and those laws are unconstitutional. And this is a call for those respective states, it's 8 of them at the time I did the research, to repeal their protectionist laws. Okay, next slide, please. Now, story time. Everybody loves a story, right? And you're no exception. I just don't want this story to put you to sleep because it's almost happy hour time. So I want to lift up 3 particular times in recent history. Confederate statutes have been there. You had the Civil War, you had the period of Reconstruction, and in post-Reconstruction, we started to put up Confederate monuments. You really started to put them up in the late 1800s, early 1900s. But they were just there. I grew up in New Orleans. They were just always there. That's me in the front of the picture there to the top left with a Confederate monument behind me. I'm leading a prayer vigil there to have some Confederate monuments taken down in New Orleans. They were just all over the place, and nobody was really in an uproar until 2015, because in June of 2015, you had a horrific shooting in Charleston, South Carolina, at an AME church, at Mother Emanuel AME Church. So there was an uproar, tear those monuments down. Here we are. I entered the picture in 2017. There was tremendous uproar because of something I'm going to lift up in just a moment when the President of the United States said, well, there's a good people on both sides, right? August of 2017 in nearby Charlottesville, Virginia, near to you. I'm in Alabama right now, but near to you. And then there was real uproar to take Confederate monuments down in the summer of 2020 after America was introduced to Breonna Taylor, Ahmaud Arbery, and George Floyd. So as part of the story here, here's who I am. I serve also as the general chaplain of Alpha Phi Alpha Fraternity Incorporated. And here, this is a picture, I think from CNN, where I was leading a prayer vigil for the removal of Confederate monuments in New Orleans. Mayor Mitch Landrieu, who was then the mayor of New Orleans, was able to lead the city in expressing, watch this, its political will. New Orleans is a majority Black city. Mitch Landrieu was, ironic enough, a white mayor, but nonetheless, though, he's as right as he can be to represent the constituency he was elected to serve. But the city, in expressing its political will, which is akin to government speech and the government speech doctrine, to remove monuments because Louisiana does not have a statute, right? 8 states, however, do, and Virginia is one of them. They prevent cities from engaging in quote unquote political speech, which is inconsistent with the Supreme Court opinion from 2009, Pleasant Grove, Utah v. Sumanen, and with the Walker v. Texas Division, Sons of Confederate Veterans from 2015. What I'm attempting to say here is that these dates, the story presents a conflict between municipal laws and a federal law, municipal attempts, I should say, and a Supreme Court. Was 2 Supreme Court cases. There's an inherent conflict. Next slide, please. 2017 was also a very special time for me. I hope this makes sense. In terms of the South not rising again, I'm going to start with the picture at the bottom right. That is the entrance to beautiful Duke Chapel. Yes, I'm a proud Duke grad. I served as chaplain for the Duke football team these last couple of years, and that is the entrance to Duke Chapel. Now, there is a figure in the center there that is missing. You see a carved out statue on the left next to the door. You see a carved out statue on the right. The figure in the center is missing. And that door, that is the center door of where you enter Duke Chapel. Beautiful entrance. Let me tell you a true story. This was August of 2017. I'm a new doctoral student at Duke University. Because I'm a pastor, I'm going in the chapel to pray, right? Okay. As I'm going in the chapel, I'm looking and I recognize certain images in the carvings. I'm a Protestant minister. I recognize Martin Luther as somebody who kicked off the Protestant Reformation. I'm a Wesleyan, I'm a Methodist. I recognize John Wesley because Duke too is a Methodist institution, right? So here we are. I look over to my right in the center statue that's missing there. I said to myself, going into the chapel now, I said, I'll be damned, because that was Robert E. Lee. And I said, I thought I left that foolishness down in New Orleans. How do we bring that right here going into the chapel, right? So the story is, a couple of days later, the Unite the Right rally over the removal of Confederate monuments, Confederate iconography occurred in Charlottesville, and these were the vigilantes. They were taking things into their own hands. They got together with the tiki torches, and they lifted up, you see the acronym there, WRT. They lifted up the white replacement theory, saying, you will not replace us, Jews will not replace us. Right. So they're wrestling with some issues and some hatred in their heart. And that's when the president said after a fatality that there are good people on both sides. Right. But all of this was about, just to bring in that last image, all of this was about Confederate monument iconography and Confederate monuments being removed. There was great discord over that. The removal there outside Duke Chapel, to go back to where I began, is very special to me because the president, then new president, Vincent Price of Duke University, had only been in the chair a month, maybe less than a month, made a unilateral decision, clearly not knowing the full culture, not knowing everything about the institution he was supposed to be serving, but he made a unilateral decision on what he thought was right and made sure the statue of Robert E. Lee outside Duke Chapel was taken down. We're going to study it. We'll put it someplace. We'll figure out what we do with it later. But right now, we're going to take it down. I just want to be clear and sharing. As an African-American man who was enrolling in that institution, that gave me a firm affinity that this is a place that's not just playing lip service to inclusion. This is a place that's serious about inclusion. So what do I say in response to that? Go Duke. All right, next slide, please. I'm attempting to keep y'all laughing, but anyway, all right. So I wanna with that backdrop, I wanna really get into the background now of what this presentation is all about. You have sort of an overarching theme of what influenced it. I want to get now into what it really is. The South will not rise again. The religion of a lost cause meets the politics of Confederate monument removal. Okay, next slide, please. All right, now, in the wake of the Civil War, and after Reconstruction, so after 1877, many romanticized the South's defeat in both legal and religious terms. There's a certain person who's running for president who was asked a few weeks back about, slavery. America's never been a racist country, never been a Civil War wasn't about slavery. Okay, some people maintain that perspective. I'm deliberately not saying that person's name, but some people maintain that perspective. Some people would say, and looking at the image there, it's a states' rights issue. Okay, other people would say this is a moral issue. Nonetheless, in addition to legal arguments that the Civil War, some people would say it's the War of Northern Aggression, was about states' rights, not slavery. There was a conflation between a white Southern religion, or really a regionalized religion, and the lost cause, our boys in gray, I'm saying that facetiously, that defended the Southern way of living as ordained by God. If you care to read the Genesis 9 narrative, the curse of Ham, many people say that says those with dark skin are damned by God. Well, I'll be damned if I believe that, right? But nonetheless, though, I want you to know that theology is out there. The fundamental belief, though, part of the basis for the hierarchical white Christian nationalism of today is commonly called the religion of a lost cause, or its basis is there in the religion of a lost cause. And what does this religion of a lost cause look like? Let me read for you two quotes, at least one here. I lifted up Karen Cox, Dr. Cox, in her book, No Common Ground. I want to share with you an excerpt that begins my article there, the forthcoming article with the Law Review. And I quote, "Southern whites after the Civil War were overwhelmingly preoccupied with coming up with a narrative to explain their defeat. Any book about Confederate culture and its evolution following the Civil War, therefore, must begin with understanding how white Southerners came to terms with that defeat, how they justified their failure to create a separate nation, and how they outright rejected the idea that slavery was a primary cause of the Civil War. To do so requires an examination of the evolving post-war narratives about the Old South, the Confederacy, and even Reconstruction, all of which evolve around what Confederates and their descendants called the lost cause." Another scholar I want to lift up here, I mentioned Robert Jones in White Too Long. He shares this from his book, and I quote, "The central question was a theodicy dilemma. How to square the ideas of a provincial power and white Christians as God's chosen people with military defeat. Finding Confederate political ambitions foreclosed, the new battle was transposed from the political arena, where disputes were settled with military violence, to the cultural arena. This new cultural project has become widely recognized by scholars as the religion of the lost cause, a term derived from an 1866 book with the same name by a Richmond editor who called explicitly for a war of ideas to sustain Southern identity." This is an overview of this religion of a lost cause. Next slide, please. All right. Now, I mentioned Southern culture. That picture on the left is from probably one of the most famous movies in the history of America, Gone with the Wind, right? The religion of a lost cause says God intended things to be hierarchical. Therefore, laws and customs that subjugate non-whites, are consistent with divine intent. Confederate monuments, therefore, memorialize quote unquote heroes and should be in public spaces. This was a prevailing sentiment by those who were adherents, if you will, to this religion of a lost cause. Next slide, please. Now, when municipalities, the image on the right there is clearly a black and white image from the 1800s, or time frame 1800s, maybe early 1900s, but municipalities erecting monuments was government speech. The government had the right to speak. The government chose to speak with the erection of a monument. We're going to talk about what denotes the difference there is really a matter of timing, right? You can stand on the soapbox and speak all day until you pass out. That's temporary because you're going to go home. But when the government decides to erect a monument, that is the government speaking, opposed to facilitating a forum for private speech when somebody gets on their soapbox. So municipalities erecting monuments was government speech consistent with the political will of the people. My question to you, what about when the political will changes and people want to take them down? The people are again speaking. Next slide, please. Now, what changed in terms of who's speaking? Because of the Voting Rights Act. I lifted that up again. The Voting Rights Act and its inclusion from 1965 literally changed the complexion. Did you catch that? It changed the complexion of municipalities' political speech, because municipalities like New Orleans prior to 1965 could have been 50-50, could have been 45, whatever the demographics were. But if they were not included in the voting rolls, if they were not part of juries, if they were not fundamental functioning citizens in society, they really did not have the right to speak in terms of government speech, right? But this all changed with the Voting Rights Act and with passage of the Voting Rights Act. I lift up the other images here now in terms of who's speaking. Once upon a time, municipalities spoke to erect monuments. Now, when you look at Tennessee, when you look at Montgomery, Alabama, you look at other places, municipalities are speaking Richmond. Municipalities are speaking again, saying we want to take those monuments down. This really kicked off, a highlight there, Mother Emanuel AME Church and Emanuel 9, who were tragically killed in June of 2015, this renewed emphasis on who's speaking. Next slide, please. Now, there's a tension then created by 8 southern states that have statutes. They present compelled speech at best, or they negate political speech. Compelled speech, I say, because they are making the municipal government speak in a way that's inconsistent with their political will by maintaining or protecting these Confederate monuments that they want to take down, or they are negating the political speech that the governmental actors are attempting to make. So in recognizing changing municipal demographics and the changing political voice of municipalities, 8 southern states, Alabama, where I am right now, Georgia, South Carolina, North Carolina, my new home, Mississippi, Tennessee, Kentucky, and where you are in VA, enacted heritage protection laws. Again, what I call statutes that prevent municipalities from removing Confederate monuments or engaging in what the Supreme Court calls government speech. My question, if they spoke to erect the monuments, that's political speech, why can't they now speak to remove the monuments? That too must be government speech. That means there's compelled speech at best or a negation of political speech, which I argue is in violation of Supreme Court law. And we'll talk about those 2 Supreme Court cases momentarily. Next slide, please. Now, this picture on your left here is from Atlanta. Atlanta is a municipality. The government represents the elected officials in Atlanta represent the constituency that elected them. And they put up a statue in Atlanta of, guess who? Martin Luther King Jr., right? So the government speech doctrine says governments have the right to speak as political actors. And that right is not subject to First Amendment challenge. First Amendment challenge comes into play when the government puts a check on private speech, right? But in this case, this is the government speaking. So what is the check? The check is the political process of elections. Meaning, if the people in Atlanta don't feel like the mayor or the city council erecting a statue of Martin Luther King Jr. represented their best interest, the check is at the ballot box when they're on the ballot the next time up, right? Okay, government speech allows cities to promote certain viewpoints without implicating the First Amendment. And in 2 recent Supreme Court cases provide examples of agency action that qualifies as government speech and also factors court ways to determine what constitutes government speech. The primary factor we're going to talk about is one of timing, right? If something is permanent or if something is temporary. Next slide, please. Here we are, as they say on ESPN. Let's go to the videotape. So the 2009 case, Pleasant Grove, Utah v. Sumner. Excuse me. Pleasant Grove is a case where Justice Alito wrote for a unanimous court, ruling that the city of Pleasant Grove's decision to not allow a monument of the 7 aphorisms of Sumner of similar shape and size to a 10 Commandments monument, you see the 10 Commandments there, that's in this public park, was not subject to the free speech clause, was not subject to challenge under the free speech clause, which governs government regulation of private speech. In other words, government has the right to speak through its markers and its monuments. What I'm saying is that if Atlanta spoke through its recent erection of an MLK monument, if DC spoke through its Black Lives Matter street, these are cases of political speech. Just to give you a little bit more background about the Pleasant Grove case there, it's a wonderful read in case you decide to take a look at it. Pleasant Grove is a park, it's a municipality, but this is a public park in Utah where there are about 15 different monuments. The Supreme Court and Justice Alito is clear. He uses the soapbox analogy. I'm gonna come to the soapbox in a moment. If I get together with you guys, I've got a limited amount of time right now. I thank you for your interest because I know I'm holding you from happy hour. But if I get together with you guys in the public park here and I stand up on my soapbox and I want to just talk and talk and talk, the government is not promoting my speech. The government is merely facilitating a place for private speech. The difference, however, when the government decides it wants to put up a monument, that by definition is not temporary. No matter how long-winded an order is, says Justice Alito, eventually that order will tire and the people will tire also. They're going to go home. But when a municipality puts up a monument, that's deemed to be political speech because of its permanence in nature, right? So the point I'm making, there were 15 monuments that were up in this park. The one we're focused on here is the 10 Commandments. The religious organization writes to the municipal government and say, hey, we want to erect a monument similar size to your 10 Commandments that promotes our religious teachings. And the municipality said no. Ultimately, the Supreme Court says this does not violate the First Amendment because the government has a right to speak and the government has a right to say no in those cases, right? So there's the difference. Next slide, please. Now, in following that case, there was also 2015 Walker v. Texas Division, Sons of Confederate Veterans. It followed Pleasant Grove, and it distinguishes when the government speaks, as in the erection of a monument, or the government merely provides a forum for private speech. The problem is that if the municipal governments could speak in yesteryear and erect Confederate monuments, why can't they speak today to remove them? That's because statutes, I believe, undermine both Pleasant Grove and Walker. So in this case, in the Walker opinion, the court followed Pleasant Grove and ruled that the Texas Department of Motor Vehicles did not violate the First Amendment by refusing to issue specialty plates, specialty license plates, because the plates are government speech. For the dissenters, however, the plates were merely a form for private speech. The point of emphasis is that under the government speech doctrine, a government has the right to express its political opinion, usually through permanent structures. And again, they give a visual emphasis to the permanent nature I'm speaking to. Next slide, please. Okay, thank you. There's me on the soapbox, right? That's a facetious me. But what does the difference between government speech and a forum for private speech look like? The picture on the left, that's me, that's you, that's whoever, literally on the soapbox, holding court, as they might say, right? No matter how long-winded, eventually he's going to get tired. No matter how good he is, eventually you all are going to go to happy hour, right? So that means this is a place we're facilitating private speech. We're only giving you access. It's a forum, opposed to when New Orleans decided, my mother used to take me to Mardi Gras parades, every Mardi Gras at Lee Circle. That was our thing. We would go to Mardi Gras at Lee Circle. And Lee Circle, did you catch that? Robert E. Lee. When the city of New Orleans opted back then to erect this in a public space, it was speaking politically. The city of New Orleans also opted to speak again politically because of a change in demographics, because of a change in who's speaking, because of an inclusive law called the Voting Rights Act. The city again spoke to remove the statue of Robert E. Lee. Fundamental legal question I'm posing then, based on those Supreme Court opinions, based on the fact that the government speech doctrine is really at issue, statutes or heritage protection laws, I believe, cause an inherent conflict between municipal actions and what they're allowed to do under the Supreme Court's governing law. Okay, next slide, please. I hope that's making sense, and we're going to wrap for questions and answers in a moment. So to talk a little bit more about this, this religion of a lost cause. As a central thesis here of the South will not rise again, I argue that the religion of a lost cause undergirds this phenomenon of white Christian nationalism. It's often called white Christian nationalism. I should say sometimes it's called white Christian nationalism. Christian nationalism is this conflation of cross and country that says America's a Christian nation. Nothing could be further from the truth. You all in law school, you certainly understand the basis for the First Amendment. It was a breakaway from the Anglican Church of England in the crown and country that we were subjected to there. This is a First Amendment that's America was not founded as a Christian nation. Let's be clear about that. But many people says it was. It's a conflation of cross and country. And when people call it white Christian nationalism, several scholars cite it as such, that is because of its hierarchical nature. It places whiteness, the social construct of race, and it places whiteness high on a pecking order above everything else. And that everything else has to deal with, if you look at the images there to the right, my last law review article, I mentioned the Howard Law Journal focused on immigration, right? So it means that those who are outside of the original intent of our whiteness here, immigrants, you're subjected to a type of bias, an inherent bias. It means the Confederacy and the Confederate States and the Confederate flag flying it around is a form of white supremacy, because that's taking us back to a day where there was greater control and dominion for the way God intended things to be, right? It also manifests in voter suppression laws. I can't make this up. This is a true to God story. Somebody just sent me, within the hour ago, somebody just sent me a link. If you go on USA Today right now, you will see me on the cover. I kid you not, right? USAtoday.com right now. I led a rally as a pastor. I led a rally this past Sunday. People, souls to the polls, we call it, people going to vote. And the article in USA Today is all about the regressive nature. Now, photo ID laws are being implemented in North Carolina and several other states. In the wake of January 6th, in the wake of all the conversation about stop the steal, we've got to stop so many people from voting. There's got to be some fraud going on. You heard the Secretary of State in Georgia, you've heard others, there's no fraud going on. Oh, there's fraud, there's fraud, there's fraud. So the laws have been targeted, as the U.S. Fourth Circuit Court of Appeals said a few years ago, with surgical precision to minimize the impact of certain demographics that usually is along the lines of race. So voter suppression laws fall under the auspices also of white Christian nationalism. And certainly, working my way back up to the top there, Confederate monuments are a reminder of who's in charge and whose country this was in the first place. So when a municipality seeks to take it down, if they spoke to put it up, they should be able to speak to take it down. That's my fundamental premise. All right, next slide, please. Now, the impact then of this white Christian nationalism, it manifests in numerous political ways. I lift up to you a wonderful book. This is a very dear friend of mine, Eric McDaniel. He's on the faculty at the University of Texas Political Science, 5 minutes, wonderful political science department. The Everyday Crusade, and he discusses how white Christian nationalism plays out in America. Again, it plays out through racism in the U.S. immigration system. That means racial discrimination as well as ethnic discrimination. Difference between the two: race is a social construct based on immutable characteristic. It's based on what you see, right? You see me as a Black man because I have certain physical characteristics, immutable characteristics that are associated with Blackness, which is the opposite of whiteness. Well, what if everybody's white? What if everybody looks the same? That means America also has a rich history of discrimination based on ethnicity. When we discriminate against our Jewish siblings that look white, when we discriminate against our siblings from Italy that look white, our siblings from Germany that look white, that's another form of discrimination that often plays out in our immigration system. So again, this deification, if you will, of really insurrectionists, the Confederate dead, as a means of carrying out, quote unquote, God's original intent for this Christian nation, is what the religion of a lost cause is all about. It embraces a regionalized religion that sees Southern culture as separate and apart from the Union and separate and apart from the United States. So next slide, please. All right, we're getting ready to pop. This has been my attempt to talk quickly and to talk in a way I hope that's been interesting to you, because again, I'm holding you from happy hour. But for the 4 minutes that we have left, or 3 minutes that we have left, I am open to any comments you have, any criticisms you have. And again, I deeply appreciate your time and sharing. All right, I see you clapping. I love it. I see you clapping. I can't hear you clapping, but I see you clapping. All good, all good.
Awesome. So we can open the floor for questions. Just raise your hand and you can send the mic.
Hello, Dr. Augustine.
Hello.
I don't know if you can see me, but I think you might be able to now. My name is Caleb, and my question for you is, if the fact that like religion motivates social behavior, it motivates political action, even if we formally try to separate church from state, it's a problem that we can't necessarily do away with just because like we have that formal separation. So I'm interested in, what are your thoughts on how do we engage with people who are in support of or who are motivated by like white Christian nationalism? Is it do we try to appeal to them in a religious sense? Do we appeal to them politically, socially? I'm just kind of curious if you have any thoughts on how do we engage with these people who are motivated by white Christian nationalism?
Yeah, thank you so much. I do have thoughts on it. As a matter of fact, the last book that I wrote, When Prophets Preach, much of it is about the prophetic leadership domain. It's about the prophet speaking truth to power and addressing those very issues. The common thread that runs through the book is white Christian nationalism and how to deal with it. In hopefully 30 to 40 seconds, I'll say there are some who are incredibly wedded to their beliefs, and they're going to hold on to their beliefs. And no matter what you say, it's not going to change their beliefs. Well, how do you eat an elephant? One bite at a time, right? So you have to be very systemic. You have to try, number one, you have to be very systemic. You have to be organized in trying to show that we all, and I underscore all, are God's children. When I quote the Great Declaration, it says we hold these truths to be self-evident that all men are created equal. When I quote it, I like to say we hold these truths to be self-evident that all people are created equal, right? Regardless of whether you're trans, regardless of your race, regardless of your ethnicity, we're all God's children. So I try from a Christocentric perspective, not to proselytize, but to show that that which we have in common is far greater than that could divide us, than that which unites us is far greater than that which divides us. And hopefully that appeals to the moral basis of some people. But again, the perfect illustration of an attempt to hold on to power. White Christian nationalism is really a political framework. It's a political construct that's about holding on to power, which is why you saw that flag, Jesus is my savior, Trump is my president. Again, those are very problematic, and some of those people are not going to have conversations, but you have to try to show the commonality we have in humanity. And thank you for the question. Did I talk too long? Did I run the clock out?
That was great. Now we have another question.
Now, to kind of follow up to that question, if you maybe have any ideas, and maybe from your non-legal standpoint, how do you convince people that I'll say don't seem to have analytical minds? There's a difference between sticking to their beliefs and preaching their beliefs and trying to convince others about their beliefs, as opposed to imposing their beliefs on others through the government, which is really the crux to the separation of church and state, and why we have the religious freedom and tolerance that we have in this country. Without it, we do become a theocracy like many other nations and dredge up an awful lot of intolerance. Is there any practical way you approach it from religion, legal, or philosophical standpoint to convince people the difference? Yes, they can preach all they want, try and convince other people, but you don't impose that through the government. That's where you cross the line.
Sure, absolutely. Wonderful question, and I thank you for it. I will say you gave me several options: religiously, politically, philosophically. From a philosophical perspective, I really, when I stand toe to toe against people that I incredibly disagree with, I always say, we may disagree, but there's never a reason for us to act disagreeable, right? So I'm never going to be rude to somebody. I'm never going to Michelle Obama used to say, when they go low, we go high, right? I'm always going to try to go high because I think that shows who I am. That shows when my projected self lines up with my actual self. I try to go high in those kind of situations. And hopefully by seeing the nature of my wholeness, if you will, that I'm consistent with who I say I am, it will help change hearts and minds. But some people are so deeply wedded to what they believe and they want to proselytize you, and you're going to hell because you don't believe what I believe. And folks like that, you just have to disagree without being disagreeable. That's my humble opinion, at least. Is it happy hour time?
One more question, maybe,
All
or
right.
maybe more. We have time. But...
I'm trying to help you all, man. I'm trying to help you all.
Hi, Dr. Augustine. This isn't a question. I just have a comment, if that's okay.
Absolutely.
Hi, well, my name is Zoe Jackson. I've been in your email inbox.
Oh, hey, yes. Thank you. You've been so nice. It's a pleasure to see you.
Thank you so much. Thank you. I just wanted to comment that I'm so thankful that you are here. And this has been such a fantastic presentation. Even on Zoom, you have such an incredible presence, and none of us are too anxious about the fact that we have to go to happy hour next. So thank you so much.
She said we have to go. She said we have to go to happy hour.
Excellent, but I'll hand it over to Kim if you want to wrap up.
Perfect.
Thank you. It has been a pleasure to work with you. I deeply appreciate you.
Well, thank you so much. And if everyone could join me in giving one last thank you to Dr. Augustine.
You all have been awesome. Thank you for the honor of sharing with you.
Thank you again, Dr. Augustine. I will just wrap us up. I know it's been a long day in this room. Thank you all so much again for coming today. My heart is just like brimming. I hope that you all had a wonderful experience and that you learned something new and that you will take it with you when you go. I will be around if you have any questions, and I hope to see you at the reception at the Answer. The address is in your programs. Thank you so much.